If you need anything while you're in the jury room, please let one of the deputies know, and we can accommodate you. Don't forget to wear those stickers when you're out and about the courthouse. I see some of y'all have already found those, but especially when you leave the building, have those on. Anyone associated with this case, with the exception of the courtroom staff, is prohibited from having any contact with you whatsoever during this trial. I believe some of you already have also found the notepads and the pens that we provide you. A few notes about notes. You can take notes, but you're not required to. Please do not let your note-taking distract you from paying full attention to the evidence and the witnesses. You may not share or discuss your notes with anyone until you start deliberating at the end of the case. Notes are not evidence, they are only memory aids. They are not more important than your own impression or memory of what the evidence may have been. While you may consider another juror's notes to refresh your memory, you should rely on your own memory of the proceedings. You must leave your notes in the jury room except when you are here in the courtroom. At the end of this case, they are going to be destroyed. And this is very important. You will not get a transcript of any witness's testimony. Often we have that request once the case is over. Because you can see sometimes we have a different court reporter every single day, and transcripts can take weeks and months to prepare. So that's not something we're going to be able to give to you immediately like that. So when you're trying to remember the testimony, you're going to hear it from the stand just on that one occasion, and remember it in the way that works best for you. Before we start, I want to cover some basic principles of civil law and everyone's role and how this trial proceeds. The case you're about to hear and we've talked about is Nicole Wade, Jonathan Grunberg, and Taylor Wilson, and Wade, Grunberg, and Wilson, LLC, versus L. Linwood and L. Linwood, PC. Under our legal system, it's my duty as the trial judge to determine the law applicable to this case, and it's your duty as the jury to determine the facts of the case. It's also your duty to apply the law that I give you to those facts in reaching your verdict. You determine the facts from the evidence, which consists of two things: testimony and exhibits. Testimony are the statements that you'll hear under oath from witnesses. Exhibits are documents, photos, or other items that will be admitted into evidence. You'll have many of those exhibits with you in the jury room for use during your deliberations. What the lawyers or the parties say during this trial is not evidence. Nothing they say in their opening statements or their arguments or at any other time during this trial is evidence, unless and until a party takes the witness stand and is under oath and subject to cross-examination. Nor is anything I might do or say evidence in this case. I have no leanings in this case whatsoever. My interest is to see that it is tried fairly for both parties and to see that it is tried according to the laws of the state of Georgia and according to the constitutions of this state and of the United States. You must consider this case as a lawsuit between persons of equal worth and equal standing in the community, and between persons holding the same or similar positions in life. All persons stand equal before the law, and all persons are to be dealt with as equals in a court of justice. A business entity, such as the ones that are some of the parties in this case, are regarded as a person in this instance. In a civil case, the plaintiff has the burden of proving their case. The plaintiff must prove this case by what is known as a preponderance of the evidence. Proof by a preponderance of the evidence simply requires that the evidence show that something is more likely true than not true. The object of all legal investigation is the discovery of truth, and rules of evidence are designed with that one prominent purpose in mind. During the course of this trial, there will be objections made by the lawyers and rulings by me. These objections and rulings will involve the technical rules of evidence, and you should draw no inferences and make no assumptions from either the lawyer's objections or my rulings. Evidence that is not admitted because of objection or other reason is not to be considered by you. Sometimes we're going to have to deal with motions or objections without you being here in the courtroom, and so we'll excuse you to the jury room. We'll try to limit such interruptions, but we ask that you please be patient when they do happen. You, the jury, must determine the credibility or believability of the witnesses. You must determine which witnesses or witness you believe and which you will not believe, if there are any whom you do not believe. You may also consider the number of witnesses, but the preponderance of evidence does not necessarily lie with the party who has the greater number of witnesses. The procedure used in a civil trial is generally as follows. First, the attorney for each side has the opportunity to address you in what is called an opening statement. This opening statement, as I've mentioned before, is not evidence. And what the lawyers or parties say is not evidence, but rather a preview or outline of what they expect the evidence to be. Since the plaintiff has the burden of proof, they go first. Following opening statements, the plaintiff presents evidence. That is, the plaintiff can call witnesses and introduce any exhibits. Then the defendant has the right to cross-examine those witnesses. When the plaintiff has presented all of his or her evidence, the plaintiff will rest their case. The defendant then has the opportunity to present a case, which means that the defendant can call witnesses and introduce exhibits, and the plaintiff has the right to cross-examine those witnesses. After all of the evidence has been presented, the attorneys have the opportunity to make what is called a closing argument. And that's when the attorneys will point out to you certain parts of the evidence they think are favorable and try to persuade you to decide the case in their favor. Both sides have the opportunity to make this closing argument. After the closing arguments, that's where I charge you on the law that applies to this case, and then I ask you to retire to the jury room to deliberate and reach your verdict. Please remember during the course of this trial to listen carefully to all of the evidence. Do not jump to conclusions before all of the evidence is presented. And please remember that during the course of this trial, it would be improper for you to discuss this case with anyone or to allow anyone to discuss the case with you or in your presence or hearing. You cannot discuss the case with each other in the jury room or elsewhere before actual deliberations begin, and only then when all of you are present. Again, to maintain the integrity of the jury system, I have to remind you, you can decide this case based only on the evidence admitted during the trial and the law I explained to you. You may not conduct any research on your own about this case or any of the people or places mentioned during the trial. You may not visit any of the places mentioned or refer to any books or documents that were not admitted during the trial. Also, you may not use dictionaries or other reference materials. You may not use Google or otherwise search the internet. And you may not use any other electronic media to get information about this case. You should only use those sources, or nor should you use those sources to get any information about legal terms or about the law. Remember, you are the ones who have been qualified as fair and impartial jurors. And for that reason, no other influence should affect your decision. And that's why you don't discuss the case with anyone, including family or friends, or let others discuss the case around you. Until actual deliberations begin, that is, until you've heard all the evidence, the closing argument, and the law, you must not even discuss the case amongst yourselves. So at this time, we're ready to proceed with opening statements. And as I mentioned, the plaintiff has the burden of proof, and so they have the opportunity to go first. Mr. Beal.
Thank you, Your Honor. Thank you.
Are you okay?
Not one in dime. Not one damn dime. These are the defendant's words. The judge has charged you to judge this case on the evidence. We have a unique opportunity here today because the evidence is the defendant's own words. The defendant's handwritten, typed words and spoken words. The evidence in this case comes from the defendant himself. Fight you till we both damn die. The defendant's words. Beat you till you can't sit down for a month. Leave you broke and homeless like a damn dog begging for a piece of meat. The defendant's words. You will hear in this case the defendant say, hey, really, this is more a breach of contract case. But listen to the defendant's words and the evidence, and you will see this is something much deeper, much darker. This is a deliberate attempt by the defendant to harm the plaintiffs. And I have the privilege of representing the plaintiffs. Let's meet them. Nicole Wade, can you stand? Taylor Wilson, and Jonathan Grunberg. These are the plaintiffs. Thanks. Why did I say I have the, sorry. Why did I say I have the privilege? Well, I've been doing this a long time. And, you know, people come to me and they're very earnest and they're serious and they want me to believe them, but their story always changes a little over time. Theirs never has. Everything they've told me has turned out to be the truth.
Excuse me, Your Honor. What they told him is not evidence.
All right.
Unless he wants to waive attorney-client privilege.
That'll be sustained, Mr. Beal. Your representations of the veracity should not be considered by the jury. You can rephrase or continue.
But I have the privilege of representing these three, and you will see the overwhelming evidence in this case. All right, let's meet them. And a little bit about their history. Nicole Wade, after she graduated from University of Michigan Law School, came to work for one of Atlanta's largest firms, and she rose through the ranks and had a great career. She became a full partner at this large firm. At that firm, she met Lynn Wood, who had come over from his own practice and joined that firm. After years of working together at that firm, Lynn Wood left and took a very large case and worked on it on his own. Nicole Wade joined him as a partner, and you will see a real brief one-page partnership agreement signed by both of them. When she got there, she saw that she met for the first time Jonathan Grunberg, who had been hired by Lynn Wood in his firm as an associate, got a salary, worked, did research, etc. Later, Taylor Wilson, who graduated from the University of Georgia undergraduate and law school and joined them as an associate. So Jonathan, after he finished a clerkship with federal court, was working as an associate, and Taylor was working as an associate, and Nicole was a partner. They worked on a variety of cases, and they had a tremendous amount of success over time. The relationship changed in 2018, and we expect the evidence to show that there is an email that Mr. Wood wrote to all of them. We call it the Happy Camper Memo, and it's in 2018, and it's Exhibit 5. And you're going to hear about it over and over and over again throughout this case. In Exhibit 5, Lynn says, listen, I'm not a happy camper. I'm working hard and I'm paying these salaries and I'm doing this. I want you all three, your LLCs, to be non-equity partners of my law firm. The name of his law firm is L. Lynn Wood PC. And let's break that down. What is L. Lynn Wood PC? That's the name of his firm. PC stands for Professional Corporation. He's the sole owner, and it owns the desks and chairs and the phones and the computer. I don't know, $25,000 worth of used office equipment. That's it.
Excuse me, Your Honor.
So
That's not in evidence. What
That
Ellen
means-
Wood-
We'll pause. We haven't yet begun evidence. If he believes it will be.
I haven't seen a document that would support what you just said.
All right.
And I know it's not accurate.
It's overruled at this time. You can continue, Mr. Beal.
thank you, Your Honor. And so Lynn decided to make their LLCs non-equity partners. Let's break down all three of those. What is an LLC? Limited liability company. And did they have LLCs? Yes, they were sole member owners, just like Lynn had his PC. And you'll also hear evidence that Lynn had his PC when he was working for that large firm. It is very common to have an individual LLC or a PC. I have one. I'm partners with Ms. Brown, and she has one. A lot of times when you go to a dental practice, it'll say, Decatur Dental Group, and it'll be 3 dentists. Actually, they've all got their own little PCs or LLCs. A lot of times when you go to a surgery center, you have to have some kind of surgery. There's 2 or 3 doctors there. They're actually all individual PCs. Do they all work for that practice group? Yes. Do they all get paid through that practice group? Yes. Do they all owe a duty to that practice group? Yes. Why do they do that? Well, there's some tax reasons and some tax benefits to do it. That's why I do it. That's why Mr. Wood previously did it. That's why Ms. Brown does it. That's why Taylor, Nicole, and Jonathan all did it. In fact, you're going to hear evidence that Lynn encouraged them to do that. And he said, I don't want to be taking out payroll taxes and mailing stuff to the Georgia Department of Revenue and the Social Security Administration and all that paperwork. I'm just going to pay you a lump sum piece of whatever we recover, the profits of the firm. And you will be responsible for your pro rata share, 1/4 of the overhead expenses, the rent, the online research tools, the phone bill, etc. So in 2018, Lynn writes the Happy Camper memo, and he acknowledges they've all got PCs. They're all going to be partners. What does non-equity partner mean? Non-equity means you don't own the PC, but you work there and you share in the profits and you are a partner. You'll hear evidence upon evidence that non-equity partner is a common term in the legal profession. You work for a firm, you start out as an associate, you become a non-equity partner, maybe you ultimately become an equity partner. But at all times, you are working for the firm. Now, I know you're asking yourself, what is this man going on about? This ownership issue, why is this important? Well, it's really not, except for the fact that you're going to hear Mr. Wood create an entire defense on the theory that they never worked for me. They never worked in my firm. Why? Well, they didn't own my firm. I know. When I was a kid, and I worked for AT&T, I didn't own AT&T. I worked there. Secondly, they had their own LLCs. He had done the exact same thing. I've done it. Ms. Brown's done it. It makes no difference. Third, he says, well, they weren't really in my firm. They were just sharing space with me. And you'll hear an abundance of evidence that that is just not even close to the truth. What did he do when he promoted them to non-equity partner? Well, let's take a look. He created a website. I guarantee you I will kick this over at some point during this opening statement, so I want to apologize ahead of time. He created a website that looked like that. And then there was a little section over here where you click on it, it says the attorneys. And then you go to Taylor Wilson and it says partner. And it describes his background. I went to University of Georgia, and this is the kind of cases that I work on and why you should hire me. And then you click on Jonathan Grunberg and it says, I went to Duke Law School. And then I worked for a federal judge. And then I went to work here. And these are the kind of cases I worked on, and you should hire me. This is a common promotional thing, and you can see it, although the judge has told you not to do research on this. I want to support that. But that is what every website for a law firm looks like. And when you click on our law firm website's picture of me and Ms. Brown and our other 2 partners, you click on that and it describes us. Can I stand here in front of you and say, Ms. Brown does not work in our firm? Space sharing. Let's talk about space sharing. You're going to hear about a Georgia ethical rule, and it says a lawyer can be a member of more than one firm at the same time. But the Georgia ethical rules are designed to protect citizens who hire lawyers.
Your Honor, he's not here to interpret an opening statement of the law.
He can be referred generally to it, Mr. Beal, but to get into the nuances of it, I think that's best left for the charge at the end of the
Yes, Your Honor.
case.
But the rules require that in order to determine where a lawyer works, you have two tests.
Excuse me, Your Honor.
How do they
That's-
hold themselves out?
That's the exact same thing he was just told not to do. You tell the jury what the law is, not Mr. Bill in opening statement.
All right. I will so instruct him, members of the jury. I will be instructing on the law that applies. Mr. Beal is allowed to tell you the facts that would come out that are going to be relevant to the issues here. I think this rule is going to be at issue. So if you want to talk about the facts, they're going to come into play in determining the rule. You can refer to the rule generally and
Thank you,
take
Your
it
Honor.
case by case.
And how does one hold themselves out to the public? That determines whether you're in a firm or not. And what do we have? We have a website, which is probably the broadest type of publication you can have, because it's not only for Atlanta, it's not only for Georgia, but it's actually the whole world. You can be in Europe and get on the internet and see someone's website in Atlanta. If you were a foreign company and you needed to hire a Georgia lawyer, you could do that. This is a worldwide publication that lists them as partners. Then you'll see numerous emails from Mr. Wood to federal judges all across the country introducing these lawyers as his partner. A duty of good faith and complete candor to the court is required of every lawyer. And he is representing in writing, these are my partners. There are numerous emails with lawyers where he says, these are my partners. There are business cards where it says partner. There are publications to the State Bar Journal for the state of Georgia for all lawyers statewide. And it lists them with a picture and a description as partners of the firm. Their email address. Send an email. We will take your deposition on Thursday. Signed, Nicole Wade, partner, Ellen Wood PC, their address and phone number. The evidence, I mean, there is no evidence to the contrary. And the other interesting thing about requirements for how you determine whether somebody's in a firm is what's called client confidences. Client confidence. You're going to hear a lot about that. How do you protect client confidences? Well, let's say one of you had an issue and you came and talked to me and said, I want to hire you because I got a fight with the IRS about my taxes. I take that information. I can't tell the judge. It's a client confidence. Your taxes are only for me and the members of my firm. When I put your tax return on my server, Ms. Brown can get on it, read it, and say, yeah, I think we got a problem here. Or no, I think we got a defense. I think they paid all the taxes they're supposed to. Will Mr. Glossop look at it and say, you know, I did a little research and I compared it to some other tax returns and I think we're okay, or I think we got a problem. Yeah, that's exactly what we're going to do. That's how we represent you. But can other people see it? No. It's a client confidence. So when you look at space sharing, bunch of lawyers who maybe share spaces, they got their own computer systems. They store their data separately. They're not allowed to talk about their cases with each other, except in general terms. Like, do you know Judge Jones? Is he good to try cases in front of? Sure, they can say that. But they can't say, gee, look at this tax return. What do you think? It is a client confidence. It stays in that law firm. How did they do it in this case? One server. All cases went on it. And who got to see it? Mr. Wood, their staff people, Taylor, Nicole, and Jonathan. They all saw it together. You'll also hear an abundance of evidence that they never worked. Taylor, Jonathan, and Nicole never worked on a single case from 2016 till the day this blew up in 2020. They never worked on a single case that wasn't handled through L. Lynn Wood PC, through the law firm. All the fees on all their cases went to the firm and were divvied up. They had no private cases, no private income, nothing. They worked for L. Lynn Wood PC. So when you hear all of these crazy talk, you're going to ask yourself, why am I hearing this? You're hearing this because the defendant has created a scenario, a series of facts that he wants to rely on to avoid making a payment. That's all. Let's get into that. Okay, so we talked about up to 2018. What happened in 2019? Well, we'll go to the big board. And okay, so we've got the hires. We've got the Happy Camper memo in 2018. What happened in January? Two important things. The Sandman case came in and the Musk trial happened and Sandman settled after a year's hard work. Let's talk about Sandman first. Sandman is Nicholas Sandman. You're going to hear a lot about him. He's the young kid, high school senior, 17 years old, from Covington, Kentucky, a little town in northern Kentucky, right across the Ohio River from Cincinnati. And he goes on a senior trip to Washington, D.C. for this whole Catholic school that he goes to. And he and his buddies sneak away from the group and they get these red MAGA hats, Make America Great Again. And so they're wearing them and laughing and running around. I don't know whether it was like a prank or whether they really felt like they wanted to be Trump supporters or whatever. So this is 2019. We're coming up. You know, the election is not far off, a year away. And he's confronted by a group of African-American protesters. They're there protesting something else. Much more senior. Guys more my age. Well, actually older. And they're Native American and they're sort of dressed in Native American garb. And they, there is a confrontation on the Washington Mall. And there's a picture of Nicholas staring at this African-American guy. And if you look at all the video footage, the kids are playing. The other protesters come up and confront them. And the protesters are sort of picking a fight with them, I guess, because they had the MAGA hat on. But
Circumstances surrounding the Nicholas Sandman case happened in Washington, D.C. are not relevant to this.
Overruled. You can continue, Mr. Bill.
And so a lawsuit comes out, a defamation suit, because Nicholas is portrayed as the aggressor in this. And he was not. And it was unfair. So what the video, what various media outlets had done is they edited out all the aggressive stuff by the older Native American protester to make it look like Nicholas had done something bad, like he was the aggressor, like he was starting an argument with this guy, when in reality, that wasn't the truth. So it was a big lawsuit because it went nationwide. CNN had it all on everything, newspapers, websites. So it was huge. So when the Sandman case came in, there was countless hours of work that had to be done. They had to go through every video feed nationwide, hundreds of hours. And then they had to write demand for retractions, which is a lengthy, complex letter that cites the law and the facts and says, hey, you've defamed my client. And you gotta retract that and take that video down immediately or we're gonna sue you. But it's not just like that. It's 10 pages. It has the law. It has all the sites. It has links to all of the publications that you contend are defamatory. Hundreds and hundreds of hours of work had to be done. But the problem is they were already working on a big case. Musk. We all know Elon Musk. I don't know if you remember a long time ago when those kids were trapped in the underground cave in Asia, and Musk had a plan to try to free them by using a device that he had invented, which was some kind of underwater submarine. And a Thai scientist had come along and said, I got a better way to do it. And they were fighting. And I know this isn't going to surprise you, but Elon Musk said some terrible things about this guy in their online fight. So there was a big lawsuit that the law firm had representing this Thai scientist against Elon Musk. And as you can imagine, the richest guy in the world, he could hire some lawyers. So it was out in LA and they had teams of lawyers and it was a huge amount of work. And it was a strain on all of them. Everybody was working hard and nobody was having any fun. In October, they tried, I think it's October, you'll hear the evidence. They tried the Musk case and they were unsuccessful. Elon won. And it was a blow to everybody. But it was good to have all that work finally over with. What happened in Sandman during this time? Well, the judge in Sandman, while the Musk trial is getting ready to go out in a huge trial in LA, the judge throws the Sandman case out and says on a technicality. And then you're going to hear evidence of how Nicole Wade starts writing briefs to turn the judge around. And she does that. And Taylor and Jonathan assist, and they create this huge brief saying, Your Honor, you made a mistake. You got to reverse yourself on the dismissal. And Lynn goes to court with them, and they argue it, and the judge reverses himself and allows the case to go forward. Well, CNN didn't want any of that because they knew they had done something bad, and if they couldn't get out on a technicality, they wanted to settle. And they did. In late December, early January, they settled the case. There was also a big case against Washington Post. You all know Washington Post, the newspaper. Well, it also has a big online presence. And they published a bunch of stuff that we considered defamatory against Nicholas Sandman. So there's a big case against Washington Post. So what happens in January? After all the pressure of all of this, just says vicious attacks. Seems so vanilla. You say it like that. You will hear evidence, all the quotes I just gave you. And you'll hear dozens more. Threats to beat you. Have you arrested? There's numerous arrest threats, and it's unclear why he's threatening to have his associates, his partners arrested. But he said he fills out an FBI investigation saying they're harming me, and he invites the FBI to investigate them. It makes no sense. The FBI doesn't do it. There's never been any claim. No one touched his computer system. Nobody touched anything. They were working round the clock on these two cases, Sandman and Musk, one that paid big and one that did not. And there are numerous awful statements. Jonathan is Jewish. And you're going to hear awful statements. GD Jew bastard. Lying Jew thief. Who says that? The defendant's words. Things get bad. These are constant fights. Taylor, Jonathan, and Nicole are frozen. They don't know what the heck to do. Where do they go? What do they do? They're trying to get the money in from Sandman and get Nicholas Sandman paid. But Nicholas Sandman can't get paid because remember I told you he's 17. So he's got to get a probate court to approve the payment because he's not 18 yet. So Nicholas and his parents, acting as guardians, were the clients at that time. And Nicholas doesn't turn 18 until July. So the agreement was cut in January, but they were waiting for a hearing from the probate court so that the probate court can authorize it. Why do you have to do that? Well, it's to make sure somebody doesn't take advantage of a young person. Like say, all right, well, we collected $1,000 and my fee is $999. It would be unfair and take advantage of a kid. That's why the probate court has to bless it. But these were big settlements. And we're under confidentiality rules. It's going to be limited how much we can say, but Nicholas wasn't going to have to be doing too much work in his life when these two settlements came in. So in February 17th, you'll see the February 17th agreement. They finally entered into some kind of an agreement. Finally, Taylor takes the bull by the horns and calls Lynn after some horrible, horrible voicemails. And most of the recordings are voicemails. Lynn's calling them and leaving these horrible messages on their recording, on their cell phones. And there are 2 meetings that are recorded. And you're going to hear, oh, that's unfair. And first of all, they told Lynn they were doing it. Secondly, Georgia is a one-party state, which means if one party to a conversation knows it's being recorded, that's fine. So the recordings are completely allowed under Georgia law, and there will not be any instruction that anything untoward or improper was done. So Taylor cuts an agreement on 2/17, and he confirms it in an email. And you're going to see that email over and over again. And what does that email say? Well, it's pretty simple. And you're going to say, big successful law firm. God, it's pretty easy to wrap things up. They had a few small cases that Taylor, Jonathan, and Nicole were working on mostly. So they took 60% of one fee and 80% of another fee, and Lynn got the balance, the 40% and the 20%. And then there was some hourly work that they would take and keep working on. And then in the Sandman case, for Sandman versus CNN, they would receive half and Lynn would receive half. That's not different than the way they did all their cases. And you'll hear testimony. That's about the cut they did on almost every one since 2018, since the Happy Camper memo. And then on Washington Post, they were going to take a much smaller percentage. So as soon as they get the February 17th agreement, they think, whoo, we got this done. We can wind up and close this firm and separate because Lynn's attacking us every day. But then the attacks continue immediately. And that's when they hired me. They said, we just can't get a deal with this guy. We need help getting separated. But what does Lynn do at that time? Well, Lynn then creates what we call the smoking gun emails. And he sends them to Todd McMurtry. Who's he? Todd is the other lawyer that was working on the Sandman cases. Remember I said he's from Covington, Kentucky. Well, Todd McMurtry is a lawyer in Covington, Kentucky. He's the one that originally got the Sandman cases, and he brought in Lynn's firm to help him work on it for defamation, for the defamation cases. Todd was in this case. He is no longer in this case. He has resolved his claims. So what do the smoking gun emails to Todd say? Well, they say, listen, we need to come up with a plan. And the plan is to be able to back out of this agreement. Any agreement I make, I want you to get the Sandmans to say that no matter what agreement I make with the plaintiffs, with Taylor, Jonathan, and Nicole, they won't honor that agreement. They won't agree to let me share my fee. So Lynn comes up with a theory that he can back out of this case based on two grounds. One, they weren't members of my firm, which is just not true. And number two, somehow that the client can control this fee. You will not hear that rule. You will not hear a rule that client consent is required. I submit to you, ladies and gentlemen, that that was made up in a bad faith attempt to avoid making payment. So the plan is set, and how is he going to carry it out? Well, he doesn't want to leave his fingerprints on it, so he gets Todd to do it. So he sends the smoking gun emails on February 22nd, two of them, at 3 in the morning and 3:15 in the morning. And it says, get the Sandmans to agree that they will not let me share my fee with these people because they were not part of my firm. And they will only get paid in quantum meruit. You're going to hear that term a lot. What is quantum meruit? It is a Latin term, and it means the value, measuring the value. And so a quantum meruit is a term in law that we do where we're trying to determine how much how much their services are worth and whether they should be paid for those services. And Lynn has a theory. And he says, if we go on quantum meruit, I will demand to see all of their contemporaneous time records, like 0.2, called Mr. Beal, 0.5, worked on brief. Some firms keep those, largely defense firms that get paid by the minute. Plaintiffs' firms oftentimes do not. And you'll hear two voicemails from Lynn Wood himself saying, don't bother keeping records of your time. So he knew they didn't have time records. So his theory was, one, they're not members of the firm. Two, they can only be paid on quantum meruit, which was some crazy theory that he came up with. And number three, if we insist on contemporaneous time records, I know they don't have it, so I won't have to pay them anything. But when you look at the smoking gun emails, you'll see these phrases, regardless of any deal I make. Screw these greedy lawyers to the wall. This plan creates a big difference between $100,000 and the $840,000 I agreed to. This will deliver a knockout punch to Taylor, Jonathan, and Nicole. Game, set, match. Write to me that you are agreeing to do this. Talk to Nick. Talk to Nick's parents. Now, you're also going to hear a lot about attorney-client privilege. You are going to hear, even though Nick is not in the, Todd is not in this case, you're going to hear his words. You won't hear what he told Nick. Why? Client confidences. We can't find out what Nick was told by Todd. But what we can hear.
Just a minute, Mr. Beal. I'm sorry.
go ahead and keep going. I just need to run to the restroom.
If you want him to keep going, that's fine. All right, continue, Mr. Beal.
Okay. And, but he can say what Lynn told him, because they're just two lawyers. Lynn's not being represented and he's not representing his lawyer. And he says, Todd says, and you'll hear it, his videotape deposition. You'll hear him say, Lynn was calling me like crazy. Lynn was acting like a madman. Lynn was trying to blow this deal up. He said it was scary. You'll hear his own words. He created this plan to back out of the deal before he ever entered into it. All right, so what comes next? After he gets this deal, oh, and here's the other smoking gun on March 4th. And this is Exhibit 45. This is 48 and this is 45. So the ones you want to look at, 5, 45, and 48. We'll go over the numbers a bunch. 5, 45, and 48. And then once he gets the deal, he hires lawyers right after this. The day after he sends this one, he hires some lawyers and they send a settlement term sheet to me, because I'm representing them, on Friday the 13th at 5 p.m. saying you got to accept it by tomorrow on Saturday. And it's almost exactly the same as the February 17th agreement. I'm on vacation with my family. They're calling me. I'm driving down the road. I'm trying to get home. We agree to the term sheet, and then we start working on the settlement agreement to memorialize what's in the term sheet. And the term sheet says same thing as February 17th. You get half of the Sandman versus CNN case. You get 10% of the Washington Post. You get the majority of the small cases. You take the hourly cases, and you owe me 200 and something thousand on any rent obligations and something about computers and furniture, and I can't remember. But you'll see this agreement, Exhibit 102. You'll see it. And so the interesting thing is, while we're working on it over the weekend, on Sunday night, Todd, local counsel on Sandman from Kentucky, emails Lynn and says, hey, the hearing for Nicholas getting approved for all that money, that's been continued. So he sits on it till after the settlement agreement is signed on Tuesday, the 17th at 5 p.m. And then he has Todd write another email to make it look like he just got notice of it on the 18th. Can you slide me up a little bit more? Thanks. There you go. Perfect. So he hires this law firm to try to give him an excuse as to why he's not going to pay. But he never tells him the truth. He tells him, hey, they were space sharers. I don't know who they are. They had their own firms. We occasionally worked on cases together. And it's just not true. They worked on all their cases together. They weren't sharing space. They were listed as partners. And these lawyers, they don't. Ms. Brown is our technology partner. And she's all they had to do was type into Google and they would have gotten these pictures. I mean, we got this 4 years later. We just went on the internet and we found that his lawyers were hired to cover his tracks. He never told them that they were in the same firm. So they do some convoluted research about quantum Maryland. And they create 3 versions of a report, and you'll see them. And they are, in June, the first draft. In July, they back it back. And then there's another one in August when they see the truth of what's going on. They write a third one and say, whoa, wait a second. But the most important thing is in all their reports, they point out one thing, Georgia's duty of good faith and fair dealing. And they make a big deal out of it. They say, Lynn, Georgia's duty of good faith and fair dealing is inherent in every contract. And what does it mean? It says you cannot enter into an agreement if you think or believe or want it not to go through. Cannot. You have to act in good faith. And you must take all reasonable steps to make sure it gets done. All reasonable steps. What reasonable steps did he take? Well, Lynn will testify. I never spoke to Nick. Nick was his client. He was a 17-year-old kid. They had just filled his pockets with enough. He hadn't started college yet. He hadn't finished high school. And he's not going to have to work. And you couldn't go to him and say, son, do you care how much I pay my partners out of this fee? Does anybody think that this kid was going to say, I mean, he didn't care. His fee was set. He had to pay 40%, 20 to Todd, 20 to Lynn. He doesn't care how Todd spends his money or Lynn. The judge will instruct you that you alone are the sole judges of a witness's credibility. And you must ask yourself, how many 17-year-old high school kids, given a lifetime of money, are going to question how much some lawyer pays to his partners? Then he went on and changed the date of the probate hearing and changed it again and changed it again until Nick turned 18. And then you'll hear evidence that he had an all-day meeting with Nick at his plantation in South Carolina. And he said, come on down. And he met with Nick all day during this time period. And then you'll hear the evidence from Todd that he's calling me up, screaming, yelling, make sure you get me out of this deal. Get me out of this deal. Get me out of this deal. All based on the two wrong theories that they weren't part of the firm and that somehow quantum merit applies, not the exact terms of the settlement agreement, Exhibit 102. What does 102 say? It says an exact amount of dollars for Sandman. And it says 10% of the Sandman Washington Post. So Nick is going to assert an attorney-client privilege. And he's not going to say what Todd told him. But what is he going to say? He's going to say, I have no objection. It was a pawn in this. He didn't know what was going on. He says, I have no objection to them getting paid. I never reviewed their file. The giant mounds of paper, I never looked at it. I never asked how much they did versus Lynn, but you'll hear testimony that almost every page was created by Taylor, Jonathan, and Nicole. Every page. Even under Lynn's crazy theory of quantum merit, they would deserve more than half because they did all the work. And you will hear the voicemails from Lynn saying, I never asked for them to keep time records because that's not the way we did business. Now he's coming back and saying, yeah, I know. You got to have time records before you can get paid. So on July 24th, on Nick's 18th birthday, Lynn's lawyers write a letter saying, I refuse to pay anything unless I see contemporaneous time records, which means this settlement agreement, Exhibit 102, just didn't exist. And your clients were never part of this firm, despite the last 4 years. So then what happened to all this money? Well, you'll see right before they entered the March agreement, the March 17th agreement at Exhibit 102, Lynn took all the money out of the small cases. He got paid. He transferred it out of his business account right into his personal account. He took all the money. There wasn't any money left to pay. So then he signs the March 17th agreement saying, I'll pay you X dollars in the Carboni case and the Lindsay case. Last names of two different plaintiffs. But the money was already gone. He took it out of his business account. And he put it in his personal account. And then what does he do on the March 17th agreement? He tries to edit it. And he says, the new edits will be that you were never part of my firm. Clients never agreed to that. I never agreed to that. We said, no, we're not going to accept that. But you'll see his edits where he tried to get them to admit to it. And then, oddly enough, he says, oh, only my PC owes this obligation, not me personally. Why? Because he was going to empty all the money out of the PC and it would just be nothing but a shell. Company would be empty. So you can sue the heck out of that company, have at it. And you can get some used office furniture if you'd like. But all that big money is in my pocket individually. The judge will charge you what constitutes fraud. We've all got our own ideas. Is fraud lying to somebody to get their money? Is fraud tricking somebody to get their money?
I think he said correctly, Your Honor would charge on fraud. Now he's giving his speculation. That's not a problem.
Well, we'll see where the opening statement goes in this regard.
And we believe the judge will charge you that it is fraud to enter into an agreement that you know you can't comply with. If I agree to sell you the Chattahoochee River and take your money, you will hear from the defendant's own lawyers the duty of good faith and fair dealing. If you breach that, you're in bad faith. You have arguably committed fraud. If you enter into this deal knowing you can't comply or take steps to make sure it doesn't comply, you have committed fraud. What do we know? Just bullet points. He writes the smoking guns. Thanks. Stop. Perfect. He writes the smoking guns emails. Exhibit 45, Exhibit 48. And he says, help me do a deal. Help me get them to deny. It's in bad faith. It's based on a lie. It's based on law that you're not going to hear. Then he does the edits to the settlement agreement to try to make it so that he can back out and so that we'll get a judgment only against his empty company. And then he conceals Todd's approval of the money. And then the Washington Post settlement comes in and he never tells them. And before that, he took all the money in on the small cases and just took it out. So when he signed the February 17th agreement saying, I will pay you 50-something thousand on this case and 80% of this fee on the other case, he knew that wasn't true because the money was gone. It was out the door. It was in his personal account. And then when it's all over, there were two small cases that they took. And he said, oh, the law is I can't pay you. We paid him twice a percentage of the fee that we had to pay. And he took that money and cashed it. Why? Because he wanted the money. He knew that there was no rule preventing him from sharing the money. So he was unable to give us the large amount of money because there was some kind of rule stopping him, even though His Honor is not going to be telling you that. And at the same time, he took money from my clients, sharing the fee on smaller cases. He knew it was all made up. He never intended. So then he gets fired by his lawyers. Once they see what's going on, they fire him. They say, look,
Your Honor, that is not true, and that is not proper argument.
All right, Mr. Wood, I'll remind the jury, I'll direct them that opening statement is an expectation of the lawyers of what they think the evidence will be and not necessarily what it is. And so with that, Mr. Beal, you can continue.
thank you. You'll see evidence where they say we're terminating our representation of you. Not fired. just terminating our representation effective immediately. Then you're going to see evidence that Nicholas Sandman fired him effective immediately. Todd McMurtry, the local council guy, wrote a letter and said, this is over. I'm not doing this anymore. You're fired. And then Lynn writes back and says, I hope you will keep the truth. Keep the truth of what you've said about the Sandman case. You know what that sounds like? You know, you watch those cop shows late at night where they catch a bunch of guys and they say, hey, stick to the story, man. Stick to the story. Keep the truth. The settlement agreement also said Lynn would not disparage the plaintiffs. And disparage just means anything, and I expect the judge will charge you that it means that which is designed to hold in a lower light. And it simply is amazing, the kind of disparaging posts. The first thing he does is Nicole represented the estate of Martin Luther King, and she was working with Dexter King. So the first thing he did was write a letter to Dexter King saying, Nicole's a criminal. Don't work with her. I hate her. Is that a violation of a non-disparagement agreement? I sure think so. Is that a deliberate attempt to ruin somebody's career with somebody who's influential and important and innocent? Dexter King didn't deserve all this. He was getting good representation from Nicole. And the kinds of comments, he holds them up to public ridicule and he invites violent outbursts against them. He shows pictures of Jonathan's children that he found on an unprotected Facebook page. He finds pictures of them and saying that they are.
Objection, Your Honor. May I approach the bench?
You may. Mr. Beal.
This is the exact same thing. This is the exact same thing he put into evidence in the defamation case. Your Honor's been clear, we're not going to redo that. That's what he's doing. That would mean I'd have to go in and totally figure out how to defend myself against the defamation case again, that he's already tried and it's on appeal.
You don't have me at any time.
Yeah, those statements are coming from not
I think someone drill down to make time, highlight clearer.
Are you able to pick that up? Okay.
Yes.
All right, Mr. Beal, you can proceed.
Thank you very much, Your Honor.
And just to note, you've got about 6 minutes remaining.
Thank you. So in all of this, you're going to hear from Lynn's lawyers. Why are they not protected by the attorney-client privilege? Well, Lynn waived it in order to get those reports in, but you're going to look at those reports and you just say, they never justified what he said. And in fact, they talk about the duty of good faith and fair dealing and warned him not to breach it. So we talked about the disparaging posts, and I'm not going to go into all the details right now, but you'll hear awful things that Lynn did intentionally to hold the plaintiffs up to public ridicule. It is a clear breach. Why? Why would he do all this? Was he upset that he couldn't control them anymore? Was he upset that they had left him and he didn't have a practice left without them? I don't know. Maybe you'll figure it out throughout this trial. So Lynn's defenses come down to they were not associated in the firm. I anticipate the judge will charge you. The only legal standard is previously associated in a firm. You'll hear that a lot. Previously associated in a firm. Were they previously associated in a firm? They were members of that firm. They were employees of that firm. They were partners in that firm. They did all of their work through that firm. You will also hear Lynn say Judge me by the body of my work. Judge me. You'll hear a lot of Christianity. You'll hear a lot of other things. I would submit to you, ladies and gentlemen, judge the defendant by his own words, by the evidence that you see, and there will be a mountain of it, and it all points in one direction. Usually in an opening statement, a lawyer says, now this other stuff's going to come out, and I don't want you to think about it. I'm not saying that because I don't have anything else. This is very unusual in a fraud case to have actual evidence of the plan. It's like that old joke, you know, the cops come in and the guy says, well, I don't know where my wife is. And they see his to-do list and it's kill wife, bury in backyard, lie to police. You know, we're going to see direct evidence from the defendant's own words in this case. The body of work also involves termination by Nick, termination by his lawyer, destruction of this firm. So the body of the work includes the last year as well. And that is why you are here, not the other issues. Thank you, ladies and gentlemen. This has been a long opening. It's a complex opening, but it's a very simple case. It comes down to a plan not to follow an agreement that he made, a plan to hurt, a plan to defraud. It is an awful responsibility that we have thrust upon you to sit in judgment on another. I know you don't want to do it. No one does. And my clients, stand up, you guys, one last time. These are the people who need justice. These are the people who need your help. These are the people who need your concentration. We thank you sincerely. And people say thank you for your service and they don't really mean it. You're the link to justice. Not one thin dime for justice. Thank you.
All right. Does anyone from the jury need a break before we proceed with defense closing or openings rather? All right. Let's y'all let us know when you're all ready by the light and we'll go from there.
You're on expect maybe 10 minutes.
5 to 10.
You're younger. You can go quicker.
We're on their time now. All right. We'll be in recess until that light comes on. Unless there's anything else to take up, we'll be off the record.
What I'm missing. Thank you. If you need me. That's why I had the spreadsheet.
Yeah, it was pretty good. I love that clock up there.
Very cool. Yeah.
You guys lost.
Yeah, thank you very much.
Yeah, but no,
I'm happy with what I-
yeah, so yes.
Yeah, it's, so you go. It's for parents.
Yeah, yeah.
Like referencing.
And the 220 women in the back car.
So, fair.
I think a lot of them got over.
representation.
Yes.
Yeah, I mean.
Yeah.
You can, I don't, whatever he says or not, I think I understand the facts.
Yeah.
Thank you so much, Andy.
Yeah, of course, yeah.
Dismissed.
Which? Are y'all?
Hey, how's it going? Where everybody at?
Where is everyone? Drink a fat.
Hey, Sean.
Hey, hon, how are you? Good to see you.
Rest of y'all.
I work here too.
I thought it is.
Sean's the only one worth saying.
Yeah, that's fine. Hey, no shit.
Where she squeezed the shit out?
Yeah, I love that.
It's just good. So, it's in the safe.
Sleep, it's safe.
What's up, Cole? You blood in it?
No, I wasn't.
You're not, you're.
I work in this building, so I'm not sitting here because we had a fight here yesterday. Who's there?
What's going on?
Well, I could be ashy.
I don't know.
We don't work. Where's, no, Scott?
He went to the bathroom. Shut up.
I've been screwing up these clocks all week. I don't know. This is not a good week for me clockwise. No. It looks like. Was I wiping my nose?
No, I needed it.
Oh, okay.
Yeah.
We might, I don't know why we don't have another box. You might want to grab another just for the witness
That's-
stand or
Okay.
wherever.
Yeah, I'll just have them on our way.
Yeah.
Anything else?
You know what? Let me go get some water.
And also, there's no way that people.
Thank you.
Yes. They tried to say.
This
that-
is keep the car. This is our court report.
Yeah, they tried to say that Bert never told Bert them all that stuff, but there's no way Bert and them didn't know that.
I told him.
I know that, because they're the ones who prepared your responses and all that. So that's unfair. They're mischaracterizing that testimony.
I just had to.
And also put them with Murphy's August 23rd. Ask them for that for later.
What is this?
That's the, yeah.
Heard him, hit him, boy.
Hit them up August 20th. Well, that's the one where he said after.
Yeah, I'm just gonna tell him, he wrote him July the 24th and
Bought,
again,
for sure.
August 28th.
Yeah, that's what he said.
Counsel, if we could have you take down the demonstrative.
I think it's.
Yes.
Shoulder.
Thank you for reminding us.
And whatever else you know.
You find this ruling on motion on limine.
I did, but I don't have it in hard copy.
Just show me.
It's right here.
Oh, absolutely. What kind you want?
Part about 1.5.
No cream, no sugar? Okay. Yeah, we get you some.
Just black coffee. It's okay. Thank y'all.
Nespresso or Keurig?
Oh, no.
Okay. All right.
Espresso,
Yeah, I think we have one of those little machines. Yeah.
living it up. Who took a picture of
What's that?
that yonder that you have? It's called Yonder. Keep going.
Well, that's the sheriff's office.
Just thought, okay, that's pretty neat.
They only do that if they have security concerns. But, we had an incident yesterday, so I think. But they do that. They do that at concerts now and then too.
What's that?
I've been to concerts before where they make you put your cell phone in.
I have been San Pedro.
Yeah, other comedians will do it.
You speak of that.
They can't be filming it, putting it online, stealing their material.
Right. No.
Zoom.
But these, I mean, I messed them up a little bit this morning, but the clocks or something. I think that we need to get more. We need to get more Superior Court folks using them.
Oh, let them know that they can go up to the second. I don't know if I like that. But we do it in the 15s or.
Yeah. Well,
That's pretty.
I think we'd go 15 over if we didn't.
That could be true, yes.
Run a brief,
Hold on. All right, let's go back on the record. Mr. Beal, you have an issue?
we wanted to invoke the rule against sequestration. And sorry, we hadn't done it earlier. Somehow, we got to address the Zoom issue that if someone's going to be a witness, in this case, they should not be participating or viewing the Zoom. And we would say that that includes, representatives. In other words, having a stalking force sit there and get all the information and then pass it along.
Yeah. All right. Well, I think we've got a Rule 615 sequestration request. So to that extent, that'll be applied here. So any witness who the parties believe may come to testify in this case is instructed not to be sitting in the gallery until they're formally excused. And the parties I'm asking the parties to help me enforce that rule, since I don't know necessarily who steps in. As to discussion of testimony as part of that rule, while the attorneys can talk with the witnesses about what their testimony that should not be shared with them, the previous testimony that's already occurred. In terms of Zoom, I'd also ask the parties to instruct any potential witnesses not to be watching any live stream or previous recordings, since that would be the equivalent of them being in the courtroom. If there's any suspicion that's happened, you can take it up on during examination, or if there's been a violation, we'll go from there. Anything else we need to address on that front?
Thank you, Your Honor.
Your Honor, may I ask for clarification on that? My law
Sure.
firm asked me to be here. My understanding, my law firm is involved somehow.
We've just got to get you identified for the record since now you're in it.
Roberts, law firm Olson and Berg.
Okay.
Does that rule of sequestration apply?
Well, I think that there are some Alston Bird lawyers on the witness list. So to the extent you're taking notes, those really shouldn't be shared with them at all, because then you'd be telling them about the testimony or the evidence that's already come out. So until they're excused, until they're called or the parties release them, yeah, that isn't something that you should be sharing with them at all. All right. Thank you for asking for the clarification.
And Your Honor, just a brief question. Are you planning on calling Olstenberg lawyers?
Yes, Your Honor. I also don't have any objection to this gentleman sitting in here. Joey and Chris are not going to somehow take advantage of whatever he tells them. They know what their testimony is.
He has every right to be here and write whatever he wants, but I know, but the question he had is whether he can then convey those notes to a witness.
Not, would you intend to convey to Joey and Chris?
I'm not speaking to Joey and Chris, I'm speaking to a partner that I work with.
So that,
There's no issue whatsoever.
think he can have at it, don't you?
Absolutely.
Absolutely, not, I mean, he's talking to, the risk manager, and Joey and Chris report to the risk manager on this case, and he defended their depositions in this case. So we have a little bit of a daisy chain, but we're getting back to the same thing. We might as well just have Joey and Chris come on down and sit through this. It would be easier for them. But I mean, if he discusses it with the risk management partner who's in charge of this very matter and who defended the depositions, the temptation to discuss it would be overwhelming. I mean,
I mean, it's there, but you know, I don't, there's only so many levels of telephone that I can control. And I think that if he's gonna be here under oath, you're gonna be able to cross him on
Sure.
this. And you can then draw whatever inferences or attention you want to. You could even ask me to strike their testimony if you think it's been flagrant. But I think we're conveying to the people involved, and we're talking about barred lawyers here, who are supposed to know they're not supposed to be tuning into a trial that they're going to be a witness at. So I've instructed him. I think the witnesses and the parties are supposed to be instructing their witnesses on the expectations. So I think, Mr. Wood, that obligation would fall on you as well.
Frustration. Will you commit that you have no intentions of having any information about what you're hearing conveyed to Joey or to Chris?
If you'd like to. Yeah, I don't think you're under any obligation to, but
Partner who does not, who Joey and Chris do not report to, another partner has to be here on behalf of the firm.
and again, I think the ultimate party that's
Tell us your name so we'll have on the record.
he already had it. Ultimately, though, the only person I can really hold accountable for violating the rule is either going to be the witness when they're here or the party who's trying to do their testimony. So that's also going to fall on you, Mr. Wood, to let them know that that's the expectation.
I don't understand why the threat.
I'm not making a threat. I'm just trying to
Well, you say it's gonna be
explain
my responsibility if they violate the rule.
to make sure they knew about the rule.
Joey Burby and Chris Marquardt.
Then we don't have an issue.
Rule of sequestration.
Then we don't have an issue, which I'm sure we
I
won't.
don't think we would. I don't challenge their honesty.
So I think we're on the same page then. So with that, the jury's indicated they're ready. I'd like to bring them back. Is there anything else, Mr. Beal?
I was gonna, request that, he not be present in the courtroom, but. it sounds
I
like
can't do that. I can't do that. I don't think that's within my power. All right. And so if there's nothing else, then do we have our deputy?
Shut down, Tanda.
Yeah, so.
All right, thanks. All right.
You have a hard time with Jonathan's statement.
All right, Joey.
Thank you. Please be seated, everyone. Vince may proceed.
Chief Your Honor,
You may.
thank you very much. Well, it's still morning, so good morning. You've already figured out I'm Lynn Wood. I'm the bad guy, according to Mr. Bill. John Exum is co-counsel for me. I represent myself, L. Lynn Wood. And John represents L. Lynn Wood and the PC, but I'm handling the problem for myself. The evidence will show you that I practice law in the state of Georgia for over 45 years. And as part of my practice here, I was involved in lawsuits in 27 states around this country. Some of the most high-profile matters during the time of my career I was involved in. I built a reputation. I took the talents that God gave me and I tried to use them properly to represent my client. And the key that I always had was that I wanted to be a zealous advocate for truth and justice. This is not about justice for Mr. Bill's clients alone. This is about justice for everyone in this courtroom. Me, the lawyers. This is about our system of justice. Now I'll have the opportunity to take the stand and I will be happy to answer any questions Mr. Bill asks me after I try to explain some of the things that happened this law. Why? Mr. Bill said, why? Why would we do this? Why would I do it? You do not leave your common sense behind when you serve on a jury. In fact, you use it. God gave you common sense. Use it. If something doesn't make sense, it doesn't make sense. I was financially successful over the course of my career, more so in the latter 3 or 4 years than the first 40-some years. I started with nothing. I'm not asking for your sympathy. I'm telling you about the truth of who I am, because I have been misrepresented for 5 years by this lawyer and his clients, and they know better. I was born in 1952 in Raleigh, North Carolina. At age 16 in Macon, Georgia, I came home and found my mother beaten to death by my
Objection,
father.
Your Honor.
Mr. Wood, if you'll phrase it as what you expect the evidence to show.
This is what I expect the evidence to show, because I'm going to present it. The evidence will show that I came home at 16.
Objection, Your Honor.
All right, we can approach. I'll pause. Mr. Wood.
Yes, I could mention that in my family, my background. Of course I can.
Okay, can you be more specific? I mean, there were several motions in limine.
Shoot, it wasn't murder.
Okay.
It was voluntary manslaughter. I'm not going to play by play. If y'all let me go through it, we did it. It's one time. That's what
No, I paused the clock. But Mr. Beal, if you've got a specific, this was specifically covered by motion limine. I don't have it in front of me. I gotta. Huh? Yeah.
Your Honor, you.
Yeah, it's just for relevance. Okay. So if you just want to establish some relevance
Just
here. All right.
The background of working through the law school, whatever.
Okay. All right, but that's not extended. All right.
Thank you, Your Honor.
All right. May resume.
So like I was telling you, the evidence showed. That's just a fact. I lied. Well, in your person. And I was 16 and didn't have a dime in the house. The evidence showed I didn't have a house to live in. We're going to have another sheriff back. So using the talent that God gave me, I managed to finish my senior year in high school. I then managed to work and borrow money to get through college. I graduated from Mercer University in 1974. And because I had decided at age 14 that I wanted to be a lawyer, I went to law school at Mercer University. I graduated in 1977. I then practiced law in Macon for just around 3 years for the firm there. I left Macon and came to Atlanta and worked for the law firm of Freeman Hawkins, the law firm in Macon in Jonesport, Illinois. I came to work in Atlanta with the law firm of Freeman Hawkins, the trial firm. Loved Paul Hawkins, even recommended. I stayed there 3 years and I carried a lot of briefcases, calls, and trials. I'd watch him and he was good. He had some heart attack problems, so he wasn't what he used to. Sorry. And I kept thinking, yeah, all's good, but I think I could do better. And so I left Freeman Hawkins in 1983, and I started my own law firm, Wood and Moore, another lawyer that ran at Freeman Hawkins. Later it became Wood, Moore and Grant, another lawyer joined us that had been at Freeman Hawkins. And so I practiced law under the name of Wood, and the law partnership, Wood, Moore and Grant. Jack Moore decided he didn't want to be a trial lawyer and he left, so it was Wood and Grant. Then in 1996, I was hired by Richard Jewell in connection with the false allegations made against him, accusing him of being the bomber of Centennial Park, which he was not. The world was against Richard at the time. I stood up. And he was, within a matter of months, exonerated. In September of 1997, my law partner at the time, Wayne Grant, he and I separated. And he had his own firm, Wayne Grant PC, and I had an established L. Wood PC, September of 1997. And I have maintained L. Wood PC from that date until the present time. Now, I wasn't very good at being told what to do, so I had problems with lawyers that were above me. I had an interesting mind. Sometimes they wanted me to do things, and I don't want to do it that way. But I liked having my own firm. I liked the independence. But I got tired of running a law firm because it's a business. And in 2016, I was asked to join the law firm of Powell Goldstein in Atlanta as a non-equity partner. I didn't want to be a partner, full equity partner. I didn't want to have any ownership in the firm. I wanted to see how I liked being in a bigger firm. I was a non-equity partner with a salary. 2 years in, they made me an equity partner, and I said, okay. Then things didn't go so well for the firm. And they sold themselves to a firm called Brian Cave. Powell Goldstein was about a 200-person firm when I came. It was going down in number. They then sold that firm to Brian Cave, which was an international law firm of over 1,200 people. And I said, well, I don't want to work here, but I'll stick it out. Because it had been a high-profile reported article when I joined Powell Goldstein. And I didn't want to black eye the deal they had with Brian Cave. So I said, I'll try to stick it out for them. And I did for about 2 years. And I didn't like it. told me what I could and couldn't do and what practice areas I could have, and I thought, well, I'm too old for somebody to be telling me this. And I didn't care about the money they were paying. God had given me enough at that time, at least at that time. I don't have it now. But I had financial independence. So I was asked by a lawyer, Brian Cave, to look at taking a case against DaVita, second largest owner and operator of dialysis clinics in the country. He wanted Brian Cave to take it under the idea that I would be lead counsel. Brian Cave refused to take it. There was my opportunity. I told the partner, Rick Miller, I said, I'm going to have lunch with Marlon Wilbanks. He said, you should. Marlon was the lawyer that referred the case. So I called Marlon, and we had lunch the next day, and I told him, I said, my PC is still intact. I will leave Brian Cave if you let me handle that case. He signed the contract. I spent years working on it. These lawyers were not involved. Jonathan came in toward the end. Even though he had not worked on it, I gave him $200,000 bonus. Pay off his student loan. And it was successful. I risked a lot of money. Because sometimes you have to advance fee expenses for clients. The law allows you to do it, as long as they agree to repay you. But if they don't repay you, clients don't have hundreds of thousands of dollars, so if you don't get repaid, you move on to the juniors. So I settled the DaVita case in 2015. Let me go back. When I left Brian Cave, and when I would take the DaVita case, I formed a law firm, a partnership with lawyers Catherine Vincent Hernacki and Stacy Godfrey Evans. They had worked with me. Catherine had worked with me at Elon with PC. I got her to come over to Powell Goldstein. She didn't like it. She left. Stacy had worked with me at Powell Goldstein and Brian Cave. So I formed a partnership with them. I had 60% interest. They had 20. That was a true partnership. And the way it was set up, it was majority rules, and so it was 2-to-1 issues that I didn't agree with. And all of a sudden I found myself caught back up in a situation where I'm not able to do what I feel like needs to be done because they voted 2-to-1 against me. And that partnership was dissolved. Prior to the dissolution of that partnership, and I was a partner in the name of Elon with PC as part of that partnership. Catherine Hernacki and Stacy Evans recommended they felt like they needed an associate. They interviewed and hired, with my approval after I met him, Jonathan Grunberg. Jonathan was a 10-year clerk for a federal judge. Jonathan Grunberg had 0 experience handling civil trials when he joined the firm. He was a judge's clerk. He was a good researcher, good brief writer. He was not a trial. But that's what they needed, so we hired. When that firm disbanded, I think we were paying Jonathan $75,000 a year. It may have been up to $90,000 at that time. When that law firm disbanded, I looked over at Catherine Hernacki. I said, "Do you want to take Jonathan?" No. "Stacy, do you want to take Jonathan?" No. So here I was with a young man who, if I'd said no, he didn't have a job. And I wasn't going to let that happen. So I hired him at full salary. But I couldn't afford at the time, but I took him on, so he had the job. You were at Boy Dyer yesterday. And if I heard it once, I heard it 1,000 times. Abusive boss. You hear the evidence in this case. I do not believe you can find that. When I had the boss one time, but from the beginning to the end of these lawyers' affiliation with me, I was good as gold to every one of them. I love them. I still do. I thought Taylor Wilson was like my son. He even said it. I can't even begin to count the number of times that I took him out to play golf. Gave the afternoon off to go play golf with him. Paid for the golf. The times that his wife wanted to go to the University of Georgia SEC championship game or go to the national championship game. And she'd ask me, Lynn, please let us go. Give us a ticket. I did it. I didn't have to. But I was more than happy to share some of what God had given me with other people. Nicole Wade was, as Mr. Bill said, an equity partner in Brian Cave at one point in time. She was at Powell Goldstein, and I joined there, and they actually got me to take on a case that she was working on for a senior partner who the SunTrust Bank was getting ready to fire. And they hired me to be a lead counsel in a case brought by some Coca-Cola heirs against SunTrust Bank. By the way, it was in the Fulton Daily Report that I was quoted as saying to the plaintiffs in that case, not one that. That's a word I've used before, phrase that I use. Means I'm gonna fight you. If you're wrong, I'm gonna fight you. I'm gonna concede my principles. Even if it's to my preference. Nicole was shocked. She couldn't believe that she was going to be stuck working with some plaintiff's lawyer who wouldn't know what he was doing. They said, Nicole, help him. And she did. Nicole came in and she did great work. And Nicole will tell you, at least up until the time of the litigation brought against me, Nicole Wade will tell you that I was the best trial lawyer she had ever seen. What happened? Mr. Bill puts up a timeline and he focuses captures a part of time. He doesn't tell you the truth of the background. He doesn't even tell you the truth of what happened after I entered into an agreement with Wade, Grunberg, and Wilson on March the 17th of 2020. He doesn't tell you about the number of cases that I sent to them after this agreement. I think it's over 4. He doesn't tell you that when the probate court postponed a hearing to approve the Sandman settlement, which everyone expected would have been done within days of March the 17th. He doesn't tell you that I offered these lawyers because I knew the payment that they were going to receive would be delayed. Didn't know how long because of COVID. CNN and Todd McMurtry, they negotiated a deal where they would pay Nicholas when he turned 18 on July the 24th. I had nothing to do with that deal. So I knew there was going to be a gaps of delay. I offered I offered these three lawyers an unsecured line of credit for $500,000. Because I knew they were starting up their new firm and I wanted to help them. They told me they didn't need it. I said, okay. Now, do you think I would have offered them $500,000 unsecured line of credit if I intended not to them to get the money from Sandman to pay me back? I don't claim to be the brightest crayon in the box, but I'm not a fool. I always intended for them to get this money. We had problems starting in the late fall of 2019 as we prepared for the Elon Musk trial. Problems that to this day I don't fully understand. I think I know. All of a sudden, Jonathan and Taylor started treating me with no respect. They would come into my law office and yell at me. They would come into my law office and interrupt me and were rude. They would come into my law office on the Elon Musk case and tell me I didn't know what I was doing. They knew what needed to be done. They never tried a case in their life at that point in time. And I didn't like it. I didn't like being treated that way. To one who much has been given, much is expected. I had earned their respect. And for some reason, they stopped doing it. We finally had a meeting at what I had at a lake house up at Lake Oconee. Finally pulled them all together for a weekend. And I said, look, this is your time. Tell me what you think ought to be done. I'll listen to you. But this has got to end. I've got a trial to get ready for. So I heard them out. I said, okay, here's what's going to be done. I'm the general, I'm the boss, I'm the almighty Lynn, which I was in that Ellenwood PC. I was the only one in. So I said, either get on board or don't go to California for the Elon Musk trial. I said, I can't be in the middle of a trial, which is a war, and tell my troops to move left and have you start arguing with me. No, we're going to go right. Either get on board and follow my leadership or don't go. We'll go. I wanted them to have the experience of trying a high-profile case in front of a jury in a foreign jurisdiction. That's tough. LA's not Linwood friendly, probably Elon Musk friendly. We went to the enemy's camp. I paid for them to stay in wonderful hotels. I bought all their food. I paid for their plane tickets to give them the experience of handling a significant lawsuit, a national lawsuit. Where were you going to get that experience? What other lawyer ever offered them that experience? They've got a website. It talks about we've handled defamation in high profile cases in 10 states around the country. That's not true. They were involved in those cases working with me as independent contractors. I gave them the experience. I gave them the opportunity. In return for that, I started getting treated like I was first year out of law school. We got through the trial, we lost. 20-minute jury. I believe that jury was rigged. Elon Musk, the most richest man in the world. Didn't cost him much to rig a jury. So we didn't make any money. I got my son involved in that case. He's a lawyer in Texas, Matt Wood. I'm 30 years older than Matt. I hadn't talked to Matt in 5 years. But Matt went out there and we tried that case. And all of a sudden I find out, at least I suspected, I found out a year later, that Taylor Wilson and Jonathan Grunberg behind my back were conspiring with my son to try to have Dr. Phil McGraw, who I've represented off and on for 10 years, who is not a clinical psychologist, he's a TV personality, but he had been involved in striking the jury, his colleague in Musk. If they're trying to arrange for Dr. Phil McGraw to do an independent medical examination on them. What? They were interfering with my relationship with my son. And I didn't like it. I've always said you can mess, you can do whatever you want to with me, but do not mess with my children, my puppies, or Richard Jewell. Because if you do, I will come down on you with the fury of God. And that's what they did. Not only were they interfering with my relationship with my son, which carried over into my other children, who, by the way, I have a deep, loving relationship with, and I know they deeply love me, even though for some reason they're scared to call me right now. I think I know why. But then I was trying to get Richard Jewell, my client, posthumously. I was trying, from a public relations standpoint, to have President Trump present to Richard posthumously the Presidential Medal of Freedom, the highest award the president can give to a civilian who was not in the military. And these people were running around talking about my mental health. I said, stop it. Don't you think, do you not realize that they see everything you put on text? They see all of your emails. They pick up all of your phone calls if it's in the air. There's no privacy in this country. I said, you're going to hurt my efforts for Richard Jewell if this gets back to President Trump, that Jewell's lawyer is mentally ill. I said, stop. Not only were they interfering with Richard Jewell, my client, I was still representing Nicholas Sandman. And the same damage they could have done to Richard Jewell's, my efforts for Richard, they could have done to my efforts to help Nicholas in the cases. So I was not happy with it. But I didn't say, I'm done with you. The Sandman case was the only case in my entire dealings with these people where we did not have an agreement on how to split up the fee. We shared split fees. We were partners. We were partners on a case-by-case basis. We agreed case by case whether they'd be paid. They were independent contractors. They were not in my firm. They worked with my firm. They worked for me, but they had their own law firms, their own PCs. They were paid off of 1099s from Linwood PC to report their income tax. They were independent contractors. So here I am, the Salmon case settled so quickly that we never made an agreement. And it settled at a time when they were interfering with my relationship with my children, interfering with my efforts for Richard Jewell, interfering and threatening my representation of Nicholas Sandman and others. And I said, I'm not going to do it. I said, stop doing this. If you will, because if you don't, I'm not going to make a deal with you. And you'll get quantum merit. You'll get paid fairly per hour for what your fair hourly fee is. Won't get beat out of any money. But in terms of getting more from me, like I had always given them in the past, I said, stop. I'm not going to do it. And then I finally came to the realization that it wasn't worth it. I don't love money. God has blessed me with money, but I don't love it. It's the root of all evil. Well, I didn't. Money is not the root of all evil. The love of money. The love of money will have you attack your friends. The love of money will cause you to be disloyal. Some people call it greed. So I go in and I try, we had some harsh conversations. I told Taylor Wilson, I ought to take you over my knee and spank your butt like I would have done one of my son. That was after spanking another. I'll destroy you. I said words to that effect, put them in the context. They were trying to destroy me and my law practice and my family. Reap what you sow. Sow good seed, good harvest. Sow bad seed, bad harvest. So I enter in finally, and this is Mr. Bill didn't tell you this. February the 10th of 2020. Oh, matter of fact, hang on, yes. Judge, is that okay?
That's fine.
Okay.
That's fine.
My legs are weak for some reason the last few months. You want a chair? No, I was leaning, I don't want to sit there. The abusive boss. The late night emails, I historically write emails at all hours of the night. I don't expect people to answer them at night. I just get it off my chest right, and I figure I'd hear from them the next day. In the right mood. Stay up late. Sleep a little bit later, too. The abusive boss. He didn't tell you on February the 10th of 2020. I'll paraphrase it. 4 February. And candidly, I'll tell you, I felt like throwing Jonathan and Taylor out the window. The way they were treating me. But it was 21st floor, so I figured I'd not do that. And I looked over at them and I said, you damn fools. I ought to sue you for defamation for what you're saying about me. Talking about my mental health. Nicole quickly piped up and said, I've never said anything like that. I've never said anything about your mental health. I haven't said anything bad about you. I said, you know, Nicole, thank you. You're too smart to have done that. Jonathan and Taylor would not. So when the Nicholas Salmon case settled unexpectedly, did Nicole work on the briefs? Yes. Did they work on getting up the massive information? Some of it. Todd McMurtry's firm, he hired an independent media firm, and they did most of the collection of national coverage on Nick. Not they did. They did something. I don't question. They put in time for which they clearly should be fairly paid for. But they had no responsibility for the result in that case. I got up when Todd McMurtry argued the motion for rehearing before the judge who had thrown it out off the seat of my pants. I said, let me take the closing. 10 minutes. That's all we had to close. Todd used 20 and it's over. And I got up and I made an argument that I'm proud of to this day. It's the only time I read a transcript of my argument and I couldn't find a single mistake in it. And it was that argument that changed that judge's mind. Not some brief that had been written. Lynn Wood's argument. So I did talk to Todd McMurtry in February. And I said, you know, if your client's They were his clients, it's the mother and the father. I said, if y'all will if they tell Jonathan and Taylor, and then they tell me we're gonna get quantum merit, that'll give me some leverage and I can get them to stop doing this nonsense. Todd didn't do that. He didn't ask them, tell them what I wanted. He just gave them the law and then wrote these people and said, my client's only willing to pay quantum merit. I remember reading it going, wow, that's a surprise. But then they were no longer the client because when Nicholas turned 18, he became the client. And they settled the case on the 18th, or 24th of July. Now, I had made a deal with them on how to split the fees. I was tired of it. Life's too short. Then I realized the way. So they've got to agree to pay that. Nope, not gonna pay that. And I turned it over to them. I said, handle this and get it resolved. I want it in the rearview mirror. And from that point on, I didn't have anything to do with it. Joy and Chris dealt directly with Andrew Bill. They dealt directly with Todd McMurtry. So you'll hear the phrase advice of counsel. I hired them. I paid them a lot of money. And I followed their advice. And after this agreement was executed in March, they informed me in another case that we were discussing that Rule 1.5 of the Georgia Bar Ethical Rules required the client to consent, in effect, not to object, if you're going to share a fee with an outside law firm. Todd McMurtry, Andrew Bill should have known that was the rule. He drafted the agreement for his clients, a fee sharing agreement. Did he miss that rule? Obviously, Joey and Chris did initially, but then they found it and said, this is what's got to happen. They knew all the facts, and they knew one critical fact that is undisputed, which finishes their breach of contract case off. They were not involved in my law firm in any shape, form, or fashion on the date of that agreement, March the 17th. On their own, they quit and walked out on February the 6th. In their own law firms, which they had established. And they were done with me. So they were clearly an outside law firm. And my lawyers were drafting a fee sharing agreement between an outside law firm and a law firm. And my lawyer said, you've got to get client consent. I said, get it. So when Nicholas Salmon's settlement was consummated, and you'll see the affidavit that Nicholas gave. You'll see attached to it an Exhibit A. Consent of Nicholas Salmon.
Objection, Your Honor.
Aye.
All right, let's approach. I've paused.
You're over there.
How was
How was I supposed to know that?
I think I was.
Definitively ruled. Can I tell the jury what it said without showing it?
Mr. Lynn.
I asked her to be brought up, not seen. I'll do it the way you suggested. You're breaking the flow of my direct.
I understand that. I understand that.
Open
If
second.
you just will, verbatim from the affidavit,
I will
Dylan
not.
actually read it, let it in, okay?
All right. The evidence in this case will show that my lawyers drafted a document asking Nicholas Salmon to consent to the division of the fees. They'll come up here and tell you that. They don't have any reason to lie. They weren't involved in any conspiracy to defraud your clients. And he didn't consent. He objected, saying that you need to see some proof of their time, not just time sheets. You'll see a letter Joey Burby wrote to Andrew Bill and said, the client wants to see time sheets or documentations, just do an affidavit about what you did. They didn't lift a finger to do anything. That's where the issue of good faith and fair dealing came in, because they were not acting in good faith and fair dealing in refusing to document their time to satisfy the client's request. So here I am. Do I ignore my lawyers and violate an ethical rule of the state of Georgia and pay them? Or do I follow my lawyer's advice? They actually tell you that the agreement that I made with these lawyers was void ab initio, because the agreement of the client should have been gotten in the beginning. And they said, well, it would be prudent if we did it at the end when it's consummated. I think that is suffice under the law to make it okay. I said, if that's the thing to do, let's get it then. That's when they got it. I didn't talk to Nicholas. I didn't talk to Todd about Nicholas. Todd McMurtry gave a deposition in this case, you all read, and he'll say that in July of 2020 that I told him I wanted to blow up the settlement. But what? I discussed the problems I had with him in February of 2020. I had no such conversation with Todd McMurtry in July of 2020. If I wanted to blow it up, I'd have blown it up before that. I could have blown it up when my lawyer said it's void against public policy because you didn't get the agreement at the beginning. I could have blown it up. I didn't want to blow it up. I wanted to get it done, get them paid, try to help them as I was trying to do by sending them cases, one of which they made a lot of money. Maybe Mr. Bill will ask them how much money they made on those cases that I sent to them. The agreement was set up so that I would receive the funds and disperse them after I took out by their agreement $285,000 that they owed my PC for their share of the office lease. They agreed to that. They agreed that the lawyer for the landlord was right. They were partners in a lease with me. So they don't send any information. All of a sudden, August 27th or 8th, I get a demand letter from my lawyers from Mr. Bill, demanding not $800,000 or $600,000.
Objection, Your Honor.
Demanding.
Wait, hold on, Mr. Wood. What's the objection based on?
Also, negotiations are confidential.
You're saying this is privileged information that won't be coming into the record?
That's right.
Coming from George and Chris as to what happened, that instead of getting the information.
Okay, well, you can approach, you can approach.
A little extra time.
Just pause.
I know.
Just pause. I didn't
This
give
is
them the
not-
same.
This is, they didn't answer.
You gotta keep your voice down. I can hear you. There's no point in approaching.
So, I'm sorry.
Yeah.
I can't.
You just-
So,
You're still very loud.
I'm sorry. I don't understand the problem.
Still very loud.
I mean, I don't understand the problem I'm talking about. I don't understand the problem. This is all clearly admissible evidence.
Okay, let me just hear Mr. Beal's position here.
So negotiations are not admissible.
To settle this case.
They're sure going into them on the question of the settlement I entered into with them, even though the agreement said that it merged So they can't have, it's goose gander. But this explains what happened. It's the truth.
Okay, is the issue that this is relevant to fraud, the state of mind?
It doesn't because it happened after the fact, so that's.
After the fact of what?
After the fact of fraud. This was in August.
Or-
It has to be part of the fraud.
When, I think the cutoff date is the date of the agreement, what they're saying
Well,
is
then,
relevant.
when did it start?
That's
the date
that's
of the
their
agreement.
Theory of the case.
No, it started the day of the agreement under their theory, and it ended the day of the agreement. I'm sorry.
Mr. Wood, this is, and I think,
This is probably something we need to have more argument on outside.
and that's
the
fine,
process.
but I think we need to move on from the opening.
Well, I would like to make the point about the demand I got, because that.
Well, you can make the point, but I don't, it's not going to serve any purpose for a ruling now.
Thank you very much.
All right.
Back on the clock.
Whenever you start speaking again.
No further to say after 20 minutes. So I'm violating Richard's rule. But even Richard can accept that sometimes. So we say that the last. That's the thief on the cross. My attorneys tried to negotiate to have Wade, Grunberg, and Wilson meet the client's request. They did not do that. They made a demand. It's high. And says you got 24 hours to pay it, we're gonna follow this.
Objection, Your Honor, this is right.
Yeah, Mr. Wood, I think at this last phase is, we need to move on.
Well, they've raised questions about why I got fired by Musk and Sandman. The lawsuit they sent me contained 110 allegations that smeared me personally. They had nothing to do with the breach of contract. And it went public day one, all over the nation and world. And I'm sure that upset Musk and Sandman. And was one of the reasons he fired me. I'm sure it upset the state bar, which is probably one of the reasons they tried to disbar him, because they.
Objection, Your Honor. Absolutely no evidence that they had any involvement in the state bar's actions against him.
All right.
It's part of their investigation against.
All right, Mr. Wood, we're moving on from this phase. I'll ask the jury and I'll remind them again, that opening is not evidence.
I'm sorry, it's gone off. And tried a case in December of 2019, so we were arrested. I prayed the Lord would make me as good the last time. One more time, I was the first time. Because he gave me his house. I am an honest man. And it's painful to me to sit here and listen to people that I was so good to hire a lawyer to smear my name. Drew Bill and I go back. I represent Herman Cain when he was running for president. And Drew's law partner went after him publicly with a lady named Ginger White.
Objection, Your Honor.
The relationship between you and Mr. Beal, I don't see relevant to the issues at hand here, Mr. Wood.
Oh,
All right.
I just know, I know who Andrew Bill is. He knows who I am. Judge McAfee's gone to bed for a couple of years. He's busy. But I'm sure that he and anybody else that took the time would look at the body of my life's work as a lawyer and know that I didn't all of a sudden change overnight from one thing into another. I only got changed one time in August 2018 when Jesus Christ rebirthed me. And I became a new man on the inside. Same man on the outside. Otherwise, I'm the same guy I've always been. But thank God I'm different on the inside. So help me in heaven for eternity. My fault. Jesus Christ. There'll be other questions that'll come up. Can't answer them all. But I've tried to answer the question that he raised. Why? Why would I create this situation? Knowing that they would litigate me and cost me millions of dollars in attorney's fees. I'm not a fool. If I thought I owed it, take it. Take the $800,000, $650,000. Because I ain't gonna want to spend $4 million defending a lawsuit for 5 years. I'm no fool. Their case is not the truth. It's a manufactured case by a lawyer. You'll hear from my lawyers at the time, they ain't gonna manufacture anything. They're gonna tell you straight from the witness stand exactly what happened. And it's going to be consistent with everything I've told you. I'm not a fraud. And there's not going to be one evidence. They use the term, he's a fraud. Still, he's a fraud. What was my act of fraud? What was my act of fraud? There is not one that he can point to. Where you signed the agreement and you didn't intend to pay because you didn't pay. That's not fraud. They knew everything that was going on between us before that agreement was signed. Nothing was hidden. They had the emails, they knew my positions, they knew what I was upset about. Nobody was hiding anything. And I'm not hiding anything today. He who has nothing to hide, hides nothing. They sued Tommy Merchant. They added him to the case, claiming that he was a conspirator with me. Because they had to say that. Because I didn't control the client, he did. So I guess the theory is that Todd and I conspired, and then he got Nicholas to not agree, and that my lawyers, Joey Berge and Chris Marquardt, they had to conspire as part of the fraud to give me advice that wasn't true. How many people in the conspiracy? I couldn't have done it by myself. It's a lie. And I don't mind calling a lie a lie. I don't like to do it, but I will call a lie, and their case is a lie. And this is a courtroom where your job is to find the truth and not be fooled by lawyers that talk fast, play fast and loose with the truth. Your search is for the truth. Because if you don't find the truth, you cannot do justice. And your verdict is to speak the truth. That's what it means. I'm fighting for my career. I was going to retire in the fall of 2019, semi-retired. I wanted to write books. And I was going to finish up my work on Nicholas Sandman's cases. I was tired of practice law. This is a new profession. Well, the Lord got me retired. And I write on Telegram. They'll talk about my Telegram post. I write about President Trump. I'm involved in politics. I majored in political science in college. I was a student of politics in the country for decades. I write about what I think is going on in the world, because the world is a mess. It's a fallen world. But primarily what I do on Telegram and Truth Social is I share the gospel of Jesus Christ. And I tell people what's being done to me. The persecution I've been under for 5 years by these lawyers and many others. And I know that I am persecuted for his name's sake. And so I tell them how I deal with it. So that I pray that they will see that I deal with it as the Bible says to do so in a Christ-like manner. Now, we all have different faiths, some of us. My faith is. I respect yours. But I believe in Jesus Christ. And I believe He controls everything. Including this. There's the Son of all things He created. He created all things. Without Him, nothing created would have been created. Praise the Lord. I'm sure I left some things out. But I appreciate you giving me the opportunity to at least tell you what the evidence in this case is. To give you an opportunity to meet not Linwood the lawyer, but Linwood the person. And then ask yourselves, why was Linwood the lawyer and the person so good to these people? So good that in September of 2018, Jonathan Grunberg suffered a horrible fall. 16 off a rock climbing wall, fell like 45 feet, shattered his legs, was in the hospital, had to go several operations. I went to see him. I tried to get a lawyer to represent him to see if he had a case against the rock climbing wall. He did not. He had let his rope get stable. And for 8 months, over time, he was able to do a little work at home. For 8 months, and this is when he was an associate, salaried associate. He had a missed paycheck. And in April, when he came back, I sent him an email. I said, I'm glad you're back. I said, because I know you made an effort to work some from home. I'm gonna give you a raise from $110,000 to $115,000. I'm not might be an unhappy boss. I might be trying to discipline my people I work with, just like God disciplines His children. But I'm not an abusive boss. Anybody that says I am is an unmitigated liar. I can go through a lot more details about the things I did for these people. Nicole was getting ready to leave Ryan Cave. They were dropping her down from equity partner.
Objection, Your Honor. Not gonna be any evidence of any of that.
She's.
All right. Is that,
Not gonna be any evidence of that. And it's not any
Leave
relevance.
that out. I withdraw.
all right, he withdraws it.
She left
Sustained.
Ryan Cave for reasons she can tell us when I ask her. And she was gonna start her own law firm. I knew about some of the problems we had, Brian, and Powell Goldstein. And I told her, I said, look, there's no need for you to go out and rent an office, get a secretary, a copy machine, telephone system. You can come to my office. I've got an extra office, and you can share and rent space from me. I tried to help. A lot more I did for them, that's nothing. Kind of clear that down. Millions of dollars. This man is gonna get up here at the end, he's gonna say, give these people millions of dollars. For what? To go in his pocket? To profit more off of me? If I had done something wrong, if I had violated the law in any aspect, I would stand up here before you And I would admit it. Because I'm not a liar. There's not a lie worth telling. Because God knows everything. He knows the lies before you even tell. So I guess I find myself finishing up. The way Apostle Paul started when he was brought before the tribunals, he represented himself. And he stood with conviction. And he said, I had broken no law, and he had not. I had broken no law. And when the evidence is in, I pray you'll do justice. Fine. But I am not responsible for them. Individually, I'm not even on the lease to pay them. And when you hear all the evidence, I believe in the jury system. And I believe good people in this community, untrained in the law, have the ability to be fair and honest, look at the evidence, and find the truth, and do justice. That's all I ask. Thanks very much. Those conclude the opening remarks of the defendants.
All right, members of the jury, I think we've reached the point where we should break for lunch this afternoon. The time's about 11:50. I'll ask you to be back here ready to go at 12:50. Again, feel free to leave the premises if you'd like to, but be sure not to talk about the case with anyone, including amongst yourselves, and not to do any research about this case until 12:50.
All right. $12.50, Your Honor.
Yes, sir. Is there,
Thank you.
but I'll ask if there's something we need to take up before they go.
Sorry.
Just want to check in before we do recess if there's anything we need to take up or any rulings I need to make before we proceed with the plaintiff's first witness.
No, Your Honor.
Nothing, Your Honor.
In that case,
Know who the first witness is?
I think yesterday was indicated to be Miss Wade, if I'm not mistaken. It appears that is still the case. We'll be back in then. Thank you.
I thought you were supposed to save the best for last.
I could see us being crunched for time and staying on track. I know it's not ordinary to do this in civil cases, but I've done it the last couple of trials, and I think it did help us on time, which is if the plaintiffs are planning on calling Mr. Wood as a witness, there's the option that then Mr. Wood, if he had anything he was going to bring out as in terms of calling himself on direct, that he would just handle that all at once. So there aren't multiple cross-examinations, multiple direct examinations, and that sort of thing.
So I could be cross-examined in their case and then go ahead and finish my testimony on that.
And then you would not need to be called again,
Or
period.
with witnesses, I have absolutely.
So instead of him having to come back later, it's just his entire testimony is done at once. So
We prefer to do it the more traditional way. We have unless Mr. Wood stipulate as to the authenticity of, or not authenticity, the amount of the Washington Post settlement, we need to call him, and it's going to be very, very brief.
Not gonna be
We're
able-
Go into a cross-examination of him. We're going to call him on cross for that one person.
that's the sole thing you're calling him for is the, Mr. Wood, we don't interrupt each other.
Sorry.
That's the sole thing you're calling him for?
Yes, and we were going to get him to authenticate, 2 other documents, but that's it. So, 5
Okay.
questions, 10 questions.
Well, let me say, I'm still under the same obligation to the client, former client of confidentiality.
That's why.
And I'm not able to reveal that amount. But Todd McMurtry did reveal it to him in violation of his agreement of confidentiality. He put it in an email to him, so they know exactly what it is. They should put Todd McMurtry on the stand and let him tell them. I can't tell.
Well, it sounds like we need to take that up. Is this, Okay, well, we'll see as that comes up. But the point being is what I'm hearing is that you aren't planning some extended cross-examination of him, calling him as an adverse witness, in which case I'll withdraw the issue that I mentioned. We'll do it in the normal practice.
Thank you very much.
All right,
guys.
we'll see you at 12:50. All right, we're back on the record. Jury appears to be ready to go. Plaintiff, if you could just go ahead and have your witness come on up here unless there's something to take up. All right.
The presentation software we tested it on Zoom this morning before anybody was on. It was very glitchy and it kept crashing. Go ahead and have the plugin option.
Yeah, try to do it. Do we need that from the outset?
There'll be exhibits pretty early on.
Okay, well, let's get to it. Ms. Wade, why don't you go ahead and just have a seat?
Do you have their exhibit list where we're objections?
So I won't touch any.
Well, looks like we already have. You like, so you can tell them 3. All right, we're off the record as you deal with these things. I think there's an HDMI cord still hooked up to the TV. If you just plug it right in, we may get a seat and you can just be sitting up there in the corner and try it that way. And then at the next break, we can try to get IT here to work through some of these issues. How do you look?
I keep seeing
It's a
myself.
sharp jacket.
Suck it in my
You're doing
phone.
fine. Yeah, I know. I know.
Thank you, my friend. I appreciate
Are you with us all week now?
I'll be with you till Friday. I have
Okay.
something on Friday, unless I can get my partner covered. Get my.
All right, fantastic.
I was trying to do all.
Cheers.
Yeah, I got one.
Oh, no.
Your Honor?
You don't bring your map just in case.
Your Honor? Your Honor? Would it be easier for you and for Mr. Bill in terms of the flow of his examination if he identified the documents he intends to introduce into evidence through Ms. Wade, and then we can cover any objections before it all gets in front of the jury, because we gave you our list.
If there, I mean, I don't know exactly how many exhibits we're talking here and if that would actually save any time. Particular ones you think that could be coming in here.
Take them up as they come out.
We've got a minute while he pulls it up here. I saw I mean, we've gotten your motion in limine targeting certain exhibits. I think as the latest development on the rule of completeness concerns was that now those exhibits were not going to be introduced by the plaintiff. So
I saw where they withdrew 2. I don't know if that was all that fell within the completeness. We'll have to, if they intend to play a clip, I'd like the opportunity to see it before the jury does or hear it to determine whether or not it's met authenticity in case I have to, in effect, void out the witness.
all right, Mr. Beal, let me check in with you. Don't have the email handy, but the challenge to 32, 32A, 33, and 33A on rule of completeness grounds was the follow-up email saying that all 4 of those exhibits were now not going to be tendered by the plaintiff.
Ms. Brown handle that. Can we address that just 1 second?
Sorry,
No, that's all right. Go ahead and do all this issue. We'll be done in 1 second.
Oh, well, that's because his shoes. Can we test the exhibit display?
Do you mean to do what they're talking about? I think you just need to change the input so that it's just being your monitor up there now.
Oh, thank you. It's HDMI 3. Yes.
All right.
And then you know how they do a black scramble that with you.
All right, so let's go back on the record now. It appears that we've got our screen working now with plaintiff's exhibits, and defense was inquiring about their challenge to exhibits 32, 32A, 33, and 33A. And to circle back on an email we received after hours, is it now the plaintiff's intention not to introduce any of those four exhibits?
Those exhibits
Our
will not be
exhibits.
introduced.
All right, so I take it that issue is moot then. And as to the remaining challenges, there was the concern from other lawsuits is available for impeachment purposes. As I indicated yesterday, I think the more accurate language there I should have written was evidence regarding other lawsuits would just be coming in as needed or referenced, but it sounds like the plaintiff wasn't intending to do that in any way. So we'd really just be focusing on what comes out during cross, unless there's some specific other item that you want to bring to my attention. I think at this point we forge ahead. Anything on the plaintiffs
Nothing, Your Honor.
and on
I
the
do-
defense?
I do know, I'm sorry.
I just said it from the defense.
Do you mind if I remain seated?
That's fine.
I noticed, and I've been pulling up our objections, but I guess Mr. Bill prefers that we address them as he tenders them. I noticed a couple of or emails from my son, and those would be subject to an authenticity requirement. So I just want to make sure that we're going to do them one-on-one. When he puts them in, I'll have a chance to review it and object.
That's fine. And I'll just
Necessary.
remind counsel, before they would show it on the screen, let's make sure it's admitted before it goes and the jury can see it. And we review the content. So with that, let's bring in the jury.
No, he was reading other ones he's working on.
All right, what we're going to do. Yeah.
Thank you.
Keep that next.
Glenn, is this your notebook?
Yeah, thank you.
You're welcome. Yep. We'll have you.
All right for the jury.
I forgot all about Word.
Thank you, Deputy Scott. Thank you and welcome back, members of the jury. Please be seated, everyone. At this point, the plaintiff may begin introducing their case in chief. You may call your first witness, Mr. Beal.
Thank you, Your Honor.
Sure.
Plaintiffs call Nicole Wade to the stand. Will you swear in the witness?
Nicole Wade, Nicole Wade.
Good afternoon, Nicole. Can you tell us a little bit about yourself? Where did you grow up?
I grew up in Nashville, Tennessee, and moved to Atlanta after law school.
And where did you go for undergrad?
Vanderbilt in Nashville. Close to home.
And in undergrad, what did you major in?
Political science and classics, which is basically like Roman history and Latin and that sort of thing. I wanted to go do a semester abroad in Rome. And so to do that, I had to be a classics major. So I became a classics major.
And where did you ultimately end up going to law school?
University of Michigan in Ann Arbor.
And after law school, where did you end up practicing?
I came to Atlanta and practiced for Powell Goldstein, which was about,
And what year was that approximately?
that was 95.
And what was that experience like for you at that time in 1995?
It was kind of a different world, especially for women. We had to we wore suits with skirts and pantyhose every day. To this day, I don't wear skirts because it feels so weird to wear without pantyhose. I was so used to that for so many years, and heels. The older lawyers would always think I was either a secretary or somebody, just sitting in. One time, a senior partner said, she looks like my granddaughter. What's she doing here, right? Things like that. It was a whole different world.
Different than,
Good. I need for Nicole, if you would, to speak up a little louder. I'm having trouble hearing her.
You can just pull the microphone towards your
Sorry.
plus G.
Is that better?
Say something, I'll let you know.
Is that better?
A little bit. Can you get a little closer? Try it now.
I can get a little louder.
Say it again.
Is that better?
That's better. Thank you. Thank you.
Okay.
You got better hearing than I do.
so 1995, entering into the legal market here in Atlanta, it was a much different time for a young female lawyer than a female lawyer coming into the practice today, you would say.
Very different. Yes.
And so how, when you were at Powell Goldstein, how did your career progress?
So, at that point in time, the partnership track was either 7 or 8 years. And I mean, you started as an associate, you came in, you worked for your 7 or 8 years round the clock. And back then there was no working from home. You were in the office, you were in the library, and you were working where you could be seen showing your face, usually 7 days a week. But, so I made partner after 7 years, which was the short end of the track.
And what did that mean for you at that time to make partner?
It was a very big deal. It was a huge deal. I was at that point in time, as Lynn said earlier, the firm was a little smaller when he joined, but at that point in time, we had more like 350 or 400 lawyers in a couple of different offices, and so that was big back then. And so it was a very big deal to me. It's what I had worked for many years.
In this initial partnership position that you were elevated to at Powell Goldstein, was it a non-equity position or an equity position?
Non-equity. All partners who came in or who either were promoted when you were promoted to partner, or if you were hired from somewhere else, you came in as a non-equity partner.
And what does that mean, non-equity partner?
It just means that you have a salary. I mean, partner is like a title at law firms. It's like being a vice president at a bank or whatever. It's a title. And so you would have a salary. You would have a set amount. And if you were non-equity, there might or might not be a bonus pool at the end of the year get to participate in. Actually, the year that I made partner, they had a bonus pool for the associates that year, and the equity partners paid a fair amount, but the non-equity partners had no bonus pool. So that's how it goes sometimes.
And so having the title partner in a law firm doesn't necessarily mean that someone's an owner, but they can still receive profits based on how the law firm does?
No, I mean, no, not necessarily, because if you're a non-equity partner, you're not getting paid based on profits. Like I said, like the first year I was non-equity, there wasn't even a bonus pool. So, I mean, it was strictly salary. And so if the firm makes more, you don't necessarily get more. But at the same time, if the firm makes less, you don't get cut, right? Yours is fixed, just like it's a salary.
But some years you could have received extra in that bonus pool as
Sure,
a non-equity partner.
Sorry, sure. Yeah, just like for associates, there's a bonus pool sometimes depending on the profits.
And so when you made partner at Powell Goldstein, what did it say on your business card?
Partner?
Did you have a business card with them?
Yes.
What did it say at that point?
Associate.
Okay, and on the Powell Goldstein website, well, was there a website back then?
I'm not even sure if there was a website back then. It may have been started it may have gotten sometime around then. I don't remember that.
Okay.
I'm not sure that there was. I don't remember when it got started.
And when you signed pleadings with the court, when you filed something, what did it say as your title?
If it said anything, it said partner. But I mean, we had a rule, for example, that every pleading that got filed, and a pleading is just something we file in court. But every pleading that got filed had to have a partner signature. But that didn't have to be an equity partner. It could be a non-equity partner. So once I became partner, I was able to be that person signing pleadings for the firm.
And did you get to go to partners meetings?
Sure.
Um,
Couldn't
It-
vote, but I was able to go.
and did you ever become an equity partner at Powell Goldstein?
I did, yes.
And when was that?
I was 3 years after I made partner.
And was that, well, actually, how did you end up making equity partner?
Because you had to demonstrate that you had a book of business. You had to have your own clients and demonstrate that you were able to, instead of just working on the cases that the senior partners brought in, you had to be able to bring in cases on your own, or at least show that you were able to bring in cases on your own and have other people who would work on them. So if you could do that, then you were able to make equity partner.
And at the time that you made equity partner, was Lynn at the law firm with you guys?
No, not yet.
And when you were promoted to equity partner, how were you paid at that point?
It was still, I think they called it a targeted salary. There was still a target amount. And so you were able to, you got paid that amount every month. And then at the end of the year, the targeted amount was based on the budget. So if we made more money than they thought, you got more money. If we didn't make as much money as they thought, there was like a holdback and they took that money. So it was more based on the profits.
Okay. And can you tell us some of the clients that you've represented throughout your career?
Sure. Lynn mentioned SunTrust and represented SunTrust Bank. I represented, when I was at Powell Goldstein, we did a lot of bank work. And so I represented a lot of banks, Bank of America, Wachovia back then, Reliance, Trust Corp. Who else? We represented a bunch of banks. I worked on different estates. I worked on the estate of Robert Rauschenberg. Most people don't know him, but he was a sort of a modern artist. Rankin Smith, who owned the Falcons at one point.
And I think we heard mention too the estate of Martin Luther King. Was that one of your clients?
Yes.
Do you still represent the estate of Martin Luther King today?
I'm not doing anything for them right now, but yes, I mean, even since Dexter's passing, I have Bernice engaged me to continue to represent the estate,
Excuse me.
but I'm not.
Just to clarify, are you saying she represented the estate of Dr. King or the estate of Dr. Martin Luther King Jr., PC? It's two different
Mr. Wood, I think that's something you can clarify on cross.
I thought it'd be helpful to get it up right the first time, but I can cover it across. I just wanted to be clear.
It's, if you'd like me to explain.
Go ahead.
It's the estate of Dr. Martin Luther King Jr., Inc. is who I represented. Dexter King was the president of that entity. The estate was incorporated. And after he passed, Bernice became the president.
Thank you for clarifying, Nicole. And what would you say approximately is the largest amount for an estate case that you've handled in your career so far?
It's hard to say. I mean, I guess it depends on what you're talking about. I mean, money, the Rauschenberg estate was hundreds of millions of dollars. But I mean, Dr. King's estate, MLK Inc., I mean, that was the Bible, the Nobel Peace Prize, right? So I mean, it depends on what you're talking about.
Hard to quantify those two in
Yes.
comparison. Okay. And at some point, did Lynn come on and work at Powell Goldstein?
Yes,
And when was that?
that was in 2006,
16.
16. No, 2006.
Pardon me. You're right. I just thought she
All right,
was.
Mr. Wood,
I'm sorry.
you know that's not how this works. We're going to let her testify and you'll get your chance.
I just thought she had misspoken. I said 16. She was right, 2006.
All right.
I apologize.
Okay.
Thank
You
you, Your
continue.
Honor. And did you work with Defendant Wood when he was at Powell Goldstein?
Yes.
And what type of cases did you guys work on together?
As Lynn mentioned, when he first came in, it was to work on the SunTrust case. And again, as I said, I had represented a lot of banks. The SunTrust case was particularly large because it was Coca-Cola heirs and they were seeking, I don't know, $100 million or something. And I didn't have the gray hair back then. So Lynn was brought in and to replace the senior partner who was heading towards retirement at that point.
Ultimately, did Lynn leave the firm at some point?
He did, yes.
When was that approximately?
That was 2011, 12, 11 or 10, 11, 12, somewhere in there. Sorry. Somewhere in
Okay,
there.
so some time period between 2010 and 2012, Lynn left the firm that you guys were working at together.
I think that's correct.
And you-
I may be off on there somewhere, but it was somewhere in that time frame.
And you stayed at the firm for some time thereafter, right?
Correct.
And when did you ultimately leave the firm?
In 2015.
And why did you leave Powell Goldstein? Or was it?
It was Brian Cave at that point. We had merged and it was a very different environment. Brian Cave, as Lynn said, was a very different environment from Powell Goldstein. And I had stayed very close to Lynn. And so we had talked a couple of times about me coming over to his firm. And so he had just had the breakup of Wood, Hernacki, and Evans. And so the time was right. And so I left him and joined him.
So it wasn't true when Defendant Wood said in his opening that you were getting demoted at Brian Cave, and that's the reason why you left.
No, that's absolutely false.
And so you and Defendant Wood, you guys remained in touch after he left Brian Cave, and you still work there?
Yes.
And did you guys, during this time period before you came over, did you guys ever meet up socially to have these conversations? You mentioned that you guys spoke about you coming on to work with him during that time period. How did that come about?
Yes. I mean, we would still meet up for drinks at Vini Vidi Vici or, whatever. We would have lunch. Lynn had we had some work things going on. We were still I was helping him in his representation of Richard Jewell for a while. So I helped him with some of that briefing. We still talked. We were still friends and we still talked.
And was there one case or one time period that ultimately ended up with you leaving and coming on at Ellenwood PC?
No, not particularly. It just seemed like the right time.
And in what capacity did you join Ellenwood PC?
As a partner.
And I know we've heard a lot about this whole partner term and it being a title in the legal field. Was it a non-equity partner position or an equity partner position?
Yeah, I was a non-equity partner. It was his PC. I wasn't going to have any equity, but I was a partner there. That I wouldn't be anything else. I was a partner.
And why is that?
Once you make partner, you don't go somewhere and be an associate again, or you don't, that's just not how it works. You go and you're a partner. Maybe if you're older and you're retiring, then you're of counsel, But in the legal world, that's just how it works. I mean, I wouldn't have gone anywhere to be his associate, or it wouldn't happen. Unless you're going to like a part-time sort of situation. Like he had someone before work for him part-time and just write briefs and stuff. But she wasn't ever on the website, part of the firm. But that's different. I was coming over to be part of the firm.
And I'm going to point you to Exhibit 61. Will you take a moment and look at that and tell me if you're familiar with it?
Let's pick one in the middle. Yes,
You're familiar with this document?
I am.
Can you describe to us what it is?
This is the agreement that Lynn and I signed when I first came over. I had talked to a couple of people about joining Lynn and the deal that we had talked about. And one person who I looked to as a mentor said, that'll be great. It'll be great. Lynn's a great lawyer, but just put something in writing. People never do that, and you should. So I typed up this, sent it to Lynn. We met and talked about it, and you can see on here, he made a couple of edits at the time we signed it. And so it just sort of documented what we were going to do, our plan.
Is this a true and accurate copy of the document you're familiar with?
Yes.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 61 admitted into evidence. and published to the
Objection to
jury.
61.
Let me pull it up. I don't think so, but. Man, this is heavy. No objection, Your Honor.
61 is admitted.
Okay, and so I'll point you to page 2, Nicole. And on here, does it describe what your the capacity you were joining Ellenwood PC that you spoke about earlier?
On pay, yes, I guess it does in the second part, yes.
And what does it say?
Employment with Ellenwood PC as a partner. And it was in quotes because I wasn't going to take equity. Again, that was kind of just non-equity partner.
And again, so this designation, if you will, it has something to do with the title and the status in the legal field and what that means.
Correct.
And how did you get paid at Ellenwood PC?
So it was always as we agreed here, and then it only changed when Taylor and Jonathan made partner. But I got, for the work that I brought in, I got 40% for the time that the associates billed on my clients. And I got 60%. No, I got 75%. Sorry, I don't even remember the exact percentages, but I got 75% of what I billed for my clients. My clients that I had were all billable. I didn't have contingency fee work at that point in time.
And were you, during the majority of the time that you were at Ellenwood PC, were you paid individually? Were you paid through some sort of entity? How did you receive these payment breakdowns that you just went through?
So I started with Lynn in May of 2015, and at that point I was just getting paid individually, Nicole Wade. And that changed
At what point did that change?
in August of 2015.
So shortly thereafter you joining.
Yeah, a few months.
And why did that change?
Because Lynn said you should set up your own, I'm sure he said PC. I ended up setting up an LLC, but he said for tax reasons, he's always had his Ellenwood PC. He said you need to set it up for tax reasons because then you can give yourself a salary from the LLC. Then you can run your expenses through the LLC and you get more favorable tax treatment. You're wasting money. You're paying the government money you don't need to by getting paid as an individual instead of having it go through a PC.
So you ultimately set up your own LLC, is that right?
Yes, I did some research, realized he was right. And so I set up my own LLC, Wade Law LLC. And that's the entity after August. I don't remember if that first started in August or if it started in September, but right around there, August or September of 2015, he started, the checks were then made payable from Linwood PC to Wade Law LLC.
So from the fall of 2015 until you left Linwood PC some years later, did you ever receive any payments directly from Linwood PC individually?
No, not after that time, only before then.
Okay. And so at that time, so from fallish of 2015 till the day you left, all of the payments came through your Wade Law LLC.
Correct.
And are you the only owner of that LLC?
Yes.
Do you still maintain that LLC still today?
Yes.
And
Just like how Lynn said he'd always had Linwood PC, I have Wade Law LLC.
And is this a common practice in the legal field to be paid through some sort of entity, either a professional corporation or a LLC?
Yeah, I mean, I think a lot of people do that. I know that it's not as common at big firms, although I don't know if Lynn got paid through his LLC or not when he was at Powell Goldstein, but I know that some people did, particularly if people were of counsel or whatever, they would have their own LLC or PC sign on, and then they would get paid through that entity. I know people do that, yes. And I think now it's really common, but it's always been something that's been done.
And was your partnership with Lynn when you came on in 2015 that we've been discussing, was it ever announced publicly?
Yes.
I'll direct you to take a look at Exhibits 64 and 65 and take a moment to tell me if you're familiar with those after you have a chance to review them. Michael.
Yes, I am familiar with those.
And are these true and accurate copies of the documents they're purporting to be in 64 and 65?
Yes.
At this time, Your Honor, I'd like to move to have plaintiffs' exhibits 64 and 65 admitted into evidence and published to the jury.
Any objection?
Your Honor, this is an article in the,
Page 2, I'll show.
I think I know. I'm saying this is an article published, it says at the Daily Report. And so it's hearsay unless it's authenticated by the Daily Report.
All right, Ms. Brown, any response?
Your Honor, this was a publication. The witness has already laid the foundation. I can lay some additional foundation that she's familiar with it. She reviewed it at the time it was published, and it's an exception, and it's not being offered into evidence for the truth of the matter asserted.
If you're contending it's non-hearsay, then what would be the purpose you are admitting it for?
Sorry, Judge, I couldn't hear you.
Yeah. Let me start with the exception. Do you have the rule number? For
Publication is, oh, is it 801? 801.
among the 22 listed exceptions there, do you have something more specific? All right, so I think I did it as a news article, but that there are statements in here, the objection remains, that may be hearsay. And so it does actually appear that you're offering it for the truth of the matter of what is contained within that article. So we need to understand how that is not hearsay, or excuse me, rather, we need to know why that's an exception to the rule against hearsay.
Your Honor can take judicial notice of publications. In addition to that is a statement against interest. Defendant Wood has repeatedly said throughout this case and throughout his opening that Ms. Wade and Jonathan and Taylor are not part of his law firm. And
If
this
there are
goes to-
quotations from him in here,
Yes, Your Honor, page 2 at the third to last paragraph, starting with trial law firm, L. Linwood PC has added.
all right, well, we don't need to read them out loud. Mr. Wood, why would if there are quotes in there that are from you, would your hearsay objection remain?
I don't see the quotes. I see a statement published in the article, but I don't see a quote from me. Maybe I'm just missing it. Am I missing it?
I can lay some additional foundation. Your
We'll
Honor.
try that, and if not, we can come back to it once we have a break.
Nicole, did Lynn ever announce to the public that you came over to his law firm?
Yes, he did.
And in what capacity did he do that, or how did he do that?
He put an ad in the Daily Report, which is just our lawyer newspaper that legal stuff is printed in, the Fulton County Daily Report. Well, it used to be printed. Now it's only online, but it used to be printed. And he sent out an email blast to everyone who was signed up to get the Fulton County Daily Report. And he had a blurb put into the On the Move column in the Daily Report, which described people who were switching law firms and that sort of thing. And so he, as a firm, announced it in those different places.
And is that something that you had any sort of involvement with, or was this his decision to do that?
He sent it to me before he had it published. And I mean, I saw it. I didn't pay for it, but he said, here's the announcement. And so I saw it before it was published, and then I saw it when it was published.
And so this was all Defendant Wood's doing, not yours?
Correct.
Your Honor, at this point, I think
Renewing tendering.
yes.
All right, Mr. Wood, are you renewing your objection, or is there anything else you want to add?
I don't object. The testimony is accurate in terms of the announcements that were published. This is not one of them. This is an article published by the Daily Report on a variety of issues, and it's not something that she's capable of authenticating, and it's not an article that the judge, Your Honor, can take judicial notice of. So the point is, what this says in this article, I think she's trying to say, and I'm not going to tell her how to do her job, is that I made a public announcement, not in this article. I didn't interview with Meredith Hobbs, but the article itself should not be allowed in.
And I also think we need to clarify which one is 64, which one's 65, what she saw. So.
Nicole, have you ever seen Exhibit 64 before?
Yes, this is the article On the Move, which the Daily Report published. I don't know if Lynn talked to Meredith or not. I think he actually had talked to Robin, not Meredith, but because he wasn't really happy that this wasn't longer.
But this is that On the Move blast announcement you were testifying about earlier?
No, the On the Move wasn't a blast announcement. The On the Move was a section in the Daily Report. This came from online, so On the Move is written really small. But in the paper, it was a section, and it just went through, right? So this first part isn't about me, it's about a different firm. But then it talks about different firms. And so then that's where there's a blurb.
And is this a true and accurate copy of the On the Move publication that was put out in June of 2015?
Yes,
And did you see it at or around the time that it was published?
yes.
Your Honor, at this point, I'd like to.
All right, Mr. Wood, let's,
Yeah.
last word here.
I don't think she's qualified to know if it's true and accurate copy. I think they're fighting over nothing in the sense that the advertisement that was put in the Fulton Daily Report, June 1 is their Exhibit 65. I have no objection to that. But I don't want to set a improper standard that they can just start pulling articles and saying, you know, this is true and correct. So this article should not go into evidence. It's hearsay. And they get what they want on 65. And I have no objection to 65.
All right, so 65 is now admitted without objection. As to 64, this is another article that I'm not hearing testimony that, I don't think I've heard testimony that it was Mr. Wood who provided the verbatim draft for it. So I've not heard any reason why, just because it's been published somewhere at some point, that comes into evidence. So sustain the objection on 64. So
Thank you, Your
that's
Honor.
the next question.
So in addition to some sort of publication in the Daily Report on the Move, you spoke about an advertisement as well.
Correct.
Is the advertisement that's on the screen the advertisement you were speaking about?
Yes, that's the email blast that went out to all of the Daily Report subscribers that Lynn had. I don't know, you pay however much it is for that, and then they send it out to everybody.
And you said the Daily Report is some sort of legal publication that lawyers follow.
Right. I mean, it's the legal paper for Fulton County. So legal notices are in there. It has the cases that come out of the Georgia Court of Appeals, the Georgia Supreme Court. So yeah, all litigators, at least, not all corporate lawyers, but all litigators read the Fulton County Daily Report.
And this email advertisement blast that went out, if we zoom in towards the bottom of the image, can we expand that? Right above that, Michael, please. Great, thank you. So this advertisement listed, is this your email address right here, nwade@linwoodlaw.com, or was that your email address at that time?
It was, yes.
Okay. And did that stay your email address from 2015 until the time you left?
Yes.
Okay. And then what about the website listed below that, the www.linwoodlaw.com? Are you familiar with that website?
Yes, that was the firm website.
And was that the same from the time you came on to the time you left?
Yes.
And generally, we've spoken a little bit about law firms and the titles and those sorts of things, but can you describe to us what the general reporting structure is like in regards to work? Is there any sort of hierarchy, if you will, of who reports to whom in a law firm, and in terms of turning in work, reviews, drafts, those sorts of things?
Well, it depends on, there's a couple of things. It depends on whose client it is, and it depends on who's the senior partner. So you'll have senior partners, you'll have junior partners. So a lot of times, and on the pleadings, which you may see some later, but it'll have like the names in order, and whoever's name is at the top is the one who's in charge. And so if it's your client and you're in charge and then, and your lead counsel, then your name is first. Everyone else has to get you to approve it or sign off before that gets filed.
And in terms of iterations of like first drafts, are the senior partners in charge of doing that, junior partners, associates? How does that work?
Senior partners don't do first drafts of anything. Junior partners sometimes do, but usually not. Usually it's like probably any profession, the people in charge are in charge and the people reporting to them are the ones doing all the work. So the theory is that when you're an associate, you're doing the work. When you become a partner, you're more in the role of reviewing and editing and approving for filing and bringing in clients and you know, big picture, but you're not the one usually researching and writing. That's usually done by associates.
And I believe we heard at some point Jonathan and Taylor came on as associates at Ellenwood PC. Is that right?
Right. Jonathan was an associate when I got there. There was another associate, David Ehrlich. So there were two associates. And then David left and Taylor joined the firm like 6 months after I came in,
Okay.
also as an associate.
And did Jonathan and Taylor ever get this title change from associate to partner?
They did. They were made partner in 2018.
And was there any sort of similar firm announcement from Ellenwood PC or advertisement about Jonathan and Taylor's title promotion, if you will, to partner?
Yes, Lynn did the same thing that he did with me. He put it in the Fulton County Daily Report. It was also in the Georgia Bar Journal. I don't know, I can't remember if he did the Georgia Bar Journal for me or not. If he did, I don't have it, but he put it in the Georgia Bar Journal, which is, again, just something that goes to all the lawyers. You have to be a member of the Bar of Georgia if you're a lawyer. And so, yeah, he did the same sort of thing, the same advertisement.
I'll direct you to take a look at Exhibit 6. Take a moment to look at that and then tell me if you're familiar with it.
I'm sorry, my man, exhibit 6.
Yes, I'm familiar with that.
And what is this?
It's the same announcement that this is what was in the Fulton County Daily Report. They got their pictures, but it's the same announcement announcing that they've been promoted to partner,
So
which is what firms normally do. Whenever you promote people to partner, and for big firms, it's once a year. For smaller firms, it can be whenever, but you put an announcement out saying, we congratulate our new partners, blah, blah, blah.
And what about pages 2 and 3 of Exhibit 6?
This is what I was mentioning, the Georgia Bar Journal, which is just a publication that has different articles, and it, like the Daily Report, has an on the move category. And again, he sent in their pictures and had this published.
Your Honor, at this time, I'd like to move to have Plaintiff's Exhibit 6 admitted into evidence and published to the jury.
Any objection to Exhibit 6?
I have no objection to the announcement that's on the first page of 6. But again, next part of that is the Georgia Bar Journal, and that's hearsay.
All right, again, Ms. Brown, any exception to hearsay? I don't think the disputes of her authenticity, but it does contain out-of-court statements.
I'm sorry. What was the ruling?
Your
I-
Honor, it goes to state of mind. Again, he's made numerous statements that they weren't part of his firm and he's advertising in the Georgia Bar. And I can lay some additional foundation about him approving this and taking actions to make this publication come to fruition.
Okay, if you want to lay that foundation connecting him to it.
Nicole, the advertisement that you're looking at in the Georgia Bar and announcing Jonathan and Taylor as partners of Ellenwood PC. How did this come about? Did you do this?
I did not do this. Kimmy did this, who was Lynn's assistant. She worked for the firm. She was primarily Lynn's assistant, and she would submit these things, draft them up, and she submitted this one.
And at whose direction did Kimmy submit this under?
Lynn's.
Your Honor, I can lay additional foundation if needed, but
You're just retendering. All right, Mr. Wood, does your objection stand?
It does, and I disagree with the characterization of counsel that I'm trying to say they weren't part of my firm. They worked with my firm.
We're gonna confine ourselves to evidentiary objections.
I just want to make sure that I don't waive, because that's not, I haven't taken that position. She said I did. The point I'll make here, I maintain that the first page, the announcement is admissible. And I believe that the rest of that article, or the article itself, is hearsay.
All right, on hearsay grounds, I think, first of all, the first page is admitted without objection. The remainder of it, I think that the witnesses testified that it is essentially a statement by a party opponent. And so the objection is preserved, but overruled. 6 is admitted in its entirety.
thank you,
You
Your
can
Honor.
ask your next question.
Excuse me, Judge, I'm not hearing.
I'll speak up. I'll speak up next. I'll try to speak up from here on out.
What was your ruling on the article itself?
Everything other than the first page you've agreed to, as to the objection for hearsay with the testimony given that this was a statement made by you or at your direction, then I'm admitting it as the exception is by a party opponent. And so the objection is preserved, but it's overruled.
There's been no testimony that I made that statement, or Ellenwood PC made that statement. That's just in a hearsay article. That's my point.
All right.
I think
Based on the testimony I did hear, Mr. Wood, I disagree. And so we'll move on.
Thank you, Your Honor. Okay, so just going back, since now we're all looking at the same thing, Nicole, this page 1 that's on the screen now, which one was this that you were testifying about?
This was the one that was in the daily report that was similar to the one that was put in the daily report when I made partner, except like I said, they got their pictures. Yeah, it's the same thing. It was in the daily report.
Okay. And if we look at towards the bottom of this, it lists the firm's website still as the same thing, www.ellen or linwoodlaw.com.
Right.
And this is same firm as it was when you came on in 2015 and your announcement was made, correct?
Yes, correct.
Same website.
Yes,
So the only thing that was different is Jonathan and Taylor being named partner.
right.
Okay. And if we go over to page 2 of Plaintiff's Exhibit 6, can you describe to us what this second page is?
The cover of the Georgia Bar Journal.
Okay. And then go into page 3.
Right. This is what I was describing, the part that's the on the move, where they just list who's moving firms or who's being promoted to partner.
Okay. And the part that's zoomed in now so that everybody can see what it looks like, this is where Ellenwood PC announced it in the Georgia Bar Journal that Jonathan and Taylor were promoted to the title of partner.
Correct.
If you'll take a moment and look at Plaintiff's Exhibit 5.
Yes, I am familiar with this.
And did you receive a copy of it
Yes.
at or around the time that it was sent?
I was a recipient. I received it when it was sent.
Okay.
Yes.
And besides the redactions, is it true and accurate?
Yes.
Your Honor, at this point, I'd like to move Plaintiff's Exhibit 5 into evidence.
Objection to 5.
I note that there are a couple of statements that are redacted. Could I see an unredacted copy?
Sure.
I don't know what it is.
Oh, it's over $1 million from a case.
What?
It doesn't matter.
I don't know. It may not be confidential. I don't, where's this?
She's already investigated.
You can't, authenticated with redacted copies doesn't mean anything to me.
Right.
What is redacted here?
You received original copies of you.
I know, but it's, you're turning it into evidence and I need to see an unredacted copy.
Your Honor, the defense has been provided all of this in discovery over 5 years ago.
Not as a trial exhibit. This may be nothing over nothing. I just need to see what they've redacted before I can roll over and say this is fine.
What would be the basis for any potential objection you have based on what you can see and what redactions may be there? I have not seen this exhibit.
You got a copy unredacted?
Yeah, but no.
Well, it's hard for me to tell you what my objections would be when I can't see what's under the black of the redaction. I know what's under the redaction, and I object to it unless it's unredacted. There is no confidentiality regarding what's redacted whatsoever. It should all go in unredacted.
All right, counsel, I don't know if you want to approach and lay this on the record. I don't know what's redacted or why it's been redacted.
Your Honor, if Mr. Wood wants to get in on cross-examination an unredacted version, then he's entitled to under the rule of completeness. For attorney-client privilege purposes, we redacted some information that relates to a case name. I can ask Ms.
Okay.
Wade about it on the record if needed.
There is no confidentiality or breach of a settlement agreement with respect to the case it's referred to. It's public record. So I think I'm entitled to have them put in a copy that's unredacted. They redacted something else. But I said, this is not, well, I'm not going to say it. All I got to do is just put the unredacted copy in. Otherwise, I think my objection is good.
Okay, and the objection based on what rule of evidence?
Incomplete.
And
Okay.
under
They're
the,
hiding,
All right.
I don't know why they're hiding that. If they just put it in, it's fine. I have no objection to it.
All right, so they've tendered a document that has certain elements redacted apparently. Those apparently, from what I'm told, are related just to a case name and some other items on the periphery that don't seem, from what I'm hearing, to be directly related to the point they're trying to make. If you have the full copy you want to tender at some point or go into it on cross, you can. But for now, I believe I'll admit Exhibit 5.
thank you, Your Honor.
Make a note. Matt, may I approach the bench, Judge?
If it's just to further expound upon this point, we'll take it up at a break and we can fix it if, to the extent there needs to be further.
While we're on it, it seems like a great time to fix it. My question is going to be pretty simple. Can we go ahead and tender it now so there's no confusion about what they put in here? And 3 hours later, I put something else in. That seems to me to be unnecessary.
At this point,
I'm prepared to offer the unredacted copy to the court right now.
you've got it at hand right now.
Got it right at hand right now.
Then I'll ask
Is it?
plaintiffs, is there any reason we don't sub out Exhibit
It's
5?
electronic, and did we file it with
An
him?
email from Mr. Wood himself. We were trying to protect him, but if he wants to have that come in,
Unredacted?
then again, he can do that.
Where'd you
under
find
the
an
rule.
unredacted copy?
Yeah,
Completeness
we'll
and-
sub that in, and we'll say that Exhibit 5 is the unredacted version. But for now, in the interest of moving this along, we can use this version. But the part that'll actually be part of the record and that you can refer to later will be an unredacted copy. All right. So with that, you can ask your next question.
Thank you, Your Honor. Nicole, if we look here at the very beginning of this email, it starts with Nicole, Jonathan, and Taylor. Can you, Michael, will you please, thank you. Can you read to us how this email from Defendant Wood starts?
Nicole, Jonathan, and Taylor, as you all have surmised or survived, I am not a happy camper lately.
Thank you. And I believe we heard reference, and Drew's opening a lot to the Happy Camper memo. Is it your understanding that that's what this plaintiff's exhibit 5 is?
Yes.
And if we go down further in this email, can you just describe to us generally what was Lynn saying in this email, and what did you take away from it?
Excuse me, Your Honor, the email speaks for itself. It's not what I'm trying to say. It's
All right.
very clear.
Overruled. You can continue if you remember the
Thank
question.
you, Your Honor.
So we had been having conversations around what was going to happen with the firm because the lease was up. So we were in one of the buildings in Midtown and you have to sign like 5-year leases. So Len was trying to decide what he was going to do. We had been having several conversations around, should we set up a different firm? Should we set up a firm Wood Wade? Should we set up Wood Wade, Grunberg and Wilson? Should we have our own separate firms and we would have Wade, Grunberg and Wilson and he would have Len Wood, and maybe we would be in different offices, but in the same building. And so there had been a lot of conversations around what was going to happen and it was unclear. So
Your Honor, may I
then,
approach the bench.
Is there an objection?
Yes, but I want to make it to the court.
All right, you can approach.
I made the objection.
Here we go. All right, next question.
Yeah. Okay, so I'll direct you to the bottom of the page where it starts with, we should meet tomorrow, and there's 1 through 5 number of points. It says we should meet tomorrow to discuss my proposal and any questions you have about it. Here are the basics of the proposal. And what at this point the firm was what did you guys ultimately end up doing? Did you have a different name or did everything just stay the same?
so, well, the name stayed the same. You see the first one. The firm will remain L. Linwood PC. So basically, he took all the other options off the table and said, we're going to remain as one firm.
And what about number 3, bullet point 3?
Right. And that's where, this is when Jonathan and Taylor made partner. He made them partner. And they had already had their own LLC set up because he had told them the same thing he told me. And so what he says here, that our LLCs became non-equity partners at LM Wood PC. We didn't own it. We weren't shareholders under the corporation, but we became partners in the law firm.
And
I mean,
so
they became partners. I was already a partner, but that's what he was saying. We're all 4 now going to be partners. That's what we're going to do going forward.
and so for you, it was the same setup as before. You were a non-equity partner.
Right. The percentages changed because Jonathan and Taylor were no longer getting a salary, so they started getting different percentages, but neither of them was really bringing in work at that point. So it was the numbers were changed, but other than that, right, it was the same.
And they came on as non-equity partners, just as you did back in 2015.
Yes.
And in terms of bullet point number 4, I think it talks about some expenses. Can you describe to us how you guys handled paying costs that came through the law firm and expenses?
Right. Before this, he was taking, so for my clients, they would pay LN would PC, they would get billed from the firm, LN would PC. Then he would write a check to me for 25%, I mean, for 75%. He would keep 25%. And with this arrangement, once Jonathan and Taylor made partner, it became sort of more like a true partnership in that the expenses and the overhead, we each paid a fourth every month. So that was divvied up. And then he then decreased the percentage of what he was taking. So for me and them, so he decreased it to 20%. And so then we just paid our share of the overhead. And so that's essentially eat what you kill is, lawyer speak for you get paid on your work. I'm not just paying you a salary. You do work, you bring cash in the door and you get part of it. That's eat what you kill.
And what if you don't bring in any work?
Then you don't eat.
And so from the time that Jonathan and Taylor were promoted to this non-equity partner title to the time that you guys left, did you split expenses the fourth every month, like you just testified about?
Yes.
And from the day that you started at Ellenwood PC back in 2015 to the day you left, how did you sign court pleadings? What did that look like?
I signed pleadings on behalf of Ellenwood PC.
And when you submit something to the court and you put in your signature block, or is there certain information that you have to provide the court, like the firm name, the firm address, those sorts of things?
You have to, it varies by different courts, but in general, you have to include your name, your bar number, the firm name, the firm address, the firm phone number, the firm fax number, and the email address.
And so all of the information you submitted to the court that we just went through from 2015 to the day you left, it was all Linwood PC information. Is that right?
Correct.
And did you ever at any point list Wade Law LLC on any court pleading?
No.
What about any other LLCs?
No.
All through Linwood PC?
Yes.
And what about your letterhead? When you sent out a correspondence, let's say to opposing counsel, what did it say?
Ellenwood PC.
And it had your email address, nwade@linwoodlaw.com?
Correct.
And what about your business card at Ellenwood PC? What did it say?
Ellenwood PC, trial lawyers, Nicole Jennings Wade, and then our address and my email address, and wade@linwoodlaw.com.
And I'll direct you to take a look at Plaintiff's Exhibit 8 and let me know if you're familiar with that and if it's a true and accurate copy.
I am familiar with it.
And is this a true and accurate depiction of what this purports to be?
Yes, it is.
Your Honor, at this time, I'd like to move to have Plaintiff's Exhibit 8 admitted into evidence and published to the jury.
Any objection to 8?
No objection.
Admitted.
Okay, thank you, Your Honor.
It's larger, but yes.
So is this a picture? What is this a picture of?
It's a blown up picture of my business card. It was a normal size, but this is the business card. This is what Len provided me when I started work. He gave me actually 2 or 3 boxes, which I think I had forever, but yeah, of these business cards.
Okay, and this business card, it had that same email address, same website that we've gone over several times now?
Yes.
And did you ever pass out any business cards in the legal community from 2015, from the time you came on with Lynn to the time you left, under any other firm heading other than the one we're seeing on the screen?
No, I never had any other business cards.
And Did you do all of your legal work through Ellenwood PC from the time you came on in 2015 to the time you left?
Yes, and I should correct one thing. I did have other business cards only at the very end of the practice.
And
With
why
Lynn.
is that?
Because he had changed the firm name at the very end. So I just didn't want to, I wanted to make sure I was correct about that, that he did provide me with additional business cards
And
at the end with a different name. But
and
I never handed any of them out, but I did have them.
And I think we'll get to that later, but what was that firm name?
Wood, Wilson, Grunberg, and Wade.
So it was still just the four of you guys.
Correct.
And what about the website when the name changed to Wood, Wilson, Grunberg, and Wade? Did it stay linwoodlaw.com?
Yes.
So going back, did you do all of your legal work through Ellenwood PC from the time you started in 2015 to the time you left?
Yes.
Did you ever do any legal work from the time you started until the day you left through a personal LLC?
No.
What about through any other entity besides Ellenwood PC?
No.
Did you ever receive any, I think we went through payments already, but did you ever handle any matters outside of the law firm Ellenwood PC? Did you ever perform any legal work?
No.
What about perform legal work on behalf of other law firms?
No.
And how did you guys keep up with your time if you did at Ellenwood PC?
For hourly cases where the clients were billed hourly, we kept up with it hourly. We would write down if we spent an hour working on a brief, we actually put it into the computer. We had a program and we would type it into the program, and then Kimmy would generate the bills and send them out. If it was a contingency fee case, so in other words, we didn't get paid unless the client got paid, we didn't keep up with our time.
So the only time that you guys would record your time in some sort of software was when the client was being billed by the hour. Is that right?
Yes.
And can you take a look at plaintiff's exhibit 253 and 253A, and that's in binder 2. Nicole, are you familiar with plaintiffs 253 and 253A?
I am.
And is 253 a true and accurate transcript of the recording that's on 253A?
Yes.
And was
Okay.
this, what is this a transcript of?
It is a voicemail that Lynn left for me on February 11th. I forget what time, in the morning.
February 11th of what year?
Sorry, 2020.
And you received his voicemail at around the time that it was left on your phone?
Yes, I listened to it sometime shortly thereafter.
Your Honor, at this point, I'd like to move to have plaintiffs exhibit 253 and 253A admitted into evidence and published to the jury.
Any objection?
I can't find it. If you'll bear with me, this binder he gave me is so full, I can't. I can't go from, it doesn't flip from number to number, so bear with me. Trying to put it back together now. What's the number again, please?
253 and 253A.
Could I be reminded of what the date of this allegedly is?
I believe the witness testified it was February 11th, 2020.
All right. I objection, Your Honor. The transcript is not done by Ms. Wade. The transcript is done by rev.com. I don't know who rev.com is. So there's no way for her or me to be comfortable that rev.com has accurately transcribed some voicemail or otherwise. It may be. It doesn't.
All right. So on
Problem,
250,
when I read it, it looks like it's got some errors. So
understood. On 253, is there an objection to the recording itself?
I don't have the recording.
If you don't have an objection at this time, Mr. Wood,
I
then
don't have the recording. I don't know if it's complete. I have a
All right.
transcript, but I don't have the recording. If they're
this
gonna
is,
put
and
the tape,
is your claim this hasn't been provided to you in discovery?
I haven't gotten anything from them about the exhibits until I just got this large notebook.
All right.
So I don't know whether I have what number is it? 254?
53.
All right. So we'll take this up at the next break,
Well,
Mr. Wood.
I could listen to it and try to see what I can tell, but whether it's complete or not, that's the only issue I would have.
Okay.
But this transcript is not authenticated and it's not admissible.
And
All right.
I'm happy to
As to the
take-
transcript, Ms. Brown, I think there needs to be more of a link here
yes,
authenticating
Your
that.
Honor,
You
I'll
can
lay some
establish that.
additional
foundation.
foundation. Thank you.
And as far as the tape goes, if I could have a moment, if they give me to listen to it, I could probably easily say yes or no.
At this point, I'll give you that time when the jury wants a break, but we have to keep
Then-
moving.
Then it ought not be played until I have that time.
I think all right. I
Couldn't be
understand your
fair.
request, but
Just-
we'll move forward.
Just briefly, Your Honor, for the purposes of the record and to respond, all these recordings were provided to Defendant Wood and Discovery years ago, and they have received a copy when they received all of our pretrial exhibits that are printed here prior to trial pursuant to the court's deadline. Nicole, looking at 253, can you, I know you said you're familiar with this, it was a true and accurate copy. Can you describe to us how this transcript was made?
Excuse me, Your Honor. That was just what you just ruled on. She cannot say it's true. Correct.
She's asking her if she has. So we're going to find out what her answer is.
Rev.com transcribed it.
That's not how this works, Mr. Wood. I disagree.
Rev.com is the only one that can testify as to its authenticity.
I disagree. I overrule your objection. I want to hear the testimony to see if it's properly authenticated.
Thank you, Your Honor. Go ahead, Nicole, you can answer.
So rev.com is what was your question? Do you want me to explain what this is?
Yes, how this
Okay.
transcript came about.
So rev.com is a website. Our firm has an account on that website. It's pretty awesome. You just transfer audio files into it and it transcribes it. And it does it, and then you review it, and it allows you to listen and read it line by line. And then that's what's generated. So I took the complete voicemail as it was on my iPhone and had to save it to my desktop. Then I dragged and dropped it into rev.com. Rev.com then emails me this. I go on the website and then I can read this and listen to it at the same time and track it.
And did you do that in this case to confirm its authenticity?
I did.
Your Honor, at this time, I'd like to move to have Claims Exhibit 253 and 253A admitted into evidence.
All right. If there are any discovery concerns, we can take those up at the next break. But based on what I've presented so far, the objection is preserved for both exhibits, but I am admitting both at this time. You can proceed.
Thank you, Your Honor. I appreciate everybody's patience while we deal with some technical issues.
Getting ready to play the tape?
I believe so.
May I approach?
If this is just the same grounds for the same objection,
No, it's different from what you just said.
you have different grounds and you need to approach, all right.
I'm sorry?
Well, no, yeah, that's fine. While he's pulling it up.
He doesn't want that. He doesn't want
I want to make sure when you say reserve. Reserve for appeal. Wow.
But I guess I'm saying reserved.
Thank you. Thank you very much, Judge.
All right, I think the jury is asking for a break here.
No, we have a question. Sorry.
Okay, ma'am, if you could just identify yourself by your jury number, that's all. All right, juror 17, you have a question for us.
I do.
Okay.
I didn't know if I needed to.
Sure, we can put it in writing, that's fine.
Okay.
I'll mark this as court's exhibit 1. All right. And counsel, you can come take a look. I'm just gonna extract a note generally that the jurors don't ask questions and tell them during the presentation.
Who's from? I think y'all was on the same.
You can clear voting.
Clear up the jury. Who?
I will.
Oh, you could do that.
What I am going to instruct them.
Yeah. Sure. Thank you.
All right. All right. So we received a note kind of asking for a point of clarification about the evidence. I shared it with the parties, and for this one particular occasion, they may address it, but I do need to let y'all know that just the way procedurally we go about this is there's not really a back and forth here. We can talk logistics, breaks, that sort of things, but we really don't take questions from the jury when we're presenting the evidence. Y'all are just kind of that receiving information. So thank you for that. All right, is the plaintiff ready to proceed?
Yes, Your Honor. And before we play the recording voicemail, Nicole, just for clarification purposes, the transcript that you made on rev.com, is that just through some sort of like subscription you guys have to rev.com?
Yes, you can use, I mean, I think there's a free function. And then I signed up for, I mean, it's an awesome service. So I signed up for a service for our firm subscription. So you get to transcribe like 1,000 minutes a month or something like that for $25. I don't remember the details, but something like that. And so, yeah, we just put these things in there and
Okay, so it's just a website anyone can go to in the public to go use and either create a free account or have a paid subscription to.
yeah, I think for the free account, you're limited in how many minutes. It like counts it by minutes. So when you drop it in, it says, like for this one, this will use 2 minutes of your 1,000 whatever. And I forget the difference, but you just get more minutes And it generates it AI, and then you have an option if you want to have a live person come and do it. But the AI, there's two different choices. You can have it do either verbatim, which puts in kind of every and everything, or you can have it do it without that. I always do verbatim, and I've found it to be very accurate. I mean,
Okay.
it's not perfect, but it's pretty darn accurate,
And
as best I could tell listening.
And I think we went over this, but just to confirm, you checked the transcript that was generated through the
I think
software.
we already covered that. I don't want to get duplicative here, or cumulative. You're experiencing some technical difficulties still.
Yes, Your Honor, I was gonna say, I'm gonna go ahead and play it without the transcript since we're having some technical issues.
Okay, if that's how you'd like to proceed. Otherwise, maybe it's been an hour and a half. If the jury wants to step out for 5, we can do that as well.
We can
But-
take a break.
Seeing no hands, then let's keep moving forward.
Okay.
Well, Ms. Wade, person you talked to me last night, you're a wise person. You and I were meant to talk last night. Certain things have been made clear, very clear to me today, and I never felt done. Same guy today that I was saying last night, you were right. This law firm is going to go forward as Wood, Wilson, Grunberg, and Wade. Business as usual is back now being business as usual. Keep doing what you're doing on the cases you're doing. I don't need your hours in any case, I never have. I don't need to do it now except in billable cases. Any questions about what you're supposed to do, and there'll be questions you had a day or two ago. It'll be the same question. It'll be about a specific matter. Ask me. I'm not going to be at the office today. Timmy's going to come down there. He's going to reopen my office door. And we're going to continue with our signage. But we're going to continue the partnership. A partnership under that name is going to be one of the great partnerships in the history of the law. That's what I believe. You're all going to have fun. You're all going to be happy. We're going to start doing things because we care about each other. We trust each other. We love each other. We were meant to be together, all of us. You, Nicole, them, Taylor and Jonathan, me, Lynn. Everything's going to be good with Kenny. Everything's going to be good with Chelsea. In fact, over the next few days, things are going to be better than ever before. I'm going to ask you to do the big word T. Trust me. So if you trust me, let's go enjoy your day. I won't be at the office today. I don't have anything that comes up that I need to call you for. I'll be at the office tomorrow. I'm always available if you need me. That is, if you need for me to answer any questions or you need for me to give you any direction, you can always call me. I love you, Nicole. I've never been happier in my life. I'm sane as a damn judge. And I'm as loving as the best of God you ever made. I'm not God. But I'm going to let God's will be done for our law firm. I'm going to let God's will be done for y'all's lives. I'm going to let God's will be done for me. I'm going to let God's will be done for Richard Jewell. That's what counts. It's coming from the right perspective. Everything makes sense. Sometimes God works in a serious way. God's will is always done. I'm going to stop getting in the way of it. Everything I said in that letter last night, continue to go back to business. I'll see you in a little while. If you need to call me tomorrow, but if you need to call me. Otherwise, I'll see you tomorrow.
Okay, so Nicole, in this, when Lynn says, keep doing what you're doing on cases you're doing, I don't need your hours in any case. I never have. I don't need you to do it now except in billable cases. What did you understand that to mean?
So this was February 11th. We had had some difficulties in the preceding days, and Lynn had said, give me your hours for the Sandman cases. I need your hours, which he knew nobody was keeping their hours. We didn't keep hours on contingency fee matters. And he had sent the email, which I'm sure we'll see at some point. And so, and I had talked to him that night, and this was what he said the next day. Forget all that. That's rescinded. I don't need your hours now. I never did. I mean, it was just like he said, okay, we're going to go back to business as usual. It's going to be the same.
And so for purposes of time, that would be keeping up with your time so you could bill clients and make money and not keep up with your time for contingency cases.
Correct. When he says,
Your Honor,
I'm sorry.
leading.
All right, to leading, if you want to rephrase, Ms. Brown, but I will give you some leeway on leading in the interest of time.
Did, and what did you, understand him to mean as business as usual?
to be the same when he says, I don't need your hours. I don't need you to do it now, except in billable cases. That's what I was describing before, where we would write down, I spent an hour working on this. Then you send it to the client and they are charged by the hour and they pay per the hour, as opposed to the ones he didn't need it. And at this point in time, we were working mostly on the contingency fee stuff. So that's, I don't know that he had any, I don't recall any billable cases, but that's the distinction.
And during the time that you worked at Ellenwood PC, did Lynn keep track of his time for billable cases?
Yes,
And what about on contingency cases? Did Lynn keep up with his time on those?
no, I mean, that's one of the, at the big law firm, we had timesheets and we had every single hour from 7 a.m. to 7 p.m. Broken down, and you would draw a line and you say, I did this, I did this, I did this, and you would account for every 6 minutes. And it was insane. And that included time that you spent like reading the daily report or whatever. You put that down as Z time, non-billable time, because you had to report to the firm what you were doing. And so that was one of the things when I came over, that's okay, you don't have to do the timesheets anymore, right? You only have to put in your hours for billable time. That was a huge benefit. It was very nice not having to keep up with my time like that anymore. So we only kept it in billable cases where we were billing by the hour.
And when you were at Ellenwood PC, did you have any sort of place where you electronically stored documents?
Yes, we had a Dropbox. So Ellenwood PC had a Dropbox account, and all of our files were in there. We had different folders, and then they were all in there in that one account.
So this was an online system that you guys had access to?
Yes, correct. Lynn had some of his older files, which sometimes we had to use on a hard drive that we would have to access, but everything newer was on the Dropbox.
So all the current cases were on the firm's Dropbox?
Yes, and we still kept records. We still had a lot of paper. There were physical files as well, but more and more it was just keeping stuff in the Dropbox file.
And who had access to this online Dropbox?
Lynn, Jonathan, Taylor, Kimmy, and Chelsea, who was our assistant / receptionist, and me. We all did. We all had access to the same information.
Did anybody outside of Ellenwood PC have full access to the firm's Dropbox account?
No, they would not be able to.
And why is that?
Because law firms and lawyers have duties of confidentiality to clients. So, for example, what we were talking about before, where we had blacked out the client's name, we have obligations to not tell people about our clients and their issues. So it's very important. And there have actually been articles written about whether Dropbox is secure enough. And for a while they weren't, but now they have enough security that it's generally accepted that law firms can use Dropbox. But the client files have to be maintained securely. It's the bar rules. It's every bar rules. Every lawyer has that obligation to maintain client confidences and client information confidentially.
And did you ever do any legal work from the time you started at Ellenwood PC to the time you left and store that legal work anywhere other than the firm's server or where the firm stored its files?
No.
And I know we've talked somewhat about the website, the Linwood Law website, but did you guys have, was this one firm website that you guys all were listed on?
Yes, Linwood Law was the website and you saw the picture. That was the cover, and then we each had our pages, just like Drew said.
And can you take a look at plaintiff's exhibits 10, 17, and 71 and tell me if you're familiar with those? I'll give you a moment.
Number 10, 17,
Okay.
7, 10, 17.
Okay, Nicole, are you familiar with plaintiff's exhibits 10, 17, and 71?
I am.
And just generally and briefly, can you describe what these exhibits are?
These are copies of different portions of the Ellenwood PC website that we pulled and printed. It's different pages. It's the main page, and then the who we are page, and the photographs, and then 71 is again the main page. Several different times we pulled it from the Wayback Machine, which is free for sure. And you can go and pull it. I mean, we didn't keep copies of the website at the time, but once all this started, we went back and pulled these copies. And this is what it looked like at the time. We were all younger.
And so if somebody from the public wanted to get access to this Wayback Machine, how do they do that? Is it a website? Is it a software?
Yeah, no, you just go. Mine is, I have it as an icon on my browser, so I just click it. But I guess it's a website. I mean, we've got the links on here. This is where it is. And it's a project. I don't remember who the owner of it is, but it's a project where they're trying to like create an archive of websites so that things are preserved more uniformly instead of haphazardly. So like you can actually go to a website and have Wayback archive it.
And are all of the screenshots in plaintiff's exhibits 10, 17, and 71 true and accurate copies of the linwoodlaw.com website from the waybackmachine.com?
Yes.
And
And this is what they look like on the dates. We've got the date. It tells you which date it's pulling from. It saves it at various different times. And this is what it looked like. I mean, this was our picture that was on there for few years.
Your Honor, at this point, I'd like to move to have plaintiff's exhibits 10, 17, and 71 admitted into evidence.
Any objection?
And flip to 71. No objection, Your Honor.
To 10, 17, and 71 are admitted.
Thank you. Okay, so now that we're all seeing this, Nicole, can you describe when this was on the website, what date this depiction was from?
This is from 2018. this picture was taken before that. The picture was taken, I don't remember if it was 2017 or even 2016. The pictures were taken before Jonathan and Taylor made partner, but this is the picture that was on our website when you would pull it up. This is the picture that was up there for several years.
Okay, and then going to page 2 of Plaintiff's Exhibit 10, when was this screen grab recorded from?
This one's from February 16, 2020. And you can see that in the URL 2020-0216. And then I think that's the time, but that's how you know the date.
So the linwoodlaw.com website from May of 2018 through February of 2020, at least what we see in pages 1 and 2 of Plaintiff's Exhibit 10, stayed the same. Is that right?
Correct.
And then if we go to page 3 of Plaintiff's Exhibit 10, can you describe what portion of the Linwood Law website this is from?
Yes, right. When you clicked on if you were on, this is on the About Us page, and then you've hovered over the attorneys. If you hover over the attorneys, it gives you the drop-down menu. And, there we are in order of seniority, Lynn, me, Jonathan, Taylor. And so then when you click on one of those, it goes to that person's page.
And
Bio.
going over to Plaintiff's Exhibit 17 now. Can you describe to us what portion of the linwoodlaw.com website this is from?
Right. This is the About Us, which is what we were looking at before, except now we're not hovering over the attorneys tab. Now we're just reading what's on the About Us page, and this is what it said.
And if we go over to the next page, what is page 2 of this exhibit?
I mean, it was all on a page, so you scroll down, you can't print it on the whole page. I mean, unless you make it tiny. But so this is just when you scroll down, this is what you saw, and we had the pictures. Like I said, these were taken before Jonathan and Taylor made partners, so it was Lynn and I were the partners, and Jonathan and Taylor were the associates. And we never had new pictures taken.
And from what point in time was this screenshot of the About Us page of linwoodlaw.com taken from?
This one was from May of 2018.
Okay. And if we go over to the next page of Plaintiff's Exhibit 17, the next 2 pages.
Right. This is the same thing, except at the end, you see that this one's from the February 16, 2020, whereas the other one was from May 2018, but the page was the same. We didn't change it.
Okay. So same as the firm's homepage, the About Us didn't change from 2018 at least until 2020 in February at some point.
Correct.
And if we go over to Plaintiff's Exhibit 71, we can quickly scroll through these. And Nicole, can you just tell us what all of these screenshots in general terms and how to read these?
Right. So this is again what was on the main page. And this just shows actually in this one, that's the Wayback Machine. That's how it captures it. And so it shows you the date and it shows you how many captures it had of this particular website. And so this one was February 16th, 2020.
Okay. And what about page 2? When was that one from?
Page 2 is January 8th, 2018.
All right. And page 3?
And we had a little scrolling. The only thing that changed, and it didn't change, but this at the bottom was a little scrolling thing. So it did change at different times, but like it would move.
It had several different like announcements that it would
Correct,
scroll through.
yes. Okay. Sorry.
Okay, and so these are just from various times from 2018 through 2020 of the launching page of the firm's website. Is that right?
Yes. The first page and then the who we are page. And as it scrolls all the way down. And then that's Kimmy and Chelsea.
And those are the two individuals you mentioned earlier who also had access to the firm's Dropbox?
Yes, correct.
And can you explain who Kimmy and what role Kimmy and Chelsea served for the firm?
Kimmy was the office manager, as it says, an executive assistant. She did a lot of paralegal work for the firm and after 2018 worked primarily for Lynn. Before 2018, Chelsea was mostly receptionist and she kind of, when Taylor and Jonathan got promoted to partner, she kind of got promoted to assistant. So she kind of became more of our assistant. It was, for a while, it was going to be like Kimmy was working with the partners and Chelsea was working with the associates. And then it switched to where Kimmy was really working for Lynn and Chelsea was doing work for the rest of us, like sending out letters or that sort of thing. But Kimmy did all of the billing and everything for the firm.
And they both worked for the firm?
Correct.
Your Honor, we've been going for a little bit. I could use
you need a
a
break?
courtesy
All right.
restroom break if
Folks,
that's okay
just
with
let
you
us know
guys.
when you're ready. If we could, just let us know by the light when you're ready to come back.
Thank you.
How much time we got, Judge?
I mean, at least 5. But let me check in before.
Might need 8.
That's fine. All right, let me just check in before we break. I know there's been some speed bumps, but how much more ground do you expect to cover with Miss Waded?
In an hour and a half to 2 hours.
All right, we'll be back in whenever the light's on. I'll bring him back in. We'll be in recess off the record. You can step down. All right, Mr. Kavanaugh, here's Exhibit 1.
Oh, yes.
Okay. Yeah, no, I'll do it.
Thank you. We're right on. Yeah. Which is good. It's great. Looks good. Did great. Okay. Did you get into it with that guy yesterday? Were you the one that had the wrestling? Had a gun?
in jail.
Yeah.
Was that scary?
Huh?
Were you scared?
No.
No, you knew you could handle it.
It was
You
just
better
so
not be
weird. It
scared.
just went from 0 to 60.
You better
so
not be
fast.
scared.
Yeah.
We trained for
Yeah.
this.
I was scared and then it kept escalating instead of de-escalating, and that's what made me.
He was trying to get back into the courthouse. He didn't get back in.
Yeah.
And we saw the mark.
Down on the wall.
Was that his head or?
But it's that legitimate.
Yeah. Yeah. Well, we appreciate it. I mean,
Yeah,
it
I was
just,
just trying not to go. Let's get close to that class.
All that old glass, I represent this guy that installs it, all that old glass, he said, when you go to an old hotel and stuff, you just can't get that close to the windows because they will give.
It's like some,
Yeah.
You're doing a great job.
It was crap, and I kept about 30 minutes later, it just came out.
Jeez.
So I was thinking, I didn't want anything.
It's okay. I appreciate you.
It's when we rushed out and we got.
Thank
you. But those aren't going out on YouTube.
Yeah.
I love the plan again.
Watching on YouTube. I mean, even aesthetically.
Oh, he
He
ran.
escaped?
I didn't know that.
Didn't
Where was the
trying to
hole in the
leave.
wall? Was that a punch?
That was his shoulders.
That was the shoulder. That's what I thought, not a punch.
How did you get him on the first floor before he left?
Yeah, I called all the deputies.
I see. Because he was shocked when he. Oh. True. Yeah, I know about him.
Sure, if you want me to put it up.
I think so.
So this is me about,
Yeah.
tell her right now while I'm still up there. And and if you,
back. Here, I'll show you.
That was my concern. He clearly did
That's
this
what I
whole
was calling
shape.
for, other deputies. They didn't get his corporate.
Judge coming out.
What is in order?
Oh, shoot. I mean, I'm working on it. You said yours is black, right?
Yeah, yeah.
That's already in too.
I'm so sorry, I was speaking. I didn't make it. I didn't make it. What you got?
Thank you.
Jonathan, can I have another water bottle to put in me?
Okay.
I can't believe it's not water.
So what's the earliest possible Todd's gonna get here? The jury binding already, so we can. I'm just wondering whether to tell them to get them up here today or tomorrow morning.
I've never been mine. Yes.
Still might be, but, you know. We can have some drinks. No, that's what I'm.
Oh,
In the
that's
back of
what
the
she is,
bus.
all right. We call it first class, you know?
Yeah. Okay.
All right, here you go. son.
Judge.
Well, we'll come to order.
Yeah, no.
The service around
Yeah, well, I mean, when you're writing down every word, I know you need your energy.
here. Fine, for sure.
All right.
Would you like for me to?
I mean, if you're eager to, we still don't know what the jury's up to, so whatever you prefer. You'll have time.
Just want to be ready.
Yeah, I appreciate it. I appreciate it. Is everything good on tech? You can use this time to test some other things. Okay.
We've been through that.
All right, good deal.
Thank you, Your Honor. Anything special? No.
I know, well, as is.
It would not matter.
Get that. No. No, she's. She done that. She done that. Okay.
Yeah, had protein, good as well.
Oh, there's a ton more. Okay.
Ron,
Sir.
Wade's still abstaining, so she's not allowed for counsel.
She's not allowed to discuss her testimony with any other witnesses.
We don't know what she's talking about with anybody. Mr. Grunberg's a witness, she's certainly talking to you. You're not, once you're on the stand, you're not allowed to, during a break, talk to even your own lawyer.
And that's not my understanding, Mr. Wood.
Certainly not.
I can find you. I think we got a opinion from Justice Pinson on that most recently. I'll see if I can find it.
I'd love to see the ruling. I told you I haven't been trying cases in a few years, so things may have changed.
Well, I'm sure every jurisdiction might do it a little differently.
They're all different. I covered 28, 27 when I was practicing.
Yeah, it's Judge Brown versus. Just outside the building.
Man, we can put it on the record if you want to, but I'll just give you the citation that I'd found is Ward v. State 316, Georgia 295. So that would have been a 2022 or 2023 case. The rule of sequestration prevents witnesses from hearing the testimony of other witnesses, but does not prohibit witnesses from speaking privately with the attorney who called them. So there's that. And there's something else from O'Kelly versus the state. No, I know, but that addresses one aspect of what you were saying. And then we got O'Kelly versus the state, 175 Georgia Appeals 503. The rule literally prohibits witnesses from being examined in the hearing of each other. Obviously, if the purpose of the rule is to be adequately served, they may not be told what prior witnesses have said either. This is a different situation where they're parties. Well, I'm not speaking into the microphone. Yeah, give me one. Just close the door. All right, we're back on the record. And is there something that you want to raise at this time? Or
Already asked Your Honor about it. My understanding is when the witness is one thing, they're not allowed to talk with other witnesses. They can see, I think they can ask their lawyer or something, but I'm not even sure that's allowed in a lot of jurisdictions. I know in federal court that doesn't matter. That's all.
all right. So, and again, before we went on the record, I was citing a case saying they can talk to the lawyer. Yeah, and echoing from, I was finishing the Saito Kelly versus the state 175 Georgia Appeals 503. Just instructing all the parties and all potential witnesses not to discuss the case with other witnesses or parties until the evidence is concluded or both have been excused from further appearance. There are exceptions when someone's a party, they're allowed to sit at the table the entire time, so they're in here. So to the extent someone's in the midst of their testimony, I agree with you, Mr. Woods, that they should be talking with their attorney, but not with other parties until they have finished and concluded their testimony. All right, is everyone on the same page?
Sure, we're on the same page.
All right.
May I ask a point of clarification?
Sure.
I'm not going to be done today. Are you telling me I can't? Sorry. Are we trying to say I shouldn't talk to Jonathan and Taylor tonight about anything? And I was not talking about my testimony, for the record. We were.
No, it's not about
chatting.
anything. It's just about the case. And you can, and your testimony itself.
That's great.
Not allowed to talk to Taylor. Maybe she'll get through today. I hope she gets.
I think she's referring to your cross-examination, though. That's probably not what she's going to be through.
Well, that may go long.
Right.
So she's not going to be allowed to talk to Jonathan and Taylor about the case tonight, but she's still on the stand. Am I right?
I agree with that.
Thank you.
Okay. Now that we're clear, let's bring in the jury.
Thank you, Your Honor.
All right, the jury.
Thank you, Deputy Scott. Please be seated, everyone. Plaintiff may proceed.
Thank you, Your Honor. Nicole, right before the break, we were looking at screenshots of the website. I'm going to direct you back to Plaintiff's Exhibit 17 that shows the About Us webpage from 2018. And if we can highlight that first paragraph, who we are, Michael. Thank you. Okay, so on this website screenshot that we're looking at from linwoodlaw.com, it mentions that the firm has a combined over 65 years of experience. Did Lynn have 65 years of experience at that point in 2018?
No, that's combined means all of us. If you add it up, we added up all of our years, I think, and that's what this is. So when we first put this up, I don't know if we changed that or not. We'd have to look at the other ones as we went along. But yeah, when we first put this up here, we added up. Lynn had, I don't know, 40 at that point, and I had 20 or 20, a lot, and Jonathan and Taylor. So we just added it all up.
So it was the four of you guys, your combined years of total experience.
Correct, yes.
And can you go over to Plaintiff's Exhibit 14 and take a look at that and tell us if you're familiar with it?
Yes, I am familiar with that.
And are these true and accurate screenshots from the Wayback Archive from the times that they say they're from?
Yes.
And did you take these screenshots?
Yes, I did.
Your Honor, at this point, I'd like to move Plaintiff's Exhibit 14 into evidence.
Objection to 14?
No objection.
Submitted. Thank you. Okay, if we can zoom in. Thank you, Michael. Nicole, what is this screen capture in Plaintiff's Exhibit 14 that we're looking at?
So this is my bio. So the one we were looking at before, when we were on the About Us page and you hovered over the attorneys, if you went down and clicked on the one that said Nicole Wade or Nicole Jennings Wade, you get here, my bio page.
Okay, and the linwoodlaw.com website under the attorneys for your bio page, what did it list you as in May of 2018?
Partner. That didn't change. I was always listed as partner.
Okay, and if we look at page 2 of Plaintiff's Exhibit 14, did anything change in terms of how you were represented on the website from May of 2018 to February 2016?
No, I had updated my bio, I guess, but the partner part was the same.
So other than updating what you had accomplished, everything else stayed the same. You had the same photo.
Same photo. We didn't retake them.
Same email address.
Yes.
And same office phone number.
Yes, that was always my Linwood Law number.
And just briefly, how, in general terms, was it working with Lynn?
Depends on when you're talking about. Generally, Lynn was an amazing lawyer. I would never deny that. Working with Lynn was awesome. Got to work on amazing things. It was good. We had fun practicing law.
And did the experience of working with Lynn ever change?
It did.
And when was that?
In and around the time of the Musk trial, as he talked about before, and then which was December 2019, and then particularly January and February of 2020, it changed dramatically.
Okay, so the Musk trial you said was at the end of 2019?
Correct, it was in December.
And was there any other major contingency cases that the firm was working on during that time?
Yes, so pretty much all of 2019, we were working on Sandman, the Sandman cases, there were several of them, and the Musk case because it was scheduled for trial and there was discovery and there were motions going on and we were flying back and forth from California, LA. And so those were the two. We were pretty much exclusively working on those cases. I may have had a couple of other small things going on, but it was pretty much exclusively working on those contingency fee cases.
And can you, speaking of contingency fee cases, can you describe to us what that means if a case is on a contingency fee?
So a lot of times it's, associated with the billboards that you see. A lot of times it's personal injury type work. In defamation, they also do it on, we do it on contingency fee a lot because the people who usually have been defamed, the Richard Jewells of the world, can't afford to pay a lawyer. So we do it. We do the work. We work for however long it takes. And there's a set percentage. So you get 30% or 40%. It depends. I mean, when you're suing CNN and the Washington Post and NBC, you're putting in a lot of time, a lot of hours, a lot of money. So it can be 40%, 45%, usually somewhere in that range. And so if the client, if there's a recovery, either through settlement or at trial, and the client gets the money, then you get your percentage, whatever you agreed to up front. And if the client gets nothing, again, you don't eat. That's how that works.
And I know we've heard a lot about the Sandman cases. Was that an hourly case or was that a contingency matter?
No, that was contingency. Nicholas could not have afforded to have lawyers do that on an hourly basis. It would have been outrageous.
And so what was L. Linwood PC hired to do for the Sandman matters in just general terms?
Well, so Todd McMurtry was the local lawyer who knew Nicholas and his family, or somebody knew them. I don't know how they connected exactly, and Todd knew nothing about defamation law. And so he looked around and found Lynn, who was one of the top, if not the top, defamation lawyer in the country. So he brought in Lynn for us to come in and do all of the work, right? Figure out who to sue. You can't just sue everybody who said something about him. You have to figure out who said something that was false and defamatory, and did they say it with actual malice? That means, did they know that it was false when they said it? So, I mean, there were articles and publications and tweets and just everywhere. News broadcasts, there were thousands of them. So we came in to go through all those and to figure out who we were going to go after and who we weren't. I mean, that was initially the premise, and then going forward to write the retraction demands, which I think Drew said could be 10 pages. Some of them were like 50 pages, so because they could be really, really detailed. It depends on which state you were in, but different states have different laws about what you have to demand in a retraction. And so some of them you have to list every single statement that you contest. So some of them would be really, really long. And then we saw who retracted, who didn't. Then you make the decision of whether you're going to sue. And so Todd's firm did none of that. We, of course, L. Linwood PC did that. So that's what we were brought in to do.
And so at that point, when you said you make a decision of who to sue, did you guys ultimately end up suing some news outlets on behalf of Nick Sandman?
Yes, we did.
And which ones were those?
We sued the Washington Post, WAPO, we always refer to it, CNN, and NBC Universal. Those are the first three that we sued.
In the initial drafting of the initial court pleadings, like the complaint, any sort of responses, was Lynn involved in drafting any of those?
Lynn doesn't draft them, he would review them. So those, Taylor actually did the initial work in those and drafted them, figured out, first you have to figure out who you're going to sue. So CNN, okay, well, who owns CNN? Who do you have to sue? Who do you have to serve? It's all very complicated. And so Taylor was the one tasked with figuring all that out. I think NBC Universal was the worst, but so he would draft all of those, and then everybody would review them, and Lynn would review them, woodize them, as he would call it, which was putting his final edits and final touches on them.
And I believe we heard Drew in his opening talk about some sort of work you did in response to a motion to dismiss. And can you tell us about that?
Yes. So the Sandman cases, as with most of these cases, the media entities in particular, they don't just say, oh, sorry, here's a bunch of money. They first file motions and they ask the court to dismiss the cases. And they say this, needs to be just thrown out for all these various reasons. And so you file competing back and forth 30, 40 page briefs with exhibits and explain why they should be pursued or why they shouldn't be pursued. And the court, the judge in the Sandman cases, these three were all filed in federal court in Kentucky. And it was one judge. And he granted the media defendant's motion to dismiss and threw out all the cases. And so I was actually out of town. I know when it was because I was out of town for my birthday. And Lynn called me and said, double down. Anyway, he said, I need you to come back and give me 110%. We got to fix this. We've just gotten thrown out of court. And so I did. I actually came home early from the trip. And then that's what I was working on, because he and Taylor and Jonathan were focused on depositions for the Musk trial. So this was in early August of 2019. And they were going out to LA and he was about to depose Elon Musk at this point in time and some of Elon Musk's top people. So I came back and I hadn't really been working on that a lot. And so I jumped into this and was the one who worked on the briefing. And again, we had to figure out, what were we going to do? Were we going to appeal? Did we file a motion for reconsideration? Did we file a motion to vacate? Was it under this rule, that rule? So there was a lot of work to be done.
Lots of hours put into whatever briefing you were compiling.
Many hours. Lynn asked me at one point if I was sleeping, and I said, yeah, I'm sleeping 3-4 hours maybe a night. Sure.
And what ended up happening with the motion to dismiss in the Sandman cases?
After we filed all of our briefing and the other side filed all their briefing, and then we filed some more briefing, and then they actually, I think, filed even more briefing. The judge scheduled a hearing, and we had a hearing that Todd argued, and Lynn did argue the last, I think it was 5 minutes, but Todd didn't give him much time. But either way, the judge reversed himself and granted our reconsideration on a key issue. And so the case was back. We got back.
And in your experience, during your career, is that common for a judge to reverse him or herself?
No, it is very uncommon.
And did Lynn ever say anything to you guys about how the fees would be split for the Sandman cases?
Yes. So it was for all of these cases. So the billable cases, it was set, right? We had our percentages set. For contingency fee cases, like I said, I didn't really have any contingency fee clients, so they were all Lynn's. And so Lynn would tell us at some point, here's what I'm gonna do. He would, at one point, he got kind of funny about it and sent us an email like, the compensation committee is meeting tonight. And of course, the compensation committee was him. And, let me know your recommendations for what I should give you. And usually at that point, we would get, for a lot of the cases, we would get 45%, he would get 65%. So we would get 15% each of whatever fee the firm got after taking out expenses. Sometimes, and so then he would say, tell me your recommendations. So we would write back 15%. And for one of them, he said, oh, surprise, the compensation committee has decided to give you each 18%. He had not done that yet with the Sandman case when it settled. We just hadn't gotten there. He usually did that late in the case, like Musk. I mean, we did the trial in December and he sent those emails. I don't remember when it was, sometime a couple of months before trial, probably. I mean, it was a formality we were always going to get. He always kept discretion, right? So it would be between 45 and 50%. He was always going to get 50%, which he was the rainmaker. It was his case. That's how it works. And then we were always going to split 45 to 50% with him, assigning, some percentages higher depending on the work. So for Sandman, that hadn't happened yet. So so to get back to the question, which was, did we have that conversation? I had to kind of explain the background. But the answer is yes. I had a conversation with him after we settled it, we then had a hearing with the court, at which point it was only CNN that had been settled at that point. And so we were announcing to the court that we've settled with CNN. Here's what we're going to do because Nicholas is a minor, all that. And so we were in Kentucky. And as we were going to the hearing, I think Jonathan and Taylor rode with Todd or something. In any event, we had all been in the conference room and Lynn and I were in the conference room packing up our stuff to go to court. And Lynn said, I just want to let you know that I'm going to give Taylor the higher percentage. I'm going to give Taylor 20% for CNN because he did more work on getting CNN together. And I'm going to give you and Jonathan each 15%. But when we settle WAPO, if I had to do it right now, my plan is to give you 20% of WAPO and they'll each get 15%. And he said, and candidly, you're probably going to end up better off in that deal because I've committed that I won't settle any of the other cases for less than what I settled CNN for. And I said, that's fair. I'm okay, great. Thank you for letting me know. That's fair.
So similar to past contingency cases, there was Lynn telling you guys what your fee split would be between the folks at the firm.
Yes, but it was always in that 15 to 20, right? We always got between 45 and 50%, and he got between 50 and 55%.
And when you were just speaking about Lynn's clients versus your clients, is that any sort of, when you say Lynn's clients or your clients, do you mean that they were clients of a different law firm? Or what do you mean by that?
No, it's just a question of who brings in the business. And particularly, well, I think in both big and small firms. I mean, if the person calls you and hires you, they're hiring the law firm, but you're the relationship partner, as they would call it, right? You're the one who has the relationship and who primarily oversees the work. So for my clients, the people who hired me, my name was the first under the signature block, but the signature block was still LNYPC. They were firm clients. I was the partner responsible for bringing them to the firm.
And so in addition to the partner responsible for bringing the clients into the firm, were you the partner responsible for the management of those clients as well?
Yes. I mean, I would consult with Lynn even on stuff from my clients because they were firm clients and he was in charge of the firm, but yes,
but all still clients of Ellenwood PC.
right, yes.
And around the time that Sandman settled, and in early 2020, was anything else going on at Ellenwood PC at that time?
Well, we had just lost the Musk case in spectacular fashion, and there was a lot of heartache over that. That was a big loss. We had been working really hard on that, and like I said, we had all been working pretty much on those two contingency fee cases, and so nobody was making money. We weren't making any money. So yeah, I mean, everybody was not happy.
And at some point in early 2020, was there a discussion about changing the name of the firm?
I wouldn't say there was a discussion so much as Lynn decided to change the firm name.
And what did Lynn decide at that time to change the firm name to?
Lynn called me one night and said, "Hey, I'm changing the firm name." I said, "Okay." He said, "It's going to be Wood, Wilson, Grunberg, and Wade." And I said, "Okay."
And is that how decisions were typically made at Ellenwood PC? He would just tell you guys what he decided?
Yeah, I mean, I think he would frequently solicit input, but yes, I mean, at the end of the day, all the decisions were his, and a lot of times he would just tell us.
And I'll point you to Plaintiff's Exhibit 25. Can you take a moment to look at that and tell me if you're familiar with it?
Yes, I'm familiar with this.
And did you receive a copy of this document?
I did, yes.
And did you receive a copy of it at or around the time that it was sent?
Yes, I was a recipient of each of these emails and saw them at the time.
Your Honor, at this time, I'd like to move to have Plaintiff's Exhibit 25 entered into evidence.
Any objection to 25?
Three pages, Alan.
Mhm.
No objection, Your Honor.
25 is admitted.
Thank you, Your Honor. Nicole, is what you were just testifying about Lynn changing the name of the firm to WWGW, if you will, for the initials. Is that what this email thread's about in Plaintiff's Exhibit 25 generally?
Yes, exactly.
Okay. And point, can we zoom in, Michael, on that for that first email where it says one last comment? Yep. Thank you. Okay, so this first portion is an email from Lynn. It says, one last comment, everybody is free to tell anybody now about the new firm. The firm has existed for several years, but has been presented to the public and clients in disguise. First, did I read that right?
Yes, I think you said everybody and it says everyone, but otherwise, yes.
Thank you for the Freudian slip correction. Everyone is free. What did you think when you read this portion of the email that says the firm has existed for several years but has been presented to the public and clients in disguise? What did that mean to you?
I mean, nothing was supposed to change about what we were all doing. And so ever since Jonathan and Taylor made partner in 2018, I mean, he was just saying that's what we've all been partners. Now I'm just putting everyone's name on the door, right? That was it was intended to be a boon for everybody. Now your name's on the door, but it was still the four of us partners in the firm.
And so it was going to be the same folks working at the firm.
Correct.
Same website.
Correct.
Same address for the firm.
Yes.
Same email domains.
Yes.
Same business cards.
Well, no, the business cards changed because he put the new firm name. I mean, they looked identical otherwise from the new firm name, but
Your contact information on the business card was still the same from Ellen.
correct.
So were you guys paid the same? Like we went over before?
Yeah, there was no change in compensation structure or no change in responsibilities or anything like that.
And what about expenses? Were you guys still splitting expenses, 1/4 each every month?
Yes, that was all the same,
And what about the way you handle cases? Was that all the same?
all the same.
What about staff? Did anybody new come on?
Nope, all the same.
Okay, and what about the firm photos that we've seen? Did anything change with those?
We never had new photos. That was the same.
So it's safe to say it was purely a name change.
Correct.
And moving forward to the February 2020 time period, what happened around, Valentine's Day in 2020?
So Lynn was going to come to the office. Lynn had not been in the office since the Musk trial. We had each had varying communications with him. We decided that we did not want to be in the office when Lynn came to the office. We were supposed to have lunch in the conference room. I think Kimmy had ordered sandwiches. And instead, we all left. And Taylor left first, and then the four of us, Jonathan, Kimmy, Chelsea, and I, left and went to lunch.
Okay. And did Lynn respond to you guys in any sort of way on Valentine's Day of that year?
Yes, you mean after that? So then after we went to lunch and Jonathan texted Lynn that, we're at lunch, we'll call you when we're done. And Lynn had been calling us and where are you? That sort of a thing. And so we called Lynn after, and then we had a conversation. And then after that, he had security change the doors, change the locks on the doors at the office, and sent us an email about the Valentine's Day massacre. Sorry, I may be going far afield.
It's okay. Well, I'll point
There was
you
a
to-
lot. Sorry.
I'll point you to Plaintiff's Exhibit 75 and 77. If you'll take a look at those and tell me if you're familiar with those.
'75 and '77.
Yes.
Yes.
And I'll take these one at a time. Is Plaintiff's Exhibit 75 a true and accurate copy of a text message you received?
Yes.
And is Plaintiff's Exhibit 77 a true and accurate copy of an email you received?
Yes.
And were both of these received at or around the time that they were sent?
Yes.
Your Honor, at this time, I'd like to move to have Plaintiff's Exhibits 75 and 77 admitted into evidence.
Any objection to 75 or 77?
Your Honor, no, except and I think this is just a mistake. On 75, it appears to be a text message from someone's, I guess, iPhone. Up above it is some sort of a YouTube thing about QI inductive wireless chargers. I think that may just have been added inadvertently from when they copied the text. And if that's the case, then I'd ask that that be removed. But otherwise, it's both exhibits are no objection.
All right, counsel, is there any reason you can't redact whatever that extra stuff is before it's at some point before it's made part of the record?
I mean, we can, Your Honor, but it's a text thread, so it's what came immediately before on the text thread. And I can lay foundation with the witness for that portion of the text thread if needed.
If I might suggest, all we gotta do is take this exhibit and black that charger part off.
Is the charger part relevant to this in
No,
any way?
no, you're not.
Then let's just keep it confined to the aspects of it that matter. So 75 and 77 are admitted without objection. 75, there'll be a redaction.
Okay. And Michael, can you zoom in on the text from? Thank you. Okay, so I believe, Nicole, you mentioned some sort of Valentine's Day massacre message. Is this what you were referring to?
Yes.
And
He sent it in this text and he said it in an email at some point as well.
and how did this make you feel at the time when you received it in February of 2020?
You know, pretty awful. I mean, it was nothing that was going on right then was good or where I wanted to be.
And what did you perceive or understand this to mean about Valentine's Day massacre?
Well, it was Valentine's Day. There was the Valentine's Day Massacre is a well-known event that took place, I think, in Chicago in the 20s or 30s or something with the gangsters, and a bunch of them got shot and killed. I think they showed up and killed everybody. And in another one, somewhere he says, 7 died that day, many more will die from mine. It was not a pleasant comparison.
And I believe you also testified that at some point he told the office building to lock you guys out of the office after y'all had left for the day.
Yes, once we told him that we needed some change or we needed to leave, and we had left, and he said, you have 45 minutes to get your stuff. The building security is going to come escort you out and change the locks on the doors at 5:00 p.m.
And is that what is depicted in the email on Plaintiff's Exhibit 77?
Yes. He had told Kimmy to do it, and then he did it.
And if we can zoom in on those first couple paragraphs, Michael.
I'm sorry, he said 5:05 p.m. that security would come. And they did.
And so this email was sent at 4:20 in the afternoon, and he locked you guys out approximately 45 minutes later.
Yes.
And all of your professional belongings were in this office, is that right?
Yes, we went back down to the office and took personal stuff. There wasn't a lot of time. So I grabbed at that point. Previously, my computer was provided by him, but then I decided I wanted a Mac. I preferred the Mac, so I got my computer. pictures, just some very personal things, but all of my work stuff, all of my files, all of my everything else were still there in my office.
And can you look over to plaintiff's exhibit 87 and tell us if you're familiar with that?
87?
Yes.
Yes, I am familiar with this one.
And is this a true and accurate copy of this email thread?
Yeah, yes, it is. This one was the next day.
And at this time, Your Honor, I'd like to move to have plaintiff's exhibit 87 admitted into evidence.
Any objection to exhibit 87?
I'm sorry.
Do you
Y'all
have,
waiting on me for something?
yeah, he asked
Any
you.
objection to 87? 87.
I do, with respect to the two emails on page 1. They're fine. I mean, I have no objection. But then it picks up another email on 22nd, 2/15/20 at 10:44 a.m. And that's not the same thread. Because the emails above that are just between Chelsea Gray and myself. And here, all of a sudden, they've tagged on here. I'm clearly talking to more than Chelsea is what I'm saying. So that's the 87 with the top two emails that I can identify are fine. The other one doesn't tell us who it's to and what time it was, well, who it was to. It makes reference to me talking to Taylor. I think games are over, Taylor, et cetera. So it's not part of the Chelsea Lynn email chain, so it needs to be redacted. And then it can be tendered in separately if they've got that, if they want it in.
I'll lay some additional foundation, Your Honor.
Okay.
Nicole, the first two emails on plaintiff's exhibit 87, were you a recipient of those emails?
I was a recipient of every email in this whole chain. It just, the way it was printed, it happens to be printed in an abbreviated fashion.
Okay.
But all of us, Jonathan, Taylor, Kimmy, Chelsea, me, we were all on all these emails.
Okay. And if you go to the back and work your way forward, is that how the emails appear based on the date and time stamps in terms of chronological purposes?
Yes, what I refer to as, sorry, but damn dumb motherfucker's email was sent at 3:45 a.m. on the 15th. It was in the middle of the night after Valentine's Day. So that's what I woke up to. Yeah.
And you received a copy of the emails on this email thread?
Yes.
Your Honor, I'd like to renew my admission.
All right. I think from here, any objections to authenticity go to its weight, not its admissibility, so I'll overrule the objection. You can proceed.
Didn't make it,
Thank you, Your Honor.
I'm sorry?
started. Do I have an objection?
Are you I assumed you were renewing it. Are you renewing your objection to 87?
I haven't renewed it. I just wanted to make sure that it was clear, but I'm fine with it.
All right, then 87 is admitted without objection. Next
Thank you, Your
question.
Honor. Michael, if we can start on page 3 of plaintiff's exhibit 87 and zoom in on the "you damn dumb motherfuckers" part and those first couple of that whole rest of the page, please. Thank you. Okay. So Nicole, this is an email that Lynn wrote to you guys and that you received, and I think you said it was at 3:45 in the morning on February 15th of 2020. Is that right?
Correct.
Okay. And it starts, "you damn dumb motherfuckers," and it goes on. And I'm not going to read this entire email because it is 3.5 pages long just from this one email. But briefly, in the first couple of paragraphs, he is accusing you guys of some sort of federal, or what is he accusing you guys of in general terms?
As far as I could tell, he was accusing us of having taken something from the firm website, taken files, something in the time frame that he had given us to go back and get our stuff. Of course, it was just not true. It was hard to know exactly what he was talking about. I don't know what the bank fraud possibly could be. Obviously, we had not committed any federal crimes, but my understanding of what he was talking about, and based on other things he said, was that he believed that we had done something with his files and some of his older case files.
And was any of the accusations in this email true?
I'd have to read the whole email, but I'm pretty sure
let
the
me
answer is
rephrase.
no.
Let me rephrase.
Pretty sure there's nothing in here that's true.
In these first couple of paragraphs, what you were talking about the federal crimes, this allegation about client files or computer hacking and bank fraud, was any of that true?
None of that was true. There was no truth at all to any of it.
And can you read into evidence the paragraph that starts, "you fucked with the wrong guy," and go through "you will lose" at the bottom of the page?
You fucked with the wrong guy. You fucked with Linwood. Bad fucking choice. Here are the findings of your final judgment day on Earth for today, the day after my Valentine's Day massacre. Taylor, you're not going to get one thin dime from me on any case. That includes Carboni and Sandman. Sue me. You will lose. You can tell your co-conspirators, Nicole, Jonathan, Kimmy, and Chelsea, all the damn criminal conspirators who, it says wars, but he sometimes would dictate these things, so I don't know, who deleted emails and Word documents related to the DeVita and Halifax cases are in fucking serious criminal and civil exposure. Did you really think that an expert could not determine when those files were deleted, by whom, when, and any efforts to now destroy them? You are all dumb as hell. I am not.
We can stop there because this goes on. When you received this email, how did this make you feel?
I don't even know how to describe how I felt when I got this email. I don't even know. It was surreal. It's still surreal to me that Lynn would say these things.
And if we go on to the next page, actually, I think that's the page you just ended on. He says, a couple lines down, "Nobody fucks with me and my children." And then on the next page, he says, "Buckle up your damn seatbelts unless I change my mind under the instructions of God. You are in for the roughest ride of your lives. I'm going to teach you all a lesson that you are going to learn. Here's the lesson. Never try to interfere with any father's relationship with his children and vice versa. Never means never, always has, always shall." In regards to these references to his children, did you have you taken any steps to interfere with his relationship with his children at all?
No,
Did you ever speak to Lynn's children about his mental health?
no,
Did you ever threaten Lynn at any point in regards to his children or his relationship with his children?
no.
Uh,
And I will change my last answer. I just want to be clear. Matt Wood did text me one time and asked me if I would be available for a meeting. And I said, yes, let me know. But that was it. I never talked to him. There was just a text. I just want to make sure.
John, I don't have that document produced.
Well, we
Text.
there's no objection.
can take that up at the next break. Mr. Wood, she's not tendering it.
Thank you,
Well,
Nicole.
I'd like to see it.
All right, you can proceed. Ask your next question.
So you just to understand, this message from Matt Wood, which is Lynn's son, was unsolicited.
Correct.
Okay. And you responded saying you would be there in support if needed.
Sure. I said, yeah, sure. Let me know what you need from me.
Did anything ever happen with that?
No.
And going on to the next page, which is Bates stamp 223, Michael. In the center where it says PS Taylor, can we highlight that? In this little PS to Taylor only, it looks like Lynn writes, they will never get a dime from me. I dare you to sue me for it. You don't have the balls to do it. And if you do it, you shall lose. And in the process, lose more of your damn asses. If there's anything left of your asses after I finish with your asses tomorrow, if you don't call my children and beg for my mercy, like the damn dogs begging for a damn piece of meat after not eating for 3 months, I think my message is clear. And it goes on. When you read these words that he was saying to all of you guys, and making statements about there not being anything left of your ass after he gets done with you guys, how did that make you feel at this time?
I mean, obviously we did not, I did not appreciate being threatened by Lynn like that. I took it seriously and I didn't know what Lynn was going to do. I didn't know.
And this was on February 17th or February 15th, and I think this thread goes on. At some point after this, in the next few days, did you guys end up speaking with Lynn?
Yes, we did.
And when was that? And I'll point you to Plaintiff's Exhibit 94 if that'll refresh your recollection.
Yeah, Taylor had a couple of had a conversation. I don't know how many. Taylor talked to Lynn at some point. I didn't talk to Lynn until the night of February 17th, which is a Monday. I just started trying to get my stuff together and so that I could continue to represent clients. And so Taylor called me and said, Lynn wants to have a phone call. And so I said, okay, let's get on the phone. And he wanted to have a call to discuss the outstanding cases and what the fee splits were going to be and who was going to do what and how everything was going to be wrapped up.
And did you guys ultimately end up coming to an agreement on the cases in this February 17th call that you're referring to?
Yes, we did.
Okay. And have you had an opportunity to look at Plaintiff's Exhibit 94?
Yes. I know it
Are
well.
you familiar with this document?
Yes.
And did you receive a copy of this email thread at or around the time the emails in here were sent?
Yes.
Your Honor, at this time, I'd like to move to have plaintiff's exhibit 94 entered into evidence.
Any objection to the email chain and exhibits 94, or exhibit 94 rather?
I'm sorry, but there's like 4 or 5 emails here, so I have to look through it. No objection, Your Honor.
97 or 94
94.
is admitted.
Thank you, Your Honor. Okay, and so the plaintiff's exhibit 94, was this before or after you guys had the conversation with Lynn on the 17th?
This was after.
Okay, and what is plaintiff's exhibit 94?
So it's an email chain
And on this first 2 pages?
on the first 2 pages is the email that Taylor sent. The 3 of us put it together, and then we had Taylor send it because we felt like Taylor was the one Lynn was the least angry at, and so it would be best coming from him. So it was summarizing the discussion that we had had and what the fee splits were going to be in these various cases that we had worked on together.
And did you guys on February 17th come to an agreement on all of the outstanding cases at the firm?
Not all of them, but most of them. Everything that had settled or that we was about to settle, or sometimes settlements happen, but then it takes a minute to get the money, that sort of thing. But yes, this is most of them, the key ones that were resolved at any event.
So the cases that fees were outstanding or would be coming in shortly, you guys came to an agreement on those?
Yes.
And are the salmon matters included in this February 17th agreement?
The CNN one is, the CNN, that one had already settled. Like I said, we had settled in January. That's when the hearing took place that I was talking about. And so it had settled, and he already knew what he was going to pay us for that one. We didn't in this one discuss the other 2, WAPO or NBC.
And did you ever pressure Lynn in any way to enter into this February 17th agreement?
No, not at all.
Did you ever threaten him in any way to enter into this February 17th agreement?
Not at all.
Did you make any threat towards him in regards to his children to enter into this February 17th agreement?
None at all.
So at this point, you guys had come to an agreement on the 17th to resolve everything and separate the business. Did everything go smoothly after that?
No.
What happened next?
Lynn, at some point first he responded and said, yes, this is great, blah, blah. Then at some point, 3 a.m., he sent an email and said, hey, I think everybody should come back up to the office and let's all keep working together again. And everything will be great. And we said, yeah, no, we're done. We're done. And after that, it went to hell in a handbasket.
And at that point, did you guys hire counsel to help out?
Yes, after that, he told us we'd better hire a lawyer, told us we should hire a criminal lawyer. We hired you and Drew.
And at some point, did Lynn hire counsel?
He did, yes, very shortly after that.
Right. And then Actually, take a look at, before we move on, Plaintiff's Exhibit 101 and tell me if you're familiar with that.
Yes, I am.
And is this a true and accurate copy of the email and the attachment as it is, as it appears here in Plaintiff's Exhibit 101?
Yes,
And although you are not a recipient on it, did you receive a copy of it shortly after it was received by Drew?
I did. Drew sent it to the three of us, Jonathan, Taylor, and me, as soon as he received it from Joey and Chris.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 101 admitted to evidence.
Is that 101?
Yes.
Any objection to 101?
No, Your Honor.
All right, 101 is submitted.
Thank you, Your Honor. Nicole, so between the time period of Plaintiff's Exhibit 94, which was the February 17th agreement email thread we just looked at, and this Exhibit 101 that we're looking at now that was sent on March 13th, was there any other negotiations during this time period?
No.
And this email from, is this an email? Who is this email from?
This is from Chris Marquardt, who was Lynn's lawyer at Austin and Byrd. Because at that point, he had hired them, we had hired you guys, so his lawyers were communicating with Drew and you.
And this term sheet and this offer, if you will, that's set out in here, that Chris sent over, was this solicited by you or anybody on your behalf?
No, I mean, I think that Drew and Chris and Joey had a couple of communications. Lynn had said something at one point about, well, I'll give you all my office furniture. And then we get this on Friday afternoon.
Okay. And if we zoom into the paragraph, Michael, that says Lynn also instructed us. It says Lynn also instructed us to make clear that this offer will expire at 5 p.m. tomorrow. Open paren, Saturday, March 14th, close paren, if not accepted by your clients by that time. And it goes on. So when this came in on Friday, the 13th at 4:40, it gave you guys 24 hours and 20 minutes to be exact, to either take it or leave it.
Correct.
Right. And we don't need to go into the specifics, but going to page 3 of this exhibit, the term sheet, was this essentially the same deal that you guys had already agreed to on February 17th that was being offered here in general terms?
Yes, except that this included the WAPO case and NBC, and this also had a provision for us, for Lynn to subtract what he was going to pay us, $285,000 towards the lease.
But otherwise, on all the cases that you guys agreed upon in the February 17th Exhibit 94 email that we saw, those were all the same, just a couple more.
Correct. It added some things, but it adopted specifically all the ones that we had agreed to on the 17th. I mean, those had already been agreed to. There was no huge, that was not a huge surprise. Those were the amounts we expected to receive before everything blew up. So.
And did you guys ultimately finalize the term sheet that we're looking at in 101 into a full agreement, if you will, that was signed?
We did. We signed this by 5 o'clock on Saturday, and then we signed a settlement agreement based on this term sheet like a couple of days later.
And I'll point you to take a look at Plaintiff's Exhibit 102.
Yes, this is the settlement agreement that we signed.
And is this a true and accurate copy of the March 17th settlement agreement?
Yes, it is.
Your Honor, at this point, I'd like to move to have plaintiff's exhibit 102 admitted into evidence.
Any objection to 102?
Wide screen is making. Yeah, so making.
That's fine. I'm waiting on defense objection to 102.
No objection, Your Honor.
102 is admitted.
Okay, so this was the finalized agreement that you guys favored and eventually executed. If we look at pages 6 and 7, these are everyone's signatures. Is that right?
Correct.
Okay. And when was the March 17th agreement signed and delivered?
We, I don't know where Lynn was when he signed it, but Jonathan and Taylor and I went over to the building where we had, our office was, Ellenwood PC, and we met Joey in the lobby and at about 6 PM, and we all signed it right there. We were waiting, we were going back, we needed to get our, we hadn't been able to get our stuff out of the office. And so that's why we met there, because we could only access the office to get our files and our things after we signed this.
And so you personally delivered it to Lynn's attorneys?
Yes, he watched us sign it.
And did you ever pressure Lynn to enter into this March 17th agreement that we're looking at here on plaintiff's exhibit 102?
To the contrary, we did not.
Did you ever threaten him in any way to enter into this March 17th settlement agreement?
No,
Did you ever make any threats or statements in regards to his children in the context of this March 17th agreement negotiations or anything like that?
no,
And during this time period, did you do anything to interfere with Lynn's relationship with his children?
no. Not during this time or any other time.
Thank you. And I think we heard in Lynn's opening some comments about Richard Jewell. Just to wrap this up real quickly, did you ever make any statements to anyone about Richard Jewell during this time that would have gotten back to the president or impacted whether Richard Jewell received a presidential Medal of Freedom?
No, at least not in a negative way. Lynn had asked me to, he had put together a video that he put on Twitter, and I retweeted that, his post. I mean, I had like 10 followers, so I don't know that that's not going to get back to anybody, but I mean, I retweeted that. That was the only thing that I ever did or said. I would not have tried in any way to limit that.
And so just to be clear, you retweeted something that the defendant posted about Richard Jewell during this time?
Yes,
And was that done in support of Richard Jewell?
yes,
And after the March 17th agreement was signed, are you aware of any referrals that Lynn sent to your new law firm?
yes.
And your new law firm, we're going to hear about it a lot throughout this trial. What's the name of it?
Wade, Grunberg, and Wilson.
Okay.
WGW.
WGW. So if we refer to WGW throughout this trial, we're referring to the law firm of Wade, Grunberg, and Wilson. Is that safe to say?
Yes, it's just easier.
It is easier with the with the abbreviation. And so going back to these referrals that Lynn sent you guys, are these potential clients that believe that they may have some sort of case?
Yeah, these are people that call called Lynn or emailed Lynn. I mean, they go on Google, Lynn's name pops up, and so they reach out to him. And so I don't know that he vetted any of them, but he sent them to us. And so we vetted them and talked to the people and did some research. They were from different states and whatever, and some of them had no case at all. And some of them we thought might have some merit. So, we took a couple of them. Most of them, there was nothing there. We did the follow-up work, but there was nothing to do.
So
most calls and emails and stuff we get, there's nothing you can do. It's not defamation legally. It's not defamation. Somebody may want to sue, they may be unhappy, but usually there's nothing you can do.
But in these cases where the potential client, if you will, who thinks that they have a case, you still have to review their information.
Sure.
You still have to talk to them sometimes to give them your evaluation.
Sure.
Sometimes you still have to do legal research depending on what jurisdiction they're in to see if they have an actual claim or not.
Correct. There's different time periods in different states when you have to file the claims. There's different people who could be liable in different states. So yes, if they're outside of Georgia, I mean, some of them we know because we had done a lot of work in, but yes, a lot of times we had to go do research.
And is all of this legwork to determine whether WGW is going to take on a new client or not? Do you guys get paid for that? Did you guys get paid for any of this?
No, we don't get paid for that.
And I believe you said you took a couple of the cases.
We did.
That Lynn sent over to you guys. And are referrals, this kind of lawyer to lawyer referral, is that common in the legal field?
Sure. Yes.
So do you send potential clients to someone else when you can't help them or don't
Sure.
practice in that area?
Sure. All the time. It's common. Either you don't focus on it or you don't have time for it or whatever the case may be. I mean, you try not to send over really bad cases, although it depends on what you think about the other lawyer. But I mean, yeah, we refer cases all the time.
And moving back to the settlement agreement and the March 17th time period, was the money that was owed under the settlement agreement that we looked at in Plaintiff's Exhibit 102, was it due to you guys immediately?
No.
When was it due?
It was due when the Sandman versus CNN money came in because we were in the process of getting that settlement approved again because Nicholas was a minor. And so that process was going on and the money was expected to be in there shortly. And so that was the 285,000 for the lease was going to come out of that. That was the pot of money. The other stuff wasn't big enough to cover that. So the plan was when that came in, Lynn would subtract the 285 from that, combine that with the two other smaller cases and give us that amount.
And did that ultimately happen with the Sandman probate court approving his settlement? Did anything happen during that time period?
Yeah, that whole process, they derailed that whole process and they didn't end up getting it approved while Nick was still a minor. Instead, they ended up agreeing with CNN that they would wait until Nicholas turned 18 in July 24th.
And I believe we heard during openings about some hearing in regards to the Sandman settlement approval or something getting postponed because of COVID. Are you familiar with anything in regards to that?
Yes. So before we left the firm on February 14th, we and Taylor had done the initial draft of it, had drafted the settlement agreement and had drafted the paperwork to be filed in probate court for Nicholas's mother to be appointed his conservator, which just means she's the one who's in charge of the money for him. And when you do it that way, you have to get approval from the court because the court's overseeing it to make sure that the money is properly handled. So there were a couple of steps that had to take place. The first step was to get Julie Sandman, Nicholas's mother, approved as his conservator. And so there was a hearing scheduled for that. And then after that, we would take that to the district court judge and he would sign off on it. Then the probate court would sign off on it and then the money would change hands.
In that first step, the appointment of Nick Salmon's mother as his conservator to start this settlement approval process with the court, did that go forward?
It did, although it was delayed. Initially, it was delayed because of COVID. We learned that the night we signed the settlement agreement. Lynn told us that. This March 17th, 2020 was kind of the day everything shut down for a while.
Is March 17th the day that Lynn found out that the hearing in Salmon would be postponed?
No, Lynn found that out earlier. Todd had emailed him March 15th and told him that the settlement would be postponed. This damn virus is causing trouble, he said.
And I believe you said it was postponed, but it ultimately happened. When did you learn about that?
That it had happened only after all of this litigation started, and I went and looked at the probate court records and saw that Julie had in fact been appointed conservator on April 15th of 2020. Although Lynn had emailed us on April 16th and said, we don't know when the probate court's going to be able to set a hearing. And she had already been appointed. They agreed with CNN to put it off.
And so when you say they agreed with CNN to put it off, what did that mean in terms of when the settlement, the Salmon settlement money would be paid to Nick Salmon or his parents?
It meant that instead of it getting paid at the end of March, as we had expected and certainly anticipated when we signed this agreement, that it wouldn't be paid until the end of July because Nick turned 18 on July 24th, 2020.
Okay, so then in July, on July 24th, 2020, or shortly thereafter, when Nick Salmon got his money because he's now an adult, did you guys get the money you guys were due under the March 17th settlement agreement?
We did not.
What did you get instead?
He got a letter from Lynn's lawyer saying, gee, sorry, we're not going to pay you. Give us your time records for what you kept on the Sandman case, on the CNN case. He said that the Washington Post case was still outstanding, although that wasn't true. We learned from Nicholas had tweeted that day that he had settled, happy birthday to me, I settled with the Washington Post. That was how we heard about that. And we got that letter and no payment. So here we are.
And what was the main reason that they gave for not paying you guys what was owed under the settlement agreement in that July letter?
They said that we had not been lawyers at Ellenwood PC, and we were not lawyers of the firm, and therefore we needed Nicholas's consent.
How did that make you feel to hear Lynn and his attorneys claiming that you guys were not lawyers at Ellenwood PC?
I still have trouble believing that he's saying that. It's insane. Of course we were lawyers. We worked for the firm. I mean, it's crazy. It's still crazy to me. I can't believe he's standing up here and saying it. It's ridiculous.
Besides not paying you guys the money that was owed under the March 17th settlement agreement that you entered into, in your opinion, did Lynn do anything else that breached the settlement agreement in the July or August 2020 time period?
Yes. Lynn immediately started disparaging us. And one of the things about the settlement agreement was that he had agreed that he would not disparage us, and he had been saying bad things about us. For example, the form he submitted online to the FBI and various other lawyers, he was saying all kinds of awful things about us. And he then started saying awful things about us again. And he emailed Dexter King and said, you know, I hate to bring you into this, but there's some things you need to know about Nicole, and she's a crook and all this terrible stuff.
Well, and I'll point you to look at Plaintiff's Exhibit 104.
Yes, this is the email.
Is this a true and accurate copy of this email thread?
Yes, it is.
Okay, and did you receive a copy of it at or around the time that these emails were sent?
Yes. Can we only put up page one
yep.
of that?
That's all I'm gonna ask you about. At this point, Your Honor, I'd like to move to have Plaintiff's Exhibit 104 admitted into evidence.
Page one.
We have the redacted version to enter in.
Okay.
However, it needs to be put up in its entirety, page 1 and 2.
Well,
All right. If counsel want to approach.
May we approach? Thank you.
If you would want the entire email thread to come in, there is some return.
So
Yeah, so only that.
if they just,
paragraph would be redacted.
the whole paragraph will amount. Redact the whole paragraph.
We can, that's housekeeping.
Yeah. They're
I
trying
would
to check
have
them
to.
out. It's up to
I would have to
Dexter.
look at the rest of it, but.
Yeah, but it's going to put it in the.
It's gonna-
look at it,
Yes.
like that, just the amount of the other bill they had.
All right, so for the record, 104 is admitted as an entirety. They'll be subject to an agreed upon redaction
Thank
to
you,
be
Your Honor.
supplemented by the plaintiffs later.
All right. And Michael, can you highlight this first page? Yep, the first.
can we address that after when we have a break? I have a client issue I'd like to raise. Thank you.
Okay, so I think you were just saying that Lynn reached out to Dexter King. Is that the email that we're looking at here on page 1 of Plaintiff's Exhibit 104?
Yes, it is.
And in here, he just, what is he saying and what is he accusing you of to one of your clients?
Excuse me, Your Honor, this is the same problem. She's trying to get Nicole to summarize the email. The email is in evidence. The jury can see what it says, or she can read what it says, but it's not proper for her to sit there and summarize an email. She may leave part out, mischaracterize it. It is what it is, just the email's in evidence. We don't need her self-serving or potentially inaccurate summary.
All right, well, the manner of presentation in that regard, I'm going to leave to the plaintiff's discretion and spare us from having to read it verbatim. And if there's anything that's mischaracterized, you can take it up on cross and the jury can make that distinction.
I never can hear you when you're talking.
I'm just probably mumbling is the problem. So to the extent that there's a objection to the manner of the presentation, I'm going to allow the plaintiffs to present their evidence the way they see fit. If there's a mischaracterization, you can follow up on cross. And rather than having to read it verbatim, they can generally summarize it from there. So objections noted, but overruled. You can ask the next question. Yes, sir.
If this were her email, then I think her lawyer would be able to say, can you give us the substance of what you were telling Mr. King? And she could summarize it. But this is not her email. Email I wrote to Dexter King, who was at the time also my client. And now she wants her to summarize my email. That's a big difference. And I think it's improper. Potentially confuse the jury. Just let them see what I said.
All right. Well, they have that in evidence. They can do with it what they want. You can do with it what you want. If it's on 403 grounds, I don't find that's a confusing presentation. I'll let them proceed. You can proceed.
Thank you, Your Honor. Nicole, you can go ahead if you remember the question, or I can.
I'm not sure what the question was. I'm sorry.
No, it's okay. I have forgotten at this point too. So we're saying that Plaintiff's Exhibit 104 is an email that Defendant Wood sent to your client Dexter King. Is that right?
Yes, and Glenn says that he was his client as well, and that's because he was my client. Lynn had left. We had both represented the King estate when we were at Bryan Cave. It was brought in by another partner at the firm. It wasn't either of our clients originally. Lynn left the firm. When Dexter had more issues, he hired me. I was still at Bryan Cave. He hired me. When I left Bryan Cave and went over to LM with PC, Dexter came with me. So he became a firm client. I mean, because all of my clients were firm clients, but that's why Lynn says he was his client.
But you were responsible for the King estate.
Correct. Lynn was not on the pleadings in the cases. Lynn was not involved, but that's always the position. Every client was Lynn's client because they were all firm clients and his name was on the door.
Okay, and I'm just going to read parts of this into the record. Lynn says in paragraph 3, I intend to expose Nicole and her partners publicly. They are putting their greed and personal interests ahead of the interests of their clients, including you. I have patiently worked with you on your bill. Nicole's efforts to extort money from me will bring my patience to an abrupt halt. Goes on to say, I will not be extorted, especially not by crooks. I have never cheated anybody out of a dime in my adult life. As a person and as a lawyer, you know my reputation, you know my integrity. Did I read that correctly?
Yes.
How did it make you feel to have your former partner accuse you of extorting him to a client in an email like this?
It was again, it was unthinkable. I mean, Dexter was an amazing person. And I mean, he was more than a client. He was a friend. He was just an amazing person. And for Lynn to say these things about me to him was just, it was awful. It was absolutely just awful. When I saw this, I just sat there. I couldn't believe he was doing this.
And just to be clear, did you guys ever try to extort Lynn at any point?
No, Lynn was trying to extort Dexter, but I never extorted Lynn. We never extorted Lynn.
So at this point, you guys had received the letter from Lynn and his attorney saying we're not going to pay. He was reaching out to your clients in August of 2020. What happened next? What did you guys do?
We filed a lawsuit.
And did Lynn know that you guys would be filing a lawsuit?
Yes, we sent it to him. Drew sent it to his lawyers. We didn't want to sue Lynn. We just wanted Lynn to pay us. But it was too much money. We just couldn't let it go. We filed a lawsuit. So we sent it to him hoping he would just pay us and we could all go on with the rest of our lives, and he would not.
And has Defendant Wood done anything else, in your opinion, that breached the settlement agreement since you guys filed the complaint in late August, early September of 2020?
Well, we've learned a lot of things since then. So I don't know. we've learned a lot of things. I mean, I knew as soon as we got the letter on the 24th that Lynn had been planning it all along, because for him to say we weren't lawyers of the firm was crazy. For him to ask for time records when he knew that we didn't keep them was, it was clearly part of a plan. So, I mean, I knew then that the whole thing was planned.
And what about, in terms of any other disparaging, what you believe to be disparaging statements? Were there any other made by Lynn?
Yes, there were countless. I literally, I have no idea. He went on first Twitter and then Parler and then Telegram and posted.
Yes, sir.
Since the whole problem where somebody created attacks on them online. I haven't been on Twitter since January of 2021. I know what she's talking about, and she's trying to blame me for something somebody else did that I have no idea who they are, and neither does she. That's the exact issue we had in the you-know-what.
All right.
If it's going to come up now, I would like to address it outside the presence of the jury.
No, I understand the basis of your objection, and I think that it can be clarified exactly what post she's talking about and whether they are forwarded or retweets or reposts or whatever. I don't see,
To be something that I said,
and I don't,
some unknown user handle.
and I don't think we've heard any indication that that's what she's referring to yet.
Do it before. That's
All right, you can continue.
Jumped up. I don't want to see that misconception in front of this jury.
You can continue, plaintiff.
Thank you, Your Honor. So Nicole, I believe you were saying that Lynn posted some comments about you guys on Twitter and Parler, and then I think you mentioned Telegram. Is that right?
Yes.
What can you explain what Telegram is for those who aren't as familiar with that?
Yes, as Lynn just said, he got kicked off of Twitter and then he got kicked off of Parler. And so then he started posting on Telegram, which I had never heard of before he started posting there. But it's just another website where, I mean, I guess it's not a website. I don't know what you call it. It's just where you go online. It's like a Twitter. You go on and post things, except on Telegram, you have a channel. Like it's kind of more like Instagram, I think, in that sense. Like Instagram, you have sort of a page, or Facebook. Telegram, you can have a channel and people, you can post things and then you can either have replies or not have replies. But he has a channel on Telegram. He actually has two where he posts things.
Okay. At this point, I'd like you to take a look at a couple of exhibits so then we can just kind of talk about all of them at once. If you'll take a look at plaintiff's exhibit 194.
Yes.
Are you familiar with plaintiff's exhibit 194?
Yes.
And what is page 1 of 194?
It's a post that Lynn made, and I think this one was on Twitter.
And what about page 2? Is that
Page-
also from Twitter?
Page 2 was on Parler.
And are these true and accurate screenshots of posts that defendant would made?
Yes, I think the second one, it has the URL in there. I think it also had the picture when it was online, but yes, this is what he posted. Yes.
And if you'll take a look at, or we admit these into evidence and go into them. 227, 234.
Sorry. What was the next one?
227.
That was after 194.
Mm-hmm.
227. Okay,
234.
$234. Okay,
Okay, so are you familiar with plaintiff's exhibit 227?
Yes,
And what are these on plaintiff's 227?
these are posts that Lynn made on Parlor.
And are these true and accurate copies of these posts that defendant Wood made on Parlor?
Yes,
Okay, same question for plaintiff's exhibit 234. What is this?
this is another post that Lynn made on Parlor,
And
then a response.
and then a response. Is this a true and accurate copy of defendant Wood's post and then a response by someone under the username at Benjamin Allen 2 on Parlor?
Yes,
And were both these screenshots, or all these screenshots in 234 and 227, were they taken at or around the time that they were posted?
yes.
Your Honor, at this point, I'd like to move to have 194, 227, and 234 admitted into evidence.
right.
194, 227, and 234.
That's correct.
No objection to 194. I have an objection to 227.
All right. On what grounds?
I don't say one word about Jonathan Taylor and Nicole. I reference their lawyers.
All right. I believe that.
Again, that disparaging of Mr. Beal, but I simply said from public filings for the three lawyers in Buckley Beal, essentially look at who they represent. I said not one word about Jonathan Taylor and Nicole, so I object to it on the grounds of relevancy. And I think, Your Honor, I have the exact same objection to 234, which is simply somebody, Benjamin Allen, I don't know him. He just simply looks like reposted the comment that I just talked about in 227. So 234 also does not reference Nicole, Jonathan Taylor. It discusses their law firm, which is not a party to any non-disparagement agreement, so it's irrelevant.
Your Honor, briefly, if I may.
Yes, Mr. Brown.
Um,
I'll just say first, 197 is admitted. And so on relevance grounds to 227, 234. I'm letting you respond here.
Yes, Your Honor. In regard to 227 and 234,
Maybe I
contrary
got the
to
number wrong.
what defendant Wood is saying, it specifically referenced the three lawyers / plaintiffs practice at Wade, Grunberg, and Wilson LLP in Atlanta. So he does specifically identify them by name.
All right. I understand the argument. And I think the admission on relevance grounds is going to go to its weight, not its admissibility here.
Right? Where is there anything disparaging? What relevance?
That's going to be a question for the jury.
Your Honor, please. Anyone curious to know if the law firm representing three plaintiffs who filed frivolous lawsuit against me, or any of the three lawyers who sued me, support leftist, activist, or is it just me? From public court filings, law firm for the three lawyers is Buckley Beal LLP in Atlanta, and the three lawyers plaintiffs are Wade, Grunberg, Wilson LLP in Atlanta. I didn't disparage anybody in that comment.
Mr. Wood, at this point, now that the jury's heard it all, I've read it, I've looked at it. I think that it's going to its weight, not its admissibility.
Objection is withdrawn. Now that they've heard it, they needed to hear it all. Let them hear it.
All right, then without objection now, 194, 227, and 234 is admitted.
Thank you, Your Honor. Okay, so Nicole, I'm directing you to plaintiff's exhibit 194. This is a September 3rd, 2020 Twitter post where Defendant Wood says, if activists seek to advance an agenda but cannot attack the truthful message, they attack messenger. A lawsuit filed against me this week contains lies and false accusations. I will not be intimidated. I am fearless. I speak truth, and I will #fight back. And then it provides a link to a law.com article. It was the law.com article that he, I guess, attached to his tweet here in Plaintiff's Exhibit 194. Was it about this lawsuit and about you guys?
Yes, it was in the daily report, Fulton County Daily Report, and
What is- hold on.
reprinted.
What is the number you're trying to discuss? What's the number? I'm sorry.
Oh, I thought it was on the screen. It was 194.
I thought 194 was already admitted.
It is. I know. I'm
This is
asking
She's publishing it.
questions.
This is, I'm sorry, she's probably, thank you very much.
Okay.
My brain doesn't quite work as well at 4:30 after a long day or 2 weeks leave, so I apologize.
Or not.
Okay, so I just read it into the record. We can keep going since we're having some technology issues. So then on page 2, this is a Parler post around the same time frame. Is it the exact same tweet that I just read, but just posted on Parler?
Yes, this was in the time frame, I think, when Lynn had started setting up and using his Parler account. He was kind of shifting over. I guess he saw the writing on the wall.
And then moving over to Plaintiff's Exhibit 227. There we go. Thank you, Michael. And can we zoom in on the second post, please? Thank you. And I believe you said that this was a Parler message. It says, anyone curious to know if the law firm representing the 3 lawyers who filed the frivolous lawsuit against me or any of the 3 lawyers who sued me support leftists / activists, or is it just me? And it goes on and it calls you guys out as the 3 lawyers / plaintiffs practice at Wade Grunberg Wilson LLP in Atlanta. #fight back. Did you guys receive any responses after these September 2020 Twitter and Parler posts that we're looking at here in Plaintiff's Exhibit 227 and 194?
Yes, we began receiving all kinds of hate mail.
And
Objection, Your Honor. Show us the hate mail. Put it into evidence.
we're gonna
We don't know what it is. We don't know who sent it.
get to a lot of
Ain't
that.
entitled to see it.
Overruled. You can continue.
Okay.
So we're gonna go talk
Thank
about
you.
hate mail. We don't know what hate mail is.
Mr. Wood, to the extent you have an objection,
May I,
I've overruled it.
may I
And
have a moment outside the presence of the jury?
I understand the basis of your argument. I think it's not ripe at this moment. All right? It's not ripe at this moment. We can readdress it at the,
I don't know
when
what
we
that
need to.
means.
I've denied your motion, and so I'm directing the plaintiffs to proceed.
Denied it before I made it.
Do you want to state the evidentiary grounds and the rule of evidence that you believe is, the question is improper?
I don't know what the witness is talking about. She claims they've gotten hate mail, and now she's going to talk about the substance of this alleged hate mail. Where's the hate mail in evidence? This is not the way it's done, Your Honor.
All right. I think
Like-
you're,
it's like-
that's something
it's
for
like-
cross-examination or a commentary on the weight of the evidence. That's not a valid objection. Mr. Wood, we're moving on. I've denied whatever the form of objection it is that you've made.
Thank you. I understand.
Thank you, Your Honor. Michael, can we go to Plaintiff's Exhibit 234? And Nicole, did you guys also, were there also responses to Defendant Wood directly on Parler, Twitter, Telegram to his messages that referred to you guys throughout the 2020, 2021 to present time period?
Yes,
And is the one pictured here by a username at Benjamin Allen to one of those responses?
yes,
And this user says, I live near Atlanta. This is useful information. Thank you. We've got a lot of responses from followers, so let's, I'm actually gonna move on from this one. If you could take a look at Plaintiff's Exhibit 202 and 203.
Jeez Louise. Yes,
Okay, I kind of want to do a couple of these at a time. So you're familiar with 202 and 203. Are these true and accurate copies of the screenshots that they're depicting to be?
yes,
And are these posts that Defendant Wood made on Telegram in 202 and 203?
yes,
And were these screenshots taken at or around the time that they were posted?
yes,
And before I admit these into evidence, can you look at Plaintiff's Exhibit 215? And 213?
215, 213.
Mm-hmm.
yes, I've looked at them.
And Plaintiff's Exhibit 215 and 213, are you familiar with these?
Yes, I am.
Okay, and taking this one at a time, and Plaintiff's Exhibit 215, page 1, are these true and accurate screenshots of Telegram posts that Defendant Wood made?
On page 1?
Yes.
Yes, yes,
And were these screenshots taken at or around the time that the posts were made?
yes,
Okay, and then the following pages, are these true and accurate screenshots of responses to the first post on Plaintiff's Exhibit 215 and or a direct message that you received to your Telegram account in response?
yes,
And were these screenshots taken at or around the time that they were posted?
yes,
Same questions for 213.
You tender those in evidence?
I will be at all at one time, so we can try to streamline this. Plaintiff's Exhibit 213 on page 1, is this a true and accurate copy of a direct message that you received on Telegram?
yes,
And then on page
Sorry.
2 of Plaintiff's 213, are these true and accurate screenshots
Right.
of responses to a Telegram post that Defendant Wood posted?
yes,
Your Honor, at this time, I'd like to move to have plaintiffs 202, 203, 213, 215 admitted into evidence.
All right, we'll take those one at a time, starting with 202.
Any objection to 202?
I'm looking at. No objection to 202, Your Honor.
All right, and then turning to 203.
No objection to 203.
So 202 and 203 are admitted, turning to 213.
13. I do have an objection to 213. It's hearsay. We don't know who that person is. We don't know when that was posted.
All right,
Any day.
and on 215.
Same problem. That's this crazy stuff on Telegram. I don't know who these people are. That's hearsay. It's not even dated, so it's just not relevant. And it's highly prejudicial. Let it in.
Yeah. All right, on this issue, Mr. Drew, I'll ask you to step out just for a few minutes while we can take this up, and we'll be back with you.
Back to Drew.
And step down for this. Thank you.
All right, I think this would be more freely discussed with the jury stepping out. So this issue, I believe, is going to echo what came up repeatedly in the contempt hearings. In those situations, as I recall, I didn't find it relevant what other people were doing and using with his statements. And so they weren't applicable or relevant. And so here, I mean, what would be the purpose of showing what other people did with his statements? Is it relating to damages in some way? And if you just want to lay that out for me.
Yes, Your Honor. I mean, it goes to the heart of damages as to the breach of the non-disparagement provision. The words that he said, casting the plaintiffs in a negative light repeatedly on social media, resulted in, with Miss Wade getting rape threats. And he keeps saying, show the responses, show the replies. Well, these are those replies. These are those responses. And now he's objecting for them to come in. I mean.
All right. So again, I haven't had a defamation case in here. And so when you say that you're entering it, or the objection is to hearsay, it's not that you're entering these for the truth of the matter, it's to show
The effect,
impact
the
of-
impact and the damages that
okay.
were.
Prejudice me from some unknown statement on social media that one of my enemies could have posted so she could use it. It's not even identified to a real person. It could be a computer bot that generated that statement. That's why you don't violate. I have enemies in this country. You know that. You know it. And they're trying to do things to undermine me. And they use social media to do so. I know what their tactics are. The point is, what you, I believe, need to understand and accept is right. We don't know who these people are. Are they bots? Are they paid shills? Are they CIA? Are they Freemasons? Are they other activist groups that I obviously advocate against, pedophiles? I mean, somebody puts up a post with no name and they want to come in here and go, look, Dave has responded to Wood and it's caused Nicole harm. Who do we know who Dave is? It may be false, created harm, and I believe it is. The people that follow me, I'm pretty sure the legitimate people, they don't talk like this. They don't make threats. Most of them are God-fearing people. So this is rank hearsay. Not only is it hearsay, it's not even identified who it's from.
All right. And for the plaintiffs, were there other exhibits that are along these lines? We have other posts and that sort of thing we're going to be going through.
Yes, Your Honor. For Miss Wade's continuation for the rest of the day, it's going to be Plaintiff's Exhibit 230 is going to fall into this category. All of these are direct messages she received to her personal Telegram. You can direct message followers on Telegram, and because Defendant Wood doxed her by posting her Telegram screen name, she got all of these direct messages sent to her. And then Plaintiff's Exhibit 231 is also the same thing, except for it's different in the sense that there were so many she was getting, so many threats. These are screenshots of her direct message, like inbox on Telegram. And instead of bringing in every single one, we just took screenshots to show the amount of responses he was getting. And, there will be evidence coming in later in the trial that shows that Defendant Wood actively monitors his replies and his followers and engages with them and responds to some of these posts. And I'm not going to go into a full response on the rest of what he said.
On the last thing she just said, these aren't from my channel. These are people posting on another Telegram channel. I know what it's called. It's called Breadbasket. They conspired to get these types of shills and bot messages posted on their breadbasket so that they could use them in court. It's a setup, but it fails because, number one, I never saw these on these weren't put on my channel. When anybody puts anything even close to this on my channel, my admins immediately delete it. My channel is not to attack or threaten anybody. Now, so we go back. Who is Lauren Liggett? John Exum looked at one of these direct messages or emails. They were saying somebody's threatened me. Found out it was from a dead person. In fact, two of them, right, John?
There were two in federal.
Two in federal court. They were from dead people.
Your Honor.
This is a social media scam that the deep state and others use to attack a patriot and a man of God. That's fine, but tell us who it is and tell me how in the world I can be responsible for monitoring all of social media. I can't, and I'm not. And I can't be held responsible for this. If the court and the jury wants to find me responsible for disparaging, I said what I said, but I should not be held liable for what these other people are out there saying, who very well may be shills paid to do it, computer bots programmed to do it. We have to draw a line somewhere, and this line has to be drawn now, or we're gonna be in the same mess in this case, in part that we're on in the federal court, where I think there was many egregious errors that are gonna get that verdict reversed. I saw the tactic coming. This is the same thing they're doing here. They're repetitive. So is the devil.
All right, last word, Ms. Brown. Any response there to the new witness or new
Yes, Your Honor.
arguments raised?
Briefly, Defendant Wood is completely conflating the evidence when he's giving the description of this individual who they found an individual with that same name who had passed away. That had nothing to do with any Telegram post or direct message. Somebody filled out a law firm "How can we help you" form on the WGW website, where you can put any name, any username, any email. And in fact, somebody put like a Seymour Butts kind of joke on one of them and send a direct message to their admin for potential clients. It's a typical form. So that's number one. Number two, all of the direct messages in 230 and 231, Ms. Wade received those specifically to her Telegram account. They were direct messages sent directly to her. A lot of them mentioned Defendant Wood, and so we can tie it back to him. And then in 213 and 215, these are responses that were maintained on his response channel. And if he didn't want individuals coming after my clients, then he should have stopped posting this and we wouldn't be here, but this is where we are.
I don't want anybody coming after her clients. I'm a man of God. But what I am also is I'm a man that people will use my name. Just because somebody goes out and says Lynn Wood does not mean Lynn Wood has one single thing to do with it. You recognize my notoriety around the country, Your Honor.
Mr. Wood, we're getting a little astray.
No, I think
The core of the question here is, what is an appropriate measure of damages for a breach of a disparagement clause.
And it can't be
And-
proven by unidentified hearsay from social media on the internet.
All right, so that is the objection before me, is to hearsay.
It is. And
The-
the fact that it's unidentified would makes it even worse.
All right, and again, to that end, I'm not in playing the gatekeeping function here. It's not my job to step in and say definitively answer all these questions. It's to that ultimately falls on the jury. To the extent this is transformed into a 403 objection, and really on hearsay, I'm hearing that it's non-hearsay. It's to be their measure of damages. All of the points you've made are things that you can bring up to say why you should not be held accountable for them. But under the rules of evidence, this is something the jury gets to decide. And so on the grounds that you've made, hearsay, 401, 403, you've made your objection, but I believe on all of these exhibits that they're going to be admissible under a kind of a prima facie case here of on the issue of damages. So,
All right, I have another motion.
all right.
At this time, the defendants move for a mistrial. Your Honor has repeatedly, and it's on the record, repeatedly said, I'm not going to be the gatekeeper. I'm going to let it in and let the jury decide whether it's admissible or not. That's not a jury function. Your Honor, you are the gatekeeper. You are the one that's supposed to protect the parties and the jury from deciding a case based on irrelevant, unidentified hearsay. If you don't do it, it's not their job. And this is many times, at least 10, that you punted the ball just like that. I think it's prejudicial to me. I think Your Honor continues to reflect a bias against me because I have addressed the fact of Freemasonry in our judicial system. And so, Your Honor, I move for a mistrial.
All right. Well, I think perhaps you're right. The use of gatekeeper is probably a poor choice of words on my part. I think I'm certainly the gatekeeper in terms of whether it passes the evidentiary threshold. What I'm trying to articulate is that who actually decides some of these issues you've brought up is the jury. And so what I have found is that the issues that you've raised on the evidentiary rules aren't going to bar this evidence. As to the remainder of your mistrial, I don't see appropriate grounds at this time.
All right.
So that's denied as well.
Thank you. It's preserved for appeal
All right.
if necessary.
Is there was something else Ms. Wade wanted to bring up about this email. I don't know if we need to do that or has that been addressed?
Right, because we took it off the screen.
It could still be part of the record. So is everyone clear on the redactions that are in that particular exhibit? Yeah. Well, it's live right now. I understand what you're saying. So your position is the entire paragraph should be redacted. All right, I understand.
What paragraph?
We're talking about exhibit 106.
106?
Wait, it might not be 106. This is going to be 104 rather. And we're not going to be reading it out loud, but you can read it to yourself and you can tell me if you have an objection to redacting the entire paragraph where the amount appears, not just the amount. The jury has not seen this, but it has formally been admitted as part of the record. And so I just want to clean that up.
So what is it they're moving to redact?
The entire paragraph containing the amount in the second page.
Well, Your Honor, I don't know why that would be. I can understand if they want to redact the amount. Dexter King is now wherever Dexter King's soul is. So he's not alive to assert.
So your position now is attorney-client
There's
privilege
nobody-
extends after death, does not extend after death?
It may, but where's the attorney-client privilege? She wrote this to him. She's clearly upset because he hasn't been paying her. I was
Okay,
aware of
now,
that.
we've just said we're not going to talk about the content of it. At this point, I've heard enough. I don't see how that paragraph's relevant in any way. We'll redact that as part of the record on 104, the second page.
Yes, Your Honor.
From there, I know you still said you had a number of these social media posts to get through. You told me you had an hour and a half to go. We're well past that point. How much longer at this point is your estimate?
Going through these are gonna be relatively quick, Your Honor, 15, 20 minutes.
And that's the
As
remainder
long
of,
as we don't have any more objections and we've resolved these issues.
that's the remainder of your direct of her?
Yes, Your Honor.
With that in mind, nonetheless, Judge, it's almost 5 o'clock. And I'd like to take a break. This isn't gonna take her that long tomorrow morning. Jury's been told they try to get out at 5. It's been a long day. People fought traffic to get here. And I think it would be a good time to send the jury home for the night. I'm gonna have to go to the bathroom anyway, so that's gonna be another 10 minutes.
All right, before we let him go, the expected plan of attack for tomorrow, Mr. Beal, I know we got cross-examination, and then what from there?
But then we will be calling the
Ms.
next
Brown?
plaintiff. Taylor
Okay.
Wilson will be called
Wilson
after
from
that.
there. And at some point, this is, I would take it that the succeeding plaintiffs from here aren't as long as Ms. Wade's because they're
You
not
got
covering as
it.
much ground.
We had
Okay,
to set a bunch of background today and we
All
were
right.
trying to dredge through that.
The exhibits that you've already gotten into.
What's the order for tomorrow? I'm sorry.
I'm gonna call Taylor Wilson next.
Taylor next,
Your Honor, would
then
you
Jonathan.
mind if we,
We're taking this one day at a time.
I'm only asking them one day at a time right now.
finish up the, exhibits that have been in evidence? Think that would be a good place to stop. Get those in.
That's clean enough. Okay,
Because she's already talked about them and they're in evidence.
let's find a clean stopping point since we were mid-objection there. All right, so if we could bring back the jury, we'll give it another minute or couple minutes here. I think we're gonna stop at whenever she's done talking about exhibit 213
These
and
guys.
Yes,
215.
these, okay, and then we'll leave these two for tomorrow. Got it.
And there's only 2 more
Yeah, 230 and 231.
total?
Yeah. But that's the it's
Okay, well, let's do that tomorrow. You're right.
all right, Michael, 202, 203, 213, 215. Okay. And there's gonna be a test on that, 5 seconds. I'm just kidding.
This were admitted.
Which ones are we talking about now?
202, 203, 213, 215.
We're ready.
Okay.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, welcome back. We stopped mid exhibits. So what I want to do is we just go a few more minutes to find a clean stopping point, and then we'll excuse you for the day. So the motion was on the floor to tender exhibits 202, 203, 213, and 215. And those were objected to. I've admitted them over the defense objection. So plaintiff may now proceed.
Okay, thank you, Your Honor. Nicole, in Plaintiff's Exhibit 202, this is a telegram post posted by Defendant Wood, is that correct?
Yes.
Okay, and it specifically mentions you guys by name as the 3 young lawyers who sued him. And it goes on to say, I will personally be taking their depositions under oath and upon cross-examination. And then it goes on and he says every lie will be revealed. Is this one of the statements that you consider him to be disparaging you in?
Yes,
And why is that?
because he's saying that he's going to cross-examine us and we're liars, right? Every lie will be revealed. Look at this below, and then the below one talks about me. It's
And-
obviously disparaging.
All right, and so going on to the one below in Plaintiff's Exhibit 203, I believe you said it talks about you personally, and I'll read some of this into the record. You will learn more about why she is falsely attacking me. She has a history of retaliating against And again, this tagline of every lie will be revealed. So is this a statement that you contend that just Defendant Wood is casting you in a negative light?
Yes, absolutely.
And did you get any responses on Telegram in regards to these types of posts that we're looking at here in 202 and 203?
Yes, I did.
And moving on to Plaintiff's Exhibit 215. And can we blow that up, please, Michael? Is this another Telegram post by Defendant Wood?
It's 2 of them. Yes.
Thank you. And it says Nicole J. Wade is online reading my right now, reading my messages. Hope she is reading your replies too. Maybe she wanted to watch her deposition testimony. I understand Nicole is under investigation by the State Bar of Georgia for grievances filed by concerned members of We the People. Hey, Nicole, missed you today. Are you going to join us tomorrow for G. Taylor Wilson's notice deposition? How is your soon to be defunct law firm and your non-existent law practice doing? Asking for a friend. Did I read that right?
Yes.
And is this another post that Defendant Wood made online that you contend cast you in a negative light?
Yes.
And the one below, can you explain what this post is from Defendant Wood where it starts Nicole J. Wade's Telegram?
Yes, I had set up, I had always followed Lynn on Twitter. I followed him on Parler. I went followed him on Telegram. I set up an account. I was typing in my name and then I was like, I don't know, maybe I shouldn't type in my name. I don't know. This is what they do. And so I typed in J and then my dog's name was Ellie. So I typed in Ellie Bug. That's what I called her. So then they started calling me Jelly Bug. I didn't see it that way at the time, but I just made a username. So that's what it was. And on Telegram, your cell phone number is tied to your name and your username. And so if your cell phone number is in the person's contacts, then it pops up with your name. So he knew that that was me because my cell phone number was in his phone.
And if we go on to page 2 of this exhibit, Plaintiff's Exhibit 215, and we zoom in on these, can you explain what these screenshots are of?
These are some of the things that people started posting when he said, I hope she's reading your post too. So then they all started, there were just tons of them. They all started in. There were 125,000 views on the first one. They all just, he had like 800,000 followers, I think, at this point.
And so for those who aren't familiar with Telegram, were these responses posted on Defendant Wood's main channel
So,
or else?
so Lynn has 2, I think I mentioned Lynn has 2 channels. Lynn Wood Speaks Truth and Reply to Lynn Wood. And so, I don't know, supposedly he had people, when he had it set up, people were spamming his main channel. I don't know. So he set up the second channel. And so his main channel,
Making it up about what I do. That's not right. She has no personal knowledge of that.
I think she's demonstrated.
She needs a
All right.
foundation.
Okay. All right. I think she's already demonstrated that she was monitoring the channels. It's overruled. You can continue.
It's not a foundation for saying what I do on Telegram.
I've ruled, Mr. Wood.
Thank you, Judge.
and so on the main channel, you cannot post replies. You can only read it. And on the Reply to Lynn Wood channel, you can post replies or comments on whatever he posts. You can't make posts, but you can post under a comment. So these are screenshots from my phone and it's comments people made to that post in Nicole J. Wade is online right now. That's why it looks like that.
Okay. And
Now, Linda, can't find that particular document. It was page 2 to 214. 215.
okay, so to read some of these responses to Defendant Wood's post about you and your deposition, this Kathleen Payne person says, Nicole, you are a loser and criminal. Lock her up, boys. Another person says Nicole is a simple piece of, and there's a poop emoji. There's another one that says bye-bye Nicole with a middle finger emoji. What goes around comes around. I'm thinking Nicole is going to have a come to Jesus moment soon. This one from somebody named Dawn says, oh, Nicole, don't mess with Lynn's army of backers. He has millions of us ready to help him in any way needed. And going to the next page, we'll read a couple more of these and then I'll ask you a question. This person named Tim, if we can zoom in on the top couple of responses, Michael. Tim says, hi, Nicole, you gutless whore. When will you tell the truth? You are a disgrace to America and everything it represents. Somebody said run, those sorts of things. When you saw these types of responses that were being posted to this post that Defendant Wood made about you, how did that make you feel?
Pretty awful that Lynn would let these things stay up on there. These people saying these things, I felt awful.
Your Honor, again, there's no evidence that these were posted on my channel or that my admin saw them and left them up. They're manufacturing evidence and
All
it's
right.
corrupt.
Ms. Brown, or the witness has testified differently. That goes to her credibility, which the jury will determine.
We'll deal with that tomorrow.
All right, you can continue.
Michael, if you'll just go back to page 1 of this exhibit real quick, please. Nicole, in Lynn's post that we saw on page 1 of this exhibit, does he reference his followers' reply to you in any way?
Yes, he says, I hope she's reading your replies. I mean, that's why they then started posting this, I'm sure.
And can we go over to Plaintiff's Exhibit 213? And this first thing, this kind of looks different than what we've seen so far. Can you explain to us what we're looking at here? And
Yes, this is again, a screenshot I took on my phone. This is a direct message. When Lynn posted that with my screenshot, I mean, with my screen name or whatever, my phone blew up and I started getting just pop-up after pop-up, and people were direct messaging me all sorts of awful things, and this was one of them.
okay, and this one from somebody named Dave says, orange jumpsuits for people like you who love brackets and jackets. I hear Gitmo has lovely weather this time of year. Have you missed me? It's been a while since we talked, with a kissing face emoji. You said you received other direct messages as well from in response to your username being posted online.
Hundreds, many hundreds.
And if we go to the next page on Plaintiff's Exhibit 213, are these more responses to the posts where he identifies your Telegram username?
Yes, these were posted on his channel.
Okay. And
not removed after it was brought, even after it was brought to his attention.
okay, and Michael, if we can zoom in some more, it's kind of difficult to see. Maybe go to I wish he good luck or something. Keep going. There you go. That's fine. So it looks like some of the individuals who are commenting are having a conversation on this in response to this particular post where he identifies your Telegram username. Is that right?
Yes.
Okay. And this Dave person, is that the same Dave we saw on page 1?
Yes, it is.
And what is Dave and Zero Smoke Show talking about here?
Excuse me, Your Honor. What are Dave and who?
Screen name says Zero Smoke Show.
What are
Smoke
Dave and
screen,
who?
excuse me.
Where is it? I can't see it.
It's,
Where is Dave and who?
It's not on the screen right now.
Which, can you put up on the screen the one she's talking about?
it is.
I'm sorry, I missed it.
You had it right, Michael.
No, it's at the bottom.
I'm sorry.
It's at the bottom.
I believe the first one is at the top, Michael. The first two.
So the question.
Oh, I see you moved them.
So where's the?
You have a copy of it, right?
I don't. I'm sorry.
It's in the binder in front of you, Mr. Wood. I'm not hearing an objection. Plaintiff, please proceed with the testimony.
Thank you.
Who is the person? I'm sorry.
What is the objection? What are the
I'm trying to-
grounds?
I'm trying to figure out when she asked her, what is Dave and somebody, and I missed the name, Mr. Thumps? I believe the question was, Nicole, what were Mr. Dave and Mr. Thumps talking about? How in the world would she know what Dave and Mr. Thumps were talking about? They're not even, probably not real people, but they're not identified.
All right, to the extent you're just asking her to summarize the exhibit or to
Oh,
refer to
thank you.
specific parts of
I'm
it,
gonna-
I didn't say you were, Mr. Wood. To the extent you have an objection, I'm overruling it and I'm allowing the plaintiff to proceed.
Thank you,
It's
Your
not
Honor.
an objection. There's
Nicole,
no foundation. It has not been shown that these people are even real, so.
I've already ruled on that objection, Mr. Wood.
Make the record.
You already have, and I'm directing you to sit down now unless you have a new objection to make, because I've already ruled on that one.
I accept the understanding of what you're trying to tell me.
All right, thank you. Plaintiff, you may proceed.
thank you. Nicole, can you read Dave's first message here that we're looking at 12, or reply at 12:49?
Yes, the guy Dave is the one that we looked at before, and he sent me these messages. A lot of people did this. They would send me the direct messages, and then they would go back on Lynn's channel and report to the other people, hey, I sent her this, and then they would post it, what they had sent to me. And they had, in fact, sent them to me. This was one of them. This is the guy who had sent me the one about with the kiss and whatever. And so then he said, this Savage, I've sent her a couple nice love letters.
Okay, and then going below at 12:51, somebody with the screen name on Telegram, Zero Smoke Screen, he responds to Dave's Savage message, and what does he say?
He says, bro, back off, she's mine.
And then if we go down to the very bottom of this thread, Dave responds again to this individual. And we'll give Michael a chance to zoom in on it so we can all see it. Thank you, Michael. And it says here, Dave responds, fine, in all caps, but I call sloppy seconds. Did I read that right?
Yes.
What did you understand these responses that we've just gone through to be talking about?
Sorry. It's my understanding that with the rape, multiple, I don't know.
And
I may be particularly sensitive to that, but
and
that's
how
how I
did
took it.
how did that make you feel when you saw that these two individuals were posting on Defendant Wood's reply channel talking about taking turns and sloppy seconds with you?
It upset me terribly. It still upsets me. I didn't know we were going to go through this. Sorry. But that hits me hard.
And Your Honor, at this point, the exhibits that we've tendered into evidence today, this is a good stopping point for us.
All right, members of the jury, thank you.
Those last ones in.
She's not done with the direct yet, so we'll pick it back up in the morning. All right, so members of the jury, I'll leave you with the direction again. Please don't discuss the case with anyone, including amongst yourselves. And don't do any research about this case. Everything you learn comes from this courtroom. I'll ask jurors 17, and I believe it was 28, juror we spoke to earlier this morning to stay behind. All right? All right, first for juror 28, I just wanted to give you the message that we have received and we are considering your request. It's difficult position you put us in because that's the kind of thing we need to know about before we pick a jury. And in the longer trial, you tend to lose jurors. We've already lost one. And so we may be able to grant your request, but not at this time. So I'm going to ask that you come back tomorrow morning, all right? And that would, I think I might have neglected to tell the rest of the jurors that that was 9 a.m. But we will follow up by email to make sure that they do know that. So with that, juror 28, you're excused for the day. We'll see you at 9 a.m., okay? All right, for juror 17, she's written us a note. I think this is her second note. So we'll mark this as course exhibit 2. I'll let counsel review that. And actually, juror 17, if you can actually step out, we'll come get you when we have a response ready for you, okay?
Right, I just realized she was sitting there and helping.
Don't be scared.
But they can we put it back up here? I'm so weird.
Slave just out here. This, I don't know what to say to this.
I mean,
I mean,
Well, let's make sure our court reporter can hear us. And I have some ideas and I just want, but I'm going to share with you every communication I get from a juror and I'll read it into the record. Did you still need to see it? Okay.
and voir dire was not streamed yesterday, correct?
No, that's something I would share with her.
Oh, you can step down.
Yeah, you can sit down.
Thank you.
All right. All right. So as I mentioned, I've marked this as court's exhibit 2. She essentially just is asking generally about safety concerns. I've allowed the parties to review it. I'll solicit input here, but I think at a minimum, I need to bring her back and answer her question about juror documents that we've collected those, we've destroyed them, they're not made part of the record. And just a general assurance that we will take her security paramount and I can offer her, I think we can escort her to the shuttle if she feels the need. But other than just a general reassurance, I don't really feel like addressing any of the other specifics in her note. And with that, let me turn it over to the plaintiffs.
That'd be fine, Your Honor. Follow your lead on that. That seems like the appropriate response.
And some of this may just be the after effects of the incident yesterday. So,
and I would ask, Your Honor, that you give an instruction to the jury, because it may well be from that. But I would want you, please instruct the jury that whatever somebody else has done here, that it is not to be considered by them in any way as being related to me, my fault, etc. I don't want them feeling like my lawsuit, their lawsuit against me has caused them to be in harm. And I've already got enough of a problem with this testimony you've allowed in with Ms. Wade, where I could see these people going, well, she's scared, I'm scared. That makes them sympathetic to her. And I think it needs to be clear that I have nothing to do with it. And it cannot be considered in any fashion when they go to deliberate this case. And I believe I'm entitled to that. Please. Thank you.
We're accepting only what Your Honor originally said you were going to do. Guessing about people's motivation wouldn't be appropriate here.
if there's a, there are generally pattern instructions that cover some of the aspects and the themes that you're talking about. If you have one you want to submit, I'll consider it. I'm trying to, I recognize the issue.
Well, it falls equally on both sides. Somebody in the jury could believe that Mr. Bill's responsible for that guy being upset. So it could be they blame Mr. Bill. I don't want anybody.
And that's, I mean, that's where, where we kind of run into danger, just kind of speculating. And so let's bring back juror 17. All right, Juror 17, feel free to have a seat. And we received your note, and I just wanted to reply generally and answer a few of your concerns. One of the overarching one being that your safety and security is paramount in our minds. And so whatever we can do as a court system, as a sheriff's office, to alleviate any concerns you have, we want to hear that. And so I'll try to answer more specifically your concerns about the jury selection process. I know you might have seen the TV on at some point yesterday. We never live stream or record jury selection to the extent that your name was read out loud. That wasn't something that was broadly disseminated. The documents that the clerk gives us with kind of the intel on it that you submit to the jury clerk, we collected all of those, and those have been shredded. And so, and to that end, if and when we make it across the finish line with a verdict, that's also not something that's documented in the court records with a list of the jurors' names. So basically, as we go through this day by day, if you have any other concerns or suggestions, you can let us know. If you need an escort to and from the shuttle or to your car, let us know. We want to make sure that you stay focused on what actually matters, which is the facts and the evidence. That's what matters. We want to make sure that your concerns, that your safety concerns, however valid they are, we don't need that weighing in to you following the evidence and helping deliver a verdict that speaks the truth of whatever had happened as you find it. Understood? All right. I think they haven't started deliberating, so I don't think it has to be in writing. Is there any objection to her asking a question here from the plaintiffs?
I don't.
Okay, you can feel free. Uh-huh. Right. And well, first of all, I can assure you that gentleman is not going to be appearing again throughout this trial. And I think we also have his cell phone. And so, Deputy Scott, I think you might have had a better view of what was on the screen as he stood up. It appeared to me like he was reading something. Was he filming? He was reading something. Yeah, all right. And that phone is in our custody now.
It's probably until he's been released, it's gonna be a month.
All right. Anything else? Okay. All right. Anything else? Any other from the parties?
I don't think so. Thank you, Your Honor.
All right. See you none. Thank you. We'll see you tomorrow morning.
Guys, real quick. Courtroom is locked, right? So we're safe leaving these exhibits here.
That's right.
Good.
All right. Is there anything else that needs to be taken up before we recess for today? Let's be back.